I'd like to give a brief introduction of our first speaker of the day, Ms. Shruti Jain Eusebius, Research Fellow, National Judicial Academy, Bhopal. Ma'am, we are honored to have you here with us today, and I'd like to, she has been a resource person in many academies throughout the nation, and we were also fortunate enough to have her at Central Academy for Police Training for a 3 days orientation program on the new criminal laws. I think we are fortunate again to have her, to have ma'am with us. Ma'am, I request you to kindly grace the dais. Ma'am would be giving a deliberation on the changes, developments, and challenges in the terror-related law offences in the new criminal laws. Please give a big round of applause for Madam. I now request Shri Alek Muivah, Member Secretary, Manipur State Legal Services Authorities, to kindly present the mementos and lengyan to Madam. Ms. Pinky may kindly assist, sir. Thank you, sir. I now request Shri Manojkumar Singh, Joint Director, Manipur Judicial Academy, to kindly grace the dais as moderator. I now hand over the floor to Madam and Sir. Ma'am, please.
Very good morning and a warm welcome all of you. First of all, I sincerely thanks to the Manipur Legal Service Authority and the Department of Law and the Legislative Affairs, Government Manipur, for organizing this valuable 2 days orientation program of new criminal laws. By inviting Madam Research Fellow from the prestigious Academy, National Judicial Academy, Bhopal, where we judicial officers are trained. In this 5th and 6th session, Madam Shruti will enlighten us in the topic changes, development, and the challenges in terror-related offenses in the new criminal law. Madam, the people of this small country, small state, has been suffering for the last 40 years, since the early part of 1980s, about the terrorist activities. In the first schedule of UAP Act, we have about 6 organizations which are declared unlawful organizations. But there are still so many other organizations which are not declared unlawful. But they are involving in this some kind of terrorist activity. So, and then our state, in our state, this, Madam may know that is Armed Forces Special Power Act has been imposing since 1980. Then still, this AFSA has been imposing in the hill areas. So, Madam's deliberation in today's epic will be very benefited to our participants today. Frankly speaking, I was not present yesterday's program, but I was the program of yesterday's on YouTube. So, on the second session of yesterday's program, there are many questions about this Terrorist Activities Act, terrorist laws. So today, we must take the opportunity from our Madam about the Dove we have in our mind. So I, being a moderator, request all the participants to participate actively by putting questions to the Madam. Whatever you have Dove in your mind about these new criminal laws. I understand that since the new criminal laws are very new to all of us, there are so many gray areas in our mind. We have to be clarified. So, I request Madam for taking your time.
Good morning to you all. May I request that my PPT just be displayed? While they're putting that up, it's a pleasure for me personally to be here in this beautiful state, and I really am grateful to the organizers, the hosters of this event for having me here. I hope to be able to satisfy your interest and your curiosity on the topic. The area that I have picked up that I would like to discuss with you, as Sir has mentioned, is something that you are dealing with in your state more than other several states of our country. That is terrorism, especially since you're a state which is on the border of our country. So, and may I have the pointer as well, please? So I would just take you through the laws that we need to know about terrorism if you're dealing with. All right, thank you. So the laws that you would require to know, and issues that are probably involved in terrorist offenses. I will be dealing with it with the development of jurisprudence. This is not a new law that has come in today. It is an area that has been developing over time, and I would give you a bit of an insight on the jurisprudence that has developed regarding offenses against national security. Thereafter, then we can open it up for a bit of discussion where I'd like to have some questions from you, where if I can do my best, I would try to address as many as possible. Apologies, we'll just wait a bit while they get the technical issue sorted. While we wait for them to just get this PPT going, just general, can we talk about what you think terrorism is? If we are dealing with this area, I think it's important to first get our foundations right. So anybody who can just give me an idea on what you think terrorism, the word, means? Anybody? Anybody can just give me a thing? You could just raise your hand and then so that I know who's speaking. What do you feel terrorism, the word, means? Anybody can give an input? Can you just raise your hand so that I know? Yes, sir, please. Mm-hmm. Okay. So sir has said one thing which I think where you're coming from is you're seeing the root word terror. So you say terrorism is what strikes terror in people. And it is something that is an act against humanity, striking at the people in general. Very well put, sir. Anybody else has a point? Sir, please. Fear caused in the general public. Right, sir. Wonderful. It comes from the root word terror, and I would say there's an interesting point. It has a Latin origin as well as a Sanskrit origin. Thrasati in Sanskrit has linkages to the modern day word terror. Sir, you wanted to say something. Unlawful acts of violence to the civilians. Okay. Here I would put a point. What distinguishes any act of violence against an act of terror? Like all acts, there might be acts which are against civilians, yes, but are all acts against civilians an act of terror in simple terms? That's a point to question. Oh. Sir, can you raise your hand? I don't know to know who's. To the right? Yes, sir, please. Mm-hmm. Right. Okay, so you have gone to section 15. I would just point out there were a couple of definitions that I wanted to take your mind to. I will just give you in a nutshell what these definitions point out. Number one, they point out that unlike any other act of violence, terror has a very specific intent. And that intent is largely a political intent. That is, they have a political agenda, a political objective that they want to achieve. And for that, they use violence and other forms to coerce a group of people or even a government to submit to their will. That's what it brings in, a fear in the general public. That is a creation of such an intense fear that without you being a direct target, somebody else might have been targeted in an incident. You not being a target will, under that fear that you could be a victim tomorrow, would submit to their will. And you would do exactly what they want you to do. That is the first thing, that it has a political agenda behind it. Second is the way the act is committed. And that is different from any act of violence. Like, for example, I'm angry today and I act out. I go and pick up a gun and start turning violent. That is, right now I'm angry, I've acted on that anger. Unlike this form of an act, terror, has a very premeditated and a very deliberate way of doing things. That is, they have an objective, they have a strategy, and they have used their resources, garnered resources, to achieve a certain objective. And that's where terror and terrorist activities are different from any other act of violence. The pointer is not working.
Down is next. Up is previous.
Oh, this one. Sorry. So these were the two definitions I wanted to point out to you. We can get to the point that we're talking. Number one, a political objective. Number two, the way it is done, premeditated, deliberate, systematic. Unlike any other act of violence, there's a premeditated objective, there's a deliberate planning and a systematic way of organizing yourself or your group to commit an act. And like any other act of violence, it has an unlawful use of force, which is common. But what is different is the way it is committed and the objective behind it. This definition I would like to put before you. My PPT will be provided to you. You can definitely have a copy and read this at your leisure. But what I would like to reference in this definition, which has been taken from Yaqub Memond's judgment, is the last two lines. And what this focuses on is that it's an act, a criminal act using force. But what is important is these acts are not justifiable for any rationale whatsoever, whether it is racial reasons, whether it's ethnic reasons, religious, it could be even political for that matter, or philosophical. Any rationale provided does not justify what is being done. That is what is unique about terrorism. Looking conceptually at it, I will not spend too much time. Let's look at a couple of aspects. I've broken it down into 4 buckets. Number one is the modus, the actus reus. What is covered is, it is obviously an act of violence, so any form of weapon I use, it could be something as simple as a gun, it could be something as complex as a non-biological weapon. It could be a weapon of mass destruction. It could be a nuclear weapon, biological weapons. That could be one form, that is, I am using weapons to commit an act which causes damage and injury. Second, we have seen this very commonly, people being abducted, hijacking of planes, assassination of political leaders. We have seen these incidents in our country. The modern day terrorism has evolved more beyond just general act of violence. They have evolved with the development of science and technology. So now today, with what forms of science development we have, so the nature of the weapon will modify, the nature of committing it will also modify. So you have today tech-based terrorism. So you might have, and this has become a reality in the northern state of India, Jammu Kashmir, where we had a drone attack on the Air Force base at Jammu. What happened in this incident? There is a drone carrying a parcel of bombs, and that drone, controlled by somebody somewhere else, comes across the border, drops that bomb on a strategic location and causes damage. That is a form where technology is used to commit the act. Terrorism has now evolved beyond that. That is where you're not doing an act which is causing violence, but you are doing an act using technology which causes damage to the interest of the country. So I would take an example of a cyber terrorism attack. What would a person doing a cyber terrorism attack do? He would take a computer, launch an attack against something, an e-resource of the country, bring it down or delete the data, prevent you from accessing it, and as a result of that, cause damage to the interests of the country, its normal functioning, target that country, or even leak information, strategic information about that country to somebody else, which puts that country at risk. That would be a form where there is technology being used to commit an act which is damaging to the interests of the country. So modern day terrorism has gone beyond act of picking up a weapon and striking at the country. It has gone towards striking the interests of a country through technology. Economic terrorism is a modern day one which is still in the process of evolving, where again, you damage the interest of the country by devaluing its economy, affecting its currency and bringing the entire economy down, where the interest of the country is lost. We will see a bit of this kind of a facet in the jurisprudence that has developed. I will take you through it in a bit. What is the intent? As I already mentioned, largely political. That is, there is a political agenda, They want to push a certain agenda they have, and for that they will coerce a government, hurt the people, cause unrest in the country, disturb the law and order and public order of the country so as to force the government to act as per their will. And that political objective is what drives terrorist activities. Outcome? If you're doing an act of violence, somebody is going to get hurt, somebody is going to get injured. Yes, so there's going to be death, there's going to be injury. There's going to be destruction. If you're striking at a place, you would strike at the place, you would destroy property as well. So death, injury, and destruction is a natural consequence of an act of violence. But that is common for all acts of violence. What sets terrorism apart from any other act of violence is the prolonged impact it has. That is, today, if a group of 50 people are attacked in my state, in, say, Bhopal, for example, and this is televised, everybody sees it across the country, you come to know about it, you are afraid. Even though you were not a direct victim, it affects you mentally. That is, I am at risk today. If somebody else is a victim, I could also be a victim. And in anticipation of being a victim in tomorrow, may be, may not be, you submit to their will. So that prolonged impact of fear, insecurity that is caused in you, the psychological trauma that it causes in the general public, is what is unique about terrorism. Who are the targets? So if you're targeting India, for example, the general public, as rightly said by one of our participants, that the general public would be a target. It could also be a section of the society, depending on certain rationale. It could be religious, racial. It could be varied reasons for even for the factum of which area you belong to. So depending on that, a section of society could be a target as well. The people who defend or lead our country are also targets. So your defense, your leaders, public authorities, these are targets. But sometimes terrorism is not against a people, it's against a place. Red Fort, for example, Parliament. Why are these places targeted? Because they have value to our country. So when they target a place for its value to the country and to affect the country as a whole, that place becomes a target of a terrorist attack. But what is important, if you want to distinguish terrorism from any other act of violence, the Supreme Court gives us this advice: look at the mens rea. The intent is far more important than the modus. Any act of violence would have violence involved, death, injury, destruction. But what drives that activity, the mens rea, the intent behind it, is what is crucial. So if you want to identify terrorism, look at the intent and what it achieved, the outcome, rather than the modus. So let's talk terrorism law. Today, after BNS coming in, we have a new set of laws. But this law has evolved over time. Let's just look very quickly at the trajectory of this law. 1860, we have the IPC coming in. At that point of time, there was a chapter, chapter 6, offenses against state, had two major offenses, waging war and sedition. The word terrorism is not used in IPC at that time, but today if you understand these offenses, they would be what we would understand to be falling as an offense against national security, a terrorist offense. So it had a couple of offenses, waging war and sedition, which are the law that governed us from 1860 onwards. 1967, we have UAPA coming in, but UAPA at that point of time was not a terror-specific legislation. It was brought in to deal with internal rebellions. So unlawful associations, unlawful activities was what was penalized under UAPA at that point of time. At that point of time, not applied to terrorism. 1985, we have the first special legislation on terrorism coming in, the TADA Act, Terrorist and Disruptive Activities Act, 1985. Brought in for a very specific purpose, that is to deal with the Khalistani movement. Specific purpose and specific shelf life. So accordingly, it lapses in 1995. Now again, there is a vacuum in between where from 1995 till 2002, when POTA comes in, we have the 1860 law, IPC, that applies. 2002, we have Prevention of Terrorist Activities Act coming in, which is a legislation which was brought in view of the increase of terrorism in our country, both in India also as well as in foreign countries. The need was felt that you need to bring in a specific legislation to deal with these kind of activities, terrorist acts. So POTA comes in 2002. Now the problem with POTA was there was widespread allegations of misuse, and because of that in 2004 it was repealed before it lapsed. It also had a shelf life of 2 years, and before it lapsed it was repealed in 2004. Now, at the point POTA goes out, UAPA gets amended in 2004 to bring in certain offenses which are terror-specific offenses. So we have Terrorist Act coming in. We have a chapter on terrorist and terrorist organizations coming in UAPA. Now 2023, we have BNS coming in, which has now become applicable from last month. So now, from July, these are the laws you need to know. One, we have the Bharatiya Nyaya Sanhita 2023. For short, I will be referring to it as BNS. We have Unlawful Activities Prevention Act, UAPA. And for jurisdiction and investigation, we have the National Investigation Agency Act of 2008. Other than that, that is these major offenses that are covered. You have terrorist acts, you have terrorist organizations. These are offenses that are covered. You would also have allied ancillary legislations that would apply for activities like possession of explosive substances, possession of arms. For that, minor offenses, minor things that tag along with the major offense of terrorism, you would have these legislations coming in which would be relevant. Other than that, we have state-level legislations in various states, though not in Manipur, which deal with organized crime. Now, why organized crime here becomes a related legislation, state-level legislation, is because Makoka being the first, Maharashtra Control of Organized Crime Act 1999 was the first legislation on this area, state level. What it had was it covered organized crime and linked it as a crime that is committed to promote insurgency. From that aspect, organized crime legislations become relevant. So in these states, these state level legislations would apply. Under BNS now, these are the offenses you need to know. So one is Terrorist Act, section 113. Second is waging war, section 147. And an offense called endangering unity, integrity, and sovereignty of India, that is 152. We will look at each of these offenses one by one, and I would give you a bit of a jurisprudence that has developed with regarding to these offenses, because these are not new offenses that have come in today. They have been in other legislation, so we can look at the jurisprudence of how these offenses have been interpreted. So Terrorist Act, number one. And because, as I mentioned, actus reus and mens rea both are important parts of the offense, and we need to focus on what the mens rea is to identify what's a terrorist act. I have broken down each offense into two buckets, the modus and the intent. So let's look at the actus reus. So what is covered under Terrorist Act? That is, number one, the use of substances which cause damage. So explosive, inflammable, lethal, poisonous. You use these substances. The second one is you cause damage or destruction to a defense property in India or in a foreign country. Third is overawing a public functionary by criminal force, even causing death. Now here, the word public functionary has been defined in the statute, and it says a person who's holding a constitutional post or a post notified in the official gazette. So the public functionary term is limited to these posts itself. The next one, abduction and detention of persons to compel the government or an international or intergovernmental organization, to my mind seems something on the lines of hijacking or abduction. It seems to be that. This last one is an addition that came in the UAPA and has been brought into BNS now, and that is unique, unlike the earlier legislations where we have an act of attacking or damaging the monetary stability of the country, and that becomes, in a first time in UAPA, that an activity that is what we were talking about is economic terrorism being recognized as an activity which is punishable. So you have the activity of damaging monetary stability of India. Now here the courts have also been very specific in their interpretation. Damaging monetary stability, what is covered under this activity? And they have said, you have to read it with the lines that follow. By production, circulation, or smuggling of counterfeit Indian currency. So they've said the act that is covered under this clause is limited to activities of relating to counterfeit Indian currency. So you have counterfeit Indian currency being produced, circulated, or smuggled. That would be what is damaging the monetary stability of India. Now here they've gone as far as interpreting not just smuggling or production of counterfeit currency, even activities related to the means of producing this currency would also be covered under this. Intent. So now mens rea becomes the important. Coupled with these activities, couple it with the intent, and that's what would be a terrorist act. So threaten unity, integrity, security, and sovereignty of India. Now here, unity, I would say, seems to be an act where we say unity of the people, unity of the country. And interesting perspective somebody had once given me that we can probably look back to it as union of states. We are a union of states. So the fact that all our states stay together in a union, in our federal structure that we have, that would be something that is a unifying factor. So unity of the people, unity of the country is what would be covered. Integrity. Now integrity has two connotations if you look at it from a dictionary. One, we are conversant with as persons who are working in a public organization. We have statements being made that a person is of high integrity. That is a personal connotation. That is, I have a high ethical value and high integral moral code. That is for an individual person. For the state, integrity has two connotations. And I would, in a nutshell, say territorial integrity. So it would have two aspects, at least. One is secession and the other one is secession. Two things. One would be territories from our border being taken away by neighboring countries, which rightfully is a part of the territory of India, being taken away from us. And we are seeing this in our border states, where territory is being, in parts being taken away. That is one activity. The second is a territory within our country deciding to break free and declare itself as a sovereign nation in its own right. So saying we are no longer part of India, we are an independent country in our own, we are an independent state. That would be two connotations which are territorial integrity. Security, to my mind, means something of fact of being safe. And sovereignty, from the word sovereign, would be the right of India to govern its territory, to make its decisions, to be independent of any other influence whatsoever, to take its own independent decisions and to administer, rightfully administer its own territory and its own people. That would be something that is a sovereignty issue. Threat and economic security, I will take you through this in the next slide. Strike terror in people in India understood if you're going to do a violent act here, you're going to terrorize the people here. Strike terror in people in a foreign country. Now this was brought in after the experience of Tada Act in State versus Nalini. If you look at the offense in State versus Nalini, the offense terrorist act at that point of time did not have this factum that you might have an activity committed here in our territory in India, which would be targeted at another country or the people of another country. So in that judgment, they had to hold, if you look back to State versus Nalini, which was Rajiv Gandhi's assassination, what actually happened was a person, not a public functionary, he was not in holding a constitutional post at that point of time, was assassinated by an outfit who had an intent to terrorize or to target the government of a neighboring country. This activity, they had to, by the letter of the law, had to hold that this is not a terrorist act in India, because it was not targeting or the people of India. So striking terror in a people in a foreign country, now with UAPA and the offenses that follow in BNS, now you would have today an act where the activity is done here in our territory, but is intended to another country or the people of another country. That would be an activity that is punishable as a terror act in our country. So that is with our experience of State versus Nalini, 1999. Threatening economic security. Now, this entire offense has been taken from UAPA and brought into BNS. But interestingly, when they took in the offense, they left this definition behind in UAPA. So this definition is not available to you in BNS. It tells you what economic security is. So when you're dealing with it under UAPA, this definition will become relevant. Not so much when you have BNS coming in place. This, to my mind, has three aspects. Economic security, number one, would be security of the economy. So economic, monetary, fiscal stability would be an aspect that is economic stability, economy. The second is economic activity stability. So the means of production, livelihood, food security, these would all be economic activity security. And the third most interesting part that they have added, which is an interesting linkage, that is, you have ecological and environment security, which is having economic implications, linking it to terror. Now that is a very interesting linkage, which I have still to see how it has manifested. Hopefully we will have judgments on this. Now here, one question we've already dealt with is, When they have said the act that is covered is damaging monetary stability of India, it is limited to counterfeit Indian currency, production, smuggling or circulation of counterfeit Indian currency. The second question that came before the high courts was, suppose there is a person, he brings in large volumes of gold into our country. Can that activity be something that is a terrorist act? This question came before the high courts. Most of the high courts are on the same page except one single bench of a high court. Everyone seems to say that by default you cannot deal with smuggling of gold as a terrorist act, minus the intent. Again, mens rea is important. And why? Simply they've given us two rationales why they do not think smuggling of gold is directly a terrorist activity. Two reasons. Number one, they have said that this offense that was brought in, this subclause, that is economic security, was brought in by way of a FinSec committee report. And that FinSec committee report, while recommending the change in the law, gave an idealized clause that needed to be added in by amendment. In that idealized clause, they had put in the word gold smuggling. The legislature, when they put in that amendment, took out the word gold smuggling and brought in the amendment. So when they have specifically taken the word out, gold smuggling, the intention of the legislature seems to be that they do not want to cover gold smuggling as an activity that is a terrorist act. The second reason that they have given is, one, if you look at UAPA Act where this offense comes from, this is jurisprudence developed in UAPA because our BNS is new. They have said one thing. If you look at section 15, which is terrorist act in UAPA, it has a second clause which has not come into BNS. 15 clause 2 says activities that are covered under the schedule to UAPA, the treaties under the schedule to UAPA, would by default become a terrorist act. So that schedule does not have Customs Act or treaties related to customs covered in it. So the intention of the legislature seems to be very clear that by default, gold smuggling will not be a terrorist activity. But there is a rider which has been placed, that is, look at the intent. If the intent to bring in large volumes of gold is to destabilize the economy and target the country, target the state, then maybe we might have to examine it more closely to see if it's actually a terrorist activity or not. Punishable terrorist act. So we've seen terrorist act, that is 113 clause 1 tells you what a terrorist act is. Clause 2 provides the punishment. What other than terrorist act is punishable is things done before. That is conspiracies, abetment, aiding, facilitating, inciting other people to do terrorist acts is punishable. Training and recruitment of terrorists for commission of terrorist act is punishable. Membership of an organization involved in a terrorist act. Now here just be very clear about it. Unlike unlawful associations, the organization exists, you are a member. The organization was involved in a terrorist act. On the day that terrorist act is committed, this organization is involved in it. You, on the date of the act being committed, become liable as a member. So even if you did not know, the fact that you were a member of an organization involved in a terrorist act would make you liable under this clause. Here I will draw a distinction when we come to unlawful associations under UAPA. Harboring or concealing a terrorist knowingly is punishable, and holding proceeds of terrorism is punishable. This is where everything has come from. This is not a new offense, this is brought in from UAPA. So if you look at it, sections 15 to 21 of UAPA and now section 113. But for the exception of one section. If you look at UAPA, section 17 seems to be missing from this list. And section 17 covers funding of a terrorist act. So terrorist funding right now is not an offense under BNS. The remaining is there, but funding of terrorist acts is not an offense here under BNS. Let's look at the second offense, waging war. Now waging war, if you look at the terminology in the law, it is extremely simple. It says whoever wages war against India is punishable. But what is waging war? Is it a war? We generally think of war in the lines of country A versus country B striking at each other. But what is waging war in our Indian law is something beyond that. That is, any person or an organization which goes and strikes at the interest of the state, strikes the state, is waging war against the country of India. So it could be a person, it could be an organization as well. So waging war, how it has been interpreted, this is under IPC. Broadly, again, I'm giving you the buckets of mens rea and actus reus. If you want to understand waging war, this is what the Supreme Court says you need to know. So what is the intent behind an activity that would be called an act of waging war? So number one is to strike at the sovereign authority of the state. I am striking at the country, impeding its right to govern its territories, impeding its right to take decisions, coercing the government to act against, on my instruction, would be something that is striking at the sovereign authority of the state, number one. That comes from Navjot Sandhu's judgment. Second is coercing the government of India. Now here, this is a view taken by the Supreme Court in Kasab's case. Very interesting point they have said, coerce the government of India. Now today, in our mind, if we say government of India, we would understand it as something as government. So organizations and persons who are governing our country would be what I would say common understanding is government of India. Here they have said, ultimately, the question that comes to their minds is, ultimately, who is the repository of the sovereign power of the state? Any views? Who do you think is the sovereign repository of the sovereign power of the state? Think back. Social contract. State. Sir, I can't see. Yes, sir. State. The state. Yes. Where does the state get its power from? Think about that. Exactly. Preamble. We, the people of India, elected a government as representatives of us, gave away a part of our rights, social contract. We gave away a part of our rights to them, saying, you represent us and our interests, you govern us on our behalf. So we are the people who hold sovereign power. We have given it to the government of India. Very rightly put, sir. So when you strike at the people of India, you are coercing the government of India. And I know I understand where this is coming from, because today, our elected representatives will be under a force, under a coercion if there's a terrorist organization which strikes at all of us. Now, because they are representing us, they need to look out for our interests. They will be under a pressure. They would be coerced to act on the instruction of the terrorist organization that is involved in striking at us. So in that sense, you have coerced the government of India. So it makes sense from that way, but it is a wide interpretation. Disturbing public peace, law and order. So targeting the country, causing massive unrest, communal tensions, law and order problems, public order, disrupting all that, would be something that is an act of waging war. Causing communal tensions. So you would strike in a way, strategic way, that is to break up the unified people into two parts, put them into tension that they are striking at each other, they go against each other. That would be an activity that is triggering, in one sense, an unrest in the country. That would be something that is waging war. But now today you might see many acts of terror are driven, these are up till now, I hate country India, so I am targeting country India. That is a feeling I have against you, for example. The last one is not so much an external hatred towards somebody, but more of a belief system. That is, I am taught, indoctrinated, or maybe even brainwashed into thinking that I need to do something because my religion requires me to do it. I have to do it not because I have a feeling against country A. I have to do it, even if I don't have a feeling, I have to do it because my God commands me to do it. So when I do that, I'm doing what is, I would call as a holy war. I'm engaging in a holy war, that is, I'm fulfilling the instructions given to me and the command that I seem to have from my God to do a certain act against a certain community or a certain country. So in that sense, I'm acting on a fanatic belief, and that is driven by my religious belief. So many attacks nowadays, if you have seen, are driven by this religious fanatic belief. And that is an intent that is internal to a person or a group, rather than a manifestation of the hatred of a certain country. That is a unique development. Now, if you want to see waging war, you would look at how it is committed, the conspiracy behind it, the mobilization of resources, how they operate it. So it goes back to the words we saw in that definition. Premeditated, systematic, deliberate. So I have involved in a conspiracy, planned it with a very specific intent, executed it in a very systematic way. So my modus of committing it becomes relevant. But here, the Supreme Court gives us a word of advice that it is not so important how the activity was committed, rather it's important what the intent was. And I'll give you an example of that. So what is minor elements is the number of persons and the force employed. Why? I'll give you an example of, say, we have tech-based terrorism today. There is a person, he's sitting somewhere with a laptop. How much did the laptop cost? 50,000? Fair enough. He's got a laptop, an internet connection, which is nowadays very cheap. He launches an attack against the defense infrastructure of the country, brings down the entire defense infrastructure. What happens? The country is at risk. There is no defense. Your defense secrets may have been leaked out to other people to use against you. But the point is, how much resources did he use? How many people? 1. How many resources? Minimal, 50,000 plus an internet connection. Damage, 100%. So today, it is not so much the number of people, the resources, the force employed. It's more, what was the intent? Did he intend to strike at the state? Yes. He wanted to bring down the state and make it prone to risk, to attacks? Yes. So he has put us at risk. He's targeted our country? Yes. So in that sense, the intent is more important. The lesser, though not irrelevant, I would say, the lesser minor element would be the number of persons and the force employed. So these are a couple of interpretations that the Supreme Court has given. I will give you 4 instances. Number 1, we were talking about places being a target. So here we have 2 cases which talk about places being a target, not the people. So Red Fort, number 1 is Red Fort attack. Second is Parliament attack. Why Red Fort, why Parliament? Red Fort, it has patriotic symbolism for us. We recently had, every year we have this celebration of our Independence Day and Republic Day at the Red Fort. It is a monument, historical monument, and it has patriotic value to our country. So when you're targeting a place like that, similarly, Parliament, why Parliament? It's a representation of our governance. And it's an important monument also for that matter. When you target these places, you're targeting the country to send a message. So when you target these places, it's also an act of waging war. Second, we've already discussed this, religious fanaticism being the driving force. So committing acts based on your religious belief, which is instructed to you, would be an act of waging war. Third is Kasab's case. Now, Kasab's case, we already discussed one thing, that was coerce the government of India. 2 other things come in on the nature of how this attack was carried on. So number 1, let's see how this attack transpired. There were a bunch of people, came by boat, landed on the shores of Bombay. And as they hit the street, they started indiscriminately firing at anybody who they saw. Whether they were Indian, whether they were foreigner, they shot and killed whoever they saw. They entered into railway stations, they entered into hotels, they entered into cafes. Whoever they saw on the streets or in these places, they shot and killed. Indians, why? Because you're an Indian citizen. Why foreigners? Because you're on Indian soil. So when you're targeting people, either because they belong to India or they are on Indian soil, you are targeting the country as a whole. You're waging war against the country. That is what Kasab's case tells us. Second thing is the choice of the city. Why Bombay? Because we all know it is the commercial capital of India. Whatever happens to Bombay and its economy directly impacts the economy of the rest of the country. So what happened in the Bombay attack, 26/11? When they attacked, everybody who was there got locked up wherever they were. Institutions stopped functioning. So when you have commercial institutions stop functioning, our stock exchange is there. You have institutions which have commercial importance stop functioning, the economy falls. When the economy falls, the currency falls, the economic activity has come to a standstill, all of us pay the price for it. Our entire economy, we lost millions in that particular attack because our entire economy came to a standstill. So when you target the city, because the act of targeting that city will have implications for the rest of the country, you are waged war against the whole country. So in that sense, the choice of the city is important. And similarly, the choice of city, if it was like Delhi, for example, because it's our governance capital, political capital. You target a city because of its implications for the rest of the country. Yes, it's an attack of waging war. This one, more particularly, I would say something on the lines of internal, but this would be a very fact-based determination that each person, judge, would have to make. And this is a question of when we are till now thinking of terrorists as somebody coming from another country and targeting. We might have organizations within our territory, whether those organizations can be committing terrorist act. They are causing internal disturbance. So they have said you need to look at the dominant intention. Now this dominant intention on a fact-based situation would have to be determined in every particular case. They said if the dominant intention is to cause any of these activities, that is overall the government, 1, strike terror in the people of, or a section of people there, 2. Third one is alienate a section of people. Fourth is adversely affect the harmony amongst different sections of society. If this is the dominant intent behind an internal disturbance, then it would be an act of waging war. So this would be a very probable, I think, issue that has to be determined on a fact-to-fact scenario, whether it's an act of waging war. But this would be the dominant intent to determine if it's an act of war, waging war, or it's an internal rebellion. Third offense, endangering unity, integrity, and sovereignty of India. Now this replaces 124A sedition. And let's look at the nature of the offense that is there before we discuss why it has come in. Again, modus, actus reus. First is what activities are covered. So I speak something, I write something, words spoken or written. Second, signs, visible representation. So I might depict something on a poster, I might make a visible representation, I might make signs of that. Those would be activities covered. What is new, unlike the sedition law, are the next two. Electronic communication. So I might communicate something through the means of an electronic mode. That would be what is now covered under this section. So for example, I write something, a blog, I might post a video, I might post an audio. So all these activities, using electronic communication as the means to communicate something, and it might be anything that I communicate on online through all these means. So a blog, a social media post, photographs, videos, audio, me saying something, or reporting something, all these things which are through electronic communication is what is covered now. Use of financial means would be in the sense I use finance, provide funds to somebody or support an activity through financial means. That would be what is covered. Other means is blanket. What doesn't fall under the first set of it would fall under other means. Now here the intent they have specified, and this is very specific, and here what is important is this is bringing in sedition law in light with Kedarnath Singh, 1962 Supreme Court. In that they had read down sedition law. Earlier, if you look at sedition law, I will show you in a bit, and then I'll tell you why it has come. This is reading it down, and we'll discuss how it has been read down in a bit. So what is covered is doing any of those activities to excite or commit secession, armed rebellion, subversive activities, separatist activities, or an activity which endangers sovereignty, unity, and integrity of India. My advice is the third one, read it in line with the first two. Ejusdem generis, what is the first two? In that line, read the third one to understand that it has an act of tendency of causing an unrest. That would be covered under this offense. What is excluded is legitimate dissent. For example, I today write a blog, and I am commenting on a policy that my government has taken. I disagree with the government, and I have strong reasons for that. I disagree with the government saying, I think this policy is not in the interest of the people of India. Here are my reasons why. I am disagreeing with my government, expressing my freedom of speech and expression to express what my views are on this policy. But I am only doing it with the intent of convincing my government, not coercing, convincing my government to change that policy. Till the point I'm doing that activity minus a violent intent, it is a legitimate exercise of my right under Article 19, Clause 1 to speak my mind. Freedom of speech and expression, till the point I do not affect public order, which is a restriction under Article 19, Clause 2. Till the point I do not affect public order, I am well within my right to exercise my freedom of speech and expression. Until that point, if I am dissenting with my government, I am not liable to be punished under this offense. So this is sedition, and that's the new offense. If you notice, the means, two things are new, which we already discussed. That is financial means, and electronic communications is a new addition. Intent, now earlier if you see, sedition law said, whoever brings into hatred, contempt, excites disaffection, that is disloyalty against the government. And in Kedarnath Singh, this was read down that it is not just any act which generally brings a feeling of hatred. It has to be an act, a word, or something that is written or communicated that has a tendency to cause unrest, rebellious activities and all. So only when the thing spoken or written has a tendency to cause public order problems is what would be punishable. So Kedarnath Singh here becomes relevant because now the new offense is brought in line with the interpretation of the Supreme Court in Kedarnath Singh. That is, activities which promote unrest, separation, rebellion would be punishable. Exclusions, legitimate dissent is the same. Punishment has slightly gone up. What was 3 years is now 7. So this is a broad chart of where everything has come from. These are not new offenses. Terrorist Act has come from UAPA minus funding of Terrorist Act. Second, waging war was there in IPC, and we've seen the jurisprudence that has evolved. Endangering sovereignty replaces sedition, brings it down in line with Kedarnath Singh. This is the broad picture that you need to know. Now let's look at how these offenses are chaptered, and this is, brings me to the point of the issues that are involved in these offenses. Waging war and endangering unity, integrity, and sovereignty are chaptered in Chapter 7, offenses against the state, right? Now Terrorist Act, 113 is in Chapter 6, offenses against human body, and this is a departure from the existing law up till July, till 2023. This is the first time we've had a Terrorist Act, which palpably, to my mind, is an act targeting a state. The intent is against the state, is classed under a chapter which is offenses against human body. Up till now, these offenses were under offenses against state. Nature, broadly, this is a departure from the existing law. Now, how does this complicate things? Let's have a look. Now, the first one, the offenses against state, that is waging war and endangering unity, integrity, and sovereignty of India, are offenses under the state. Question is, who investigates these offenses? From July 16th, I think the position is clear. There is a notification of the government, central government, which says, read all references to the old law, IPC, CRPC, and Evidence Act, as references to the new law, BNS, BNSS, and BSA. So by virtue of that, what actually happens is, the NIA Act can be read down now. NIA has the schedule. Since we're talking about scheduled offenses, it has a schedule at the back which has a reference to the chapter of IPC. So we would now read that chapter of IPC as chapter of BNS. So accordingly, offenses against the state, so two offenses, waging war and endangering unity, integrity, and sovereignty, become offenses against the state, become a scheduled offense under NIA Act. So the investigation mechanism would kick in here. We will deal with the investigation mechanism in a bit, so you need to know how this would flow. So now, your investigation would proceed under NIA Act for these two offenses. It's an offense against the state, so obviously sanction is a requirement. So 207. Terrorist Act is a scheduled offense under NIA. So it's an offense against human body. Right now, your jurisdictional court is the Sessions Court. Okay? So since it is, and the procedure would be as per BNSS. So what would happen, unlike the NIA offenses which are directly taken cognizance of by the special court, here you would have a committal proceedings. So it would be committed to the Sessions Court for trial. The jurisdictional court would be the Sessions Court. It's an offense against human body, sanction is not a requirement. So you do not require sanction, right? Now, and this is important for the investigators in the house, you need to know about explanation to 113. What does 113, the explanation, provide? It says, when an offense under a terrorist act is committed, at the point the FIR is registered, an officer not below the rank of superintendent of police has to take a call. He shall decide, not may decide, he shall decide. Decide with reasons or not, it's up to you, but right now it does not specifically mention that you shall decide with reasons, but you should probably have strong reasons for deciding either way. Shall decide, either you register it under 113 or you register it under UAPA offenses. You can't do alternative. You can't have alternative both offenses being, you will decide either or. So you will either register it under 113 or you would register it under UAPA. So that is a call that the police, investigating authorities and the police has to take at the stage of the FIR being lodged. The second question that becomes relevant for the judges in the house is, now see, either they choose 113 or they choose UAPA. Now weigh the pros and cons. 113, BNSS applies. Jurisdictional court is sessions court. Sanction is not a requirement, so your investigation and coming to trial will be faster. But you will not have the provisions under UAPA available to you, that is the extended period of remand, and the stricter provisions of bail will not be available if you go under 113. If you go under UAPA, you would have to wait for sanction. Your jurisdictional court changes. You do get the stricter provisions of remand and bail, yes? So that is the thing. Now, the question that comes before the judges in the house would be, suppose they register it under UAPA, not so much a problem, but if they register it under 113 BNS, and the matter comes to you after committal, you're framing charges, right? Now you feel you want to bring in UAPA. The first question that comes to consideration is, do you have the power to rope in UAPA at the stage of framing of charge? That is a question I would pose to you to think. And I would just, because of paucity of time, I will just take you to the relevant section that you need to know, and that would be 239 of BNSS. Subclause 1 of 239 of BNSS says that the court can at any point before the judgment is passed add or alter to the charge, and here there is a judgment of Nallappa Reddy which says add a charge means add a new charge under a new statute. That would be relevant. You can look at Nallappa Reddy also for this. You can add a charge anytime before the judgment. Now the question that is, now if you've added a charge under UAPA, you need sanction. What do you do? So then clause 5 of 239 gives you the answer. It says if the added or altered charge requires sanction, you will have to wait for sanction. Sanction has to be taken at any stage. If you're adding, you will have to get the sanction for the new charge. And for that, you will have to wait. Now the third thing that comes up is the moment you add in UAPA and you are the sessions court, you are no longer the jurisdictional court because the NIA court has jurisdiction. So the advice would be you refer it to the competent authority that this is a case where UAPA is involved. He would then take a call to send it to the NIA court. So that would be 3 consequences that you would have to consider. That is an issue that you need to know. So 239 becomes your answer. You can add a charge. You need to get sanction if you add it, and you would have to probably send it to the right court for adjudication. Now, the question that comes is, when you alter these charges, one second. May I have a bottle? The question that comes before us is, both the offenses are exactly the same. Why, you would have to also consider why you need to bring in the new offense. Why do you need to bring in UAPA when 113 already covers the same offense? The punishment is the same, the offense is exactly the same. Why would you have to bring in that offense? You need to also justify if you're adding the charge. So you have something to say? Okay. The point what I'm trying to make is if you have to add the charge, you need to consider why, if at all you require to bring in, if both the offenses are exactly the same, why? Then you would have to look at UAPA for what else it has, which might be relevant considerations when you decide to bring in UAPA. Number 1, funding of terrorist act is not an offense under BNS. For dealing with the activity of funding, you might have to rope in UAPA. That would be one reason why you add in UAPA at that stage, at the stage of framing of charge. Second is, there are certain provisions under UAPA which are not available to you under BNSS. And number 1 is section 44, protection of witnesses. So 44 gives the court very strong powers to take actions to protect their witness. So 44 becomes a relevant consideration. 46 also becomes a relevant consideration, that is admissibility of evidence collected through interception of communication. So that would become a relevant rationale for roping in UAPA when the offenses are exactly the same. So 3 reasons you would have. One is terrorist funding as an offense needs to be added. And second reason would be you have special provisions under UAPA which become relevant for you as the court to apply. So this is the issue that you have, both for the investigator and both for the judge. There are issues with the explanation which you would have to take up. Let's look. Offenses under UAP I will cover at this point, and I will stop here. I think we need to have a tea break also, then we can come back. Offenses under UAPA, because we're dealing with terrorist law and this is the special legislation, along with BNS, you need to also consider UAPA. So these are the offenses that are relevant for you under UAPA. Terrorist Act we've already seen. It's exactly the same what has been brought under BNS. Other than that, you have unlawful activities and unlawful associations being punished, terrorist and terrorist organizations. Unlawful activities. What are unlawful activities? Let's look at the definition of the term. And again, I break it down into buckets. Modus is similar. Now this looks repetitive because these are acts which are common to most of these national security offenses. So acts, words spoken or written, signs and visible representation and other means, coupled with this intent. So intent to bring about a secession of or secession of a territory, claiming, disclaiming or disrupting or questioning the sovereign or territorial integrity of India, and causing disaffection against India is what is an unlawful activity. So you act or you speak or you write something or you make representations on the point which is targeting either to cause break away from the country or internal issues of disaffection or anything that challenges the sovereign or territorial integrity of India would be an unlawful activity. So that is unlawful activity. What is the punishable offenses? You either take part or you yourself commit an unlawful activity, you advocate, abet, advise, incite someone else to do it, or you assist somebody else in committing an unlawful activity. This is what is punishable. Unlawful association, we've seen unlawful activity, so whichever association, this is the criteria, whose objective is to commit an unlawful activity, that is acts which are questioning the sovereign authority or territorial integrity of India, etc., or encourages somebody else or assists somebody else, aids somebody else to do an unlawful activity, or its members do this. That is an organization, an association that is meeting the criteria to be declared as an unlawful association. Here I come to the point that I was making regarding membership. We will come to that first. Oh yeah, and an activity that is punishable, that is promoting enmity or imputations that are prejudicial to national integration, that would be now 196 and 197 of BNS. We read it as casus omissus. That is now with the notification of 16 July, we can read this reference as BNS now. So this is the criteria. But now the point is you can't say that, oh, this organization, there's an activity that has happened, somebody has committed an unlawful activity, you aided them, you're punishable as an association. That's not how it works. Here the procedure is reverse. Here the association has to first be declared an unlawful association. And there is a procedure prescribed in section 3 and 4, which provides for the procedure, takes about 3 months. What would happen in this procedure is there would be an association which meets this criteria. The central government, the central government comes at a later stage. This criteria is met, a show cause is given to the association, why you should not be declared as an unlawful association. The matter is referred to a tribunal which is under section 5 of the UAPA, the Unlawful Activities Tribunal. The Unlawful Activities Tribunal then looks into the matter, gives a hearing to the association to defend itself, and thereafter passes an order. And then based on that order, there is an official gazette notification which declares this association as unlawful. The day that, this takes about 3 months, the day that this is published in the official gazette, the offenses kick in. So it takes about 3 months, and then after that, these offenses. On the date this unlawful association is declared unlawful, if you are a member on that date, you become liable. Second, you deal with the funds of the association now that you operatively know that it's an unlawful association, or you contravene an order regarding a notified place. If you contravene this after it is declared, you are liable. Now here I would draw the distinction between membership of an organization involved in a terrorist act. Here it's reverse. Earlier it was terrorist act committed, the organization was involved in a terrorist activity. On the date the offense is committed, you are liable as a member. Here, on the date the association is declared unlawful, you are liable as a member, not backdated. So here that's the difference. Terrorists and terrorist organizations, with this I would stop for a tea break. Now, under UAPA, there are 2 schedules which list people, individuals and organizations as terrorist and terrorist organization. The criteria for being declared a terrorist or a terrorist organization is this. So you're either involved in an act of terrorism, you're preparing, not committed yet, but preparing for a terrorist activity, or you promote or encourage other people to commit a terrorist activity. That is the criteria. You meet this criteria, the central government by notification can declare you as a terrorist organization in the first schedule, or fourth schedule, a terrorist individual. So there are a list, and as Sir had mentioned, I had definitely looked at the schedule. The first schedule mentions, I think items 14 to 18 are relevant to Manipur, where there are organizations mentioned which are terrorist organizations declared. And this declaration has a life of 10 years. So now the question is, once this is notified, these offenses kick in. You're notified as a terrorist or a terrorist organization. You're a member, you're punishable. You support, you're punishable. Or you are fundraising for them, you're punishable. So this is what is there. Now here I would just take you to a factual scenario. Let's examine this to get a clarity about it. I am Mr. A. Okay? I go to a certain village in my state, and I have money of my own, legitimate, well-earned money. I take that money, I go to a place, there are poor children. I go and feed these poor children food. I don't talk to them, I don't say anything to them, I don't even interact with them at all. I just fund it, I'm there, and they are fed, they are starving, they are fed, okay? At this event, in the backdrop of that event where the children are being fed, there is a banner. And banner says Organization XYZ. Organization XYZ is listed in the first schedule as a terrorist organization. Now the question is, this activity of mine, feeding the poor, is it a punishable offense? What do you think? Sir, please, sir. Section 40, funding. Okay. So you're saying this would be an act of terrorist funding. Okay. How so, sir? Because I'm not giving funds directly to a terrorist organization. I'm feeding the poor. I use it only to buy ration to feed them, and there is no transaction of mine with Organization XYZ. Organization XYZ is nowhere here, not even close to the venue. I do not communicate with them, but I'm only buying ration or funding the I pasted it. Let's be clear, I got it pasted. Absolutely, sir. I agree with you. Let's look back on this. Now, and this is an important thing, because when we're talking membership, organizations which are banned will not have a manifesto for you to read. Where are you, sir? May I just see? Right, sir, right. He's emphasizing, he's promoting the organization. I would agree with you, sir. The point what I'm trying to make is, you will never find, in most cases, you will not have a manifesto available for you to read that this is terrorist organization with their objective is this, their agenda is this. You will not always find a membership role. You might have sleeper cells. You might never know who's a terrorist as such. So you will never actually know effectively who is a member, who is not a member. So two things come into question here. And then let's look back at the offenses that are there. When I did this activity of feeding the poor, it's a bona fide good act. But why did I bring in Organization XYZ's name into the picture? Why? Am I linked to them, as rightfully sir has said? Am I linked to them? Am I associated with them? Am I a member? My activity, my intent seems to be declared by my act of putting their name up. Am I a member? Maybe. My acts speak for themselves. Second is, why did I bring it up? As sir rightly said, am I trying to promote them? Am I trying to highlight them? Am I trying to support their cause? So both ways, either way, it seems to indicate that you have some ulterior purpose behind feeding the poor. So even if it's a bona fide good purpose, the intent behind it may be covert. So we need to be careful to look at what looks at bona fide good acts, whether that is a punishable offense. Now taking this one step further, and here I will stop for a tea break. Question is, now this activity, so far we've agreed it's an offense under either 38 or 39. Funding I would not say, because the linkage seems to be missing. I do not seem to be sending any funds or providing any resources to the organization directly. Now the question is, this activity we've agreed is an offense in some way or the other. Now the question is, suppose this activity and Mr. A are not in India. I am not an Indian citizen, I am somewhere in a foreign country. The question is, this activity is also done in a foreign country. It has nothing, no links to India as a whole, except that the organization is banned in India. I do this activity in a foreign country, I myself am a foreigner. Can we say this act is it's punishable offense in India? Yes. Can we say that you as the court here or the investigator have jurisdiction over this? Is the question you need to think over. Do you have jurisdiction? It's beyond the territory of India, do you have jurisdiction? Sir, you have something to say. NIA Act gives you the power to prosecute beyond the territory. That is, if I'm right, it is 1 subclause 4. And I would read it out for the audience because now we go to the next issue, that is extraterritoriality. So here, 1 subclause 4, section 1 subclause 2D. It says it extends to the whole of India and it also applies to persons who commit a scheduled offense beyond India against Indian citizens or affecting the interests of India. So NIA Act gives you investigatory as well as jurisdiction over commission of scheduled offenses or offenses against the interests of India which are committed beyond Indian territory. So one is that provision. Let's look at extraterritoriality in a bit. And here I will stop for a tea break. Under BNS, you have limited extraterritorial application. So here BNS, if you look at section 1 subclause 5, further subclause C, read with section 75 of IT Act, offenses that are committed targeting a computer resource located in India. Activity done abroad, but the act is targeting a computer resource. So tech-based terrorism. If you're targeting a computer resource in India, then in that case, BNS has extraterritorial application. Second is, this is a new offense that has been brought in BNS, section 48, this is the first time it has come in, and it says if you abet an act done in India, but you are abroad. So abetment of a commission of an offense in India by a person outside India also is punishable, specifically under section 48. So to this limit, you have extraterritorial jurisdiction under BNS. UAPA, now adding to what NIA provides, UAPA becomes relevant. That is, it is applicable to any person who commits an offense beyond India, which is punishable. So there's a UAP offense. Now here, this was unlawful association, terrorist organization banned. It's a offense which is under UAPA. UAP offenses are scheduled offenses. So scheduled offenses, it's a scheduled offense. It's an offense under UAPA. Any person who commits an offense beyond India, punishable under UAPA, would be punishable as if the act had been committed in India. So in UAP and NIA, you have extraterritorial application, BNS limited. So in this respect, I just wanted to point out this extraterritoriality, that where can you take a call. So back to this, back to this point, this activity is done in a foreign country by a person who's not in India. Even though it's an activity punishable in India under UAPA, you have extraterritorial jurisdiction over him. That's the simple point I wanted to make. With that, sir, I think we can stop for a tea break if you wish. Okay.
Thank you so much, madam. Now we shall have tea break for say 15-20 minutes. I request everyone to proceed to the lobby at the ground floor and the first floor for tea. We will continue with the session after tea. I request all the participants to assemble here at 11:45. Thank you. Ma'am, announcement of the Tojage. Like say, a question when the PV were like Singe, Lay with the Kudungta, the Villare, Handoksa have to Kara Yaure Hare. I think Matang the ma'am, like say, in case Handuning Habitat, cannot like to Puraga, Quigi registration destadum, like say Loga Haraga, cano Lupachate and KPV. I think with it, like say Tamapan P, ma'am, Lupachate and Kayam registration destadum PV. La apam bale de हमने पाम नदी के चुकाई दे हम registration दे थम बिरमो अतुम दे announce तो जगह तो ने okay I request all the participants to please take their seats. We will now continue with our 6th session. Madam, please.
Shall we begin? There's little left. We'll cover that and then I think we'll open it up for questions from you. We'd like to hear your views and probably if you have any doubts, we'll try to solve them. I wanted to talk a little on specific modern day areas and specific areas in terrorism which might be relevant, and one thing which we were talking was tech-based terrorism. So cyber attacks and use of technology in terrorism. This has become a reality, as I mentioned, and drone attacks have become a reality, as I mentioned. Our Air Force base in Jammu was attacked. And how it happened was there was a drone carrying a parcel of bomb, comes across the border and drops it on a strategic location, which was the Air Force base. So it is very difficult in terms for investigation as well as jurisdiction for that matter, to find a person who was behind it, who controlled the operation, who ran the drone, who was the mastermind, finding them, identifying them, investigating the offense, extraditing them. It's extremely difficult. There are challenges across with terrorism becoming a faceless form of terror. And our cyber attacks modern day, we imagine terrorists as people with a certain dress, with guns or ammunition, launching an attack against us. But today our modern day terrorists might be very difficult to distinguish. He might be an ordinary person and probably even younger than we imagine, because he might be a person who's tech savvy and probably could be a younger person. He might not even be wearing what we see in this image. He might be an ordinary person with a laptop sitting somewhere may not be in enemy territory, maybe in a neutral area, launching an attack which causes significant damage to the country's interests. And what kind of attacks he would undertake are these. He would disrupt your networks. He would hack into your systems, delete data, compromise the system, hack into websites, prevent you from accessing what you should be able to access. He might access information that he should not know, and that is an act of cyber espionage. That is strategic information like defense locations, defense strategies, government policies, critical information about the country that should not be leaked to enemy countries and enemy institutions. That could be leaked out and making our country insecure in the sense that we are prone to attacks in that sense. He could also disrupt critical infrastructure systems. I would give a very simple example. For example, there could be a terrorist who hacks into your traffic signal server, flips the switch, and what should, on a highway, for example, he flips the switch and suddenly puts a red light. Whatever's going in speed will have to suddenly brake. What's coming behind would probably hit. There would be a mass pile-up on a highway. You could also have what has to be running is stopping, what is running is, what should not be running is running. So then you might have mass traffic jams, mass accidents on highways and main roads as well. So you could do damage, which is physical damage also by the use of technology. So today your terrorist might be a far more tech-savvy person and very difficult to identify him and bring him over and to face the music in terms of adjudication. Where is this covered in law? You should know. So number one, let's look at IT Act 66F has a very specific offense of cyber terrorism. And what does it cover? Again, I break it down into two buckets. These are the three activities covered under 66F, that is denial of access to computer resource. And we've seen a recent set of attacks which have happened. The RBI, for example, aims, you have DDoS attacks being committed. That is, they access and prevent you from accessing what you should be able to access. So you are unable to access what is your server, what is your network, what is your resource, one. Second is he might access something that he should not know or should not be able to access. So that is one thing. Or he introduces a contaminant like a Trojan horse or a virus which deletes data which, and imagine from a judicial point if, for example, legacy files get deleted. It's a massive loss which cannot be replaced. They could cause damage to the institutions by this attack. These attacks any hacker will do. Coupled with the intent, it becomes a cyber terrorist activity. So this is the intent. So an attack of cyber attack coupled with the intent to strike against the country and its sovereignty becomes an act which is cyber terrorism. The outcome, I wanted you just to look at this because this was brought in 2000. At that point of time, the outcome that they imagine seemed to be very wide. That is, an attack, cyber attack targeting the country and its interests could cause any of this so far as even contempt of court and defamation. So it's a very wide outcome that they imagine, quite broad. Other than that, let's look at BNS if we can imagine if it can cover cyber terrorist activities. So I would read out the lines that are underlined. So it says, whoever does any attack, any act with the intent by now we have understood, targeting the state. Whoever does any act, clause A, by any other means, whatever nature. It could be a cyber attack, any other means, whatever nature, to cause or likely to cause loss or damage or destruction of property. Can we read property to be e-property? Possibly. So if he's causing damage, destruction or loss of e-property, that's an activity that gets covered. One, that second one is disruption of any supplies or services. Services essential to the life of the community in India or in a foreign country. So disruption of services becomes a outcome. Or the last clause, damage or destruction of any property used for defense or for governance. So if there is, and I would say property again, e-property. So by any means, that could be cyber means, which targets to destroy property or disrupt services or damage or destroy defense or governance properties is an attack that is covered under 113. So to my mind, 113 also becomes applicable. And then again, read with the extraterritoriality, you have jurisdiction to deal with any act that was committed beyond the territory of India targeting a computer resource in India. So in that sense, you can even prosecute a person who did not do this act in India. So that becomes a relevant consideration. Terror financing. Now, because this is not an offense under BNS, I am dealing with it separately, so you know where terror financing lies in the existing framework of law. And why is terror financing so important is because any act requires resources. I need resources to even purchase guns, for example. I need money, I need the economic wherewithal to commit an act. And how am I going to do it? By illegal activities. Because I'm committing a terrorist activity, I'm going to gain money by illegal activities. So I would raise funds, I would fund it by raising funds through any of these means, which would now today be an organized crime. So raising funds through extortion, drug trafficking, foreign funding, counterfeit currency. And extortion here, Sudesh Kedia's case becomes relevant because it says if there is a person who's extorted of money, and that money ultimately goes for terrorist activities, they are extorting money to commit terrorist activity because he's coerced into providing those funds, he is not liable. That is what Sudesh Kedia's judgment of 2021 gives us. But then terrorist funding is committed through these mechanisms. Where is it covered? Section 17 UAPA. This didn't get copied into BNS for reasons unknown. This has not been treated as an offense under BNS. What is terrorist funding? Funding for terrorist activities, the offense, the ingredients. I would just give you that. So it penalizes the raising, providing or collecting of funds, whether it's from a legitimate or illegitimate source. You raise funds for terrorist activities, whether in India you raise the source or you raise it in a foreign country, both of these activities will be covered. It also includes raising of funds which would be counterfeit money. So even if you use counterfeit money for funding of a terrorist act, that is also covered. Now here the point that is there, that is important is, anybody can raise funds, but if I provide or I raise that fund, knowing my intent is absolutely important, my knowledge is important to make me liable for raising funds for terrorist act under section 17. I should have known at the time of providing, raising or collecting these funds that these funds or even a part of it will go for terrorist acts. If I knew at the time of doing this activity, I am liable even if those funds do not get used. At the time of providing, for example, I am giving the money, I knew I gave 100 rupees, I knew that 20 rupees of that 100 rupees will go for terrorist act, likely to go. My knowledge binds me even subsequently if that 20 rupees does not get used for terrorist activity. So my knowledge at the time of providing that fund makes me liable even if those funds don't get used. So actual use or not is irrelevant, but I should have known. So my intent is required, my knowledge is required. It also, as I mentioned, covers provision of funds through counterfeit Indian currency. So even if I provide fake funds, I can't say that, oh, I provided fake money, so that doesn't apply. I provided counterfeit money, I am bound by my knowledge of providing it for terrorist activity. That makes me liable. Section 40, as we already discussed, you raise funds for a terrorist organization, that also is a punishable offense. Not in BNS. So for now, we would have to depend on UAPA for these activities, and that might be a rationale for roping in UAPA in the trial if you add it as a separate charge. Organized crime. I wanted to just mention a bit on organized crime. Why I'm mentioning, as I mentioned earlier, there are state level legislations on organized crime which are linked with the objective of promoting insurgency. Organized crime under BNS does not have that promoting insurgency as a part of the term of the offense. It does not say that organized crime is done to promote insurgency. BNS deals with organized crime as a standalone offense. So you do activities for material benefit as a syndicate. It's an act which is punishable under section 111, organized crime. But in the grander conspiracy of terrorism, you will find organized crime being a part of the conspiracy. And why? Because I said, to do any act, I require resources, I need funds. And how am I going to raise these funds? Through the commission of an organized crime. I will traffic, for example, I might involve in human trafficking. I might raise funds through this illegal activity, raise that funds, that is illegal money because it's raised by illegal activity. I launder that money, so PMLA becomes relevant at that stage. I'm laundering that money. and then I finance a terror outfit or I finance a terrorist activity. So that becomes the chain. Terror funding again becomes the part of the link, ultimately accumulating into the commission of a terrorist act. So in the grander conspiracy, organized crime might also become one of the aspects that you will be dealing with when you deal with terrorist offenses. So in that sense, I wanted to just highlight on terrorism and its linkages with organized crime. The last point, last 2 points that I wanted to make, and I will stop after this. I wanted to just dwell on the jurisdiction in terms of investigation as well as trial with regard to terrorist offenses. So now this procedure applies, let me at the start itself say, it applies to UAPA because that's a scheduled offense, and it also applies to the offenses of waging war and endangering unity, integrity and sovereignty of India. These two offenses, which are offenses against the state, also this procedure will apply by virtue of the notification of 16th July. So what is this procedure? Now simply put, NIA Act has a schedule behind it. It lists certain offenses which are recognized, which trigger the jurisdiction of the NIA Act. So in that, when the offense is committed and the FIR is lodged quoting those sections, now the police is under a responsibility to inform the state government that there is an FIR regarding the commission of a scheduled offense, that is a scheduled offense under NIA Act. Police informs the state government. State government in turn has to inform the central government there is a scheduled offense for which an FIR is lodged. Now the central government has to take a call. They have to decide, and within a period of 15 days, they have to decide whether to call the entire investigation up to the NIA, which is a federal body for investigation, specialized investigation, or they let the state police continue with the investigation. This decision has to be taken in 15 days. Other than that, if the central government itself recognizes and takes cognizance of an offense, its suo moto can order the NIA to investigate. It will lodge the FIR and require the NIA police to start the investigation. So without the procedure before, the central government can suo moto also direct the NIA to commence investigation on a scheduled offense. Now, two scenarios come in. One, within 15 days, central government decides to order that the NIA take up the investigation. So now, at this point, it will direct either two things. One, NIA takes up the investigation and the state police has to assist. One. Second, it can require that the investigation is continued by the state police under the monitoring of the NIA. Two things can be done. Either directly the NIA takes up the investigation. Now, if it does not, then the state police continues with the investigation, right? Now, what happens further is, once this is how the investigation happens. Once the jurisdiction of the NIA Act triggers, that is, it's a scheduled offense, the jurisdiction would be the NIA courts. There are two courts. One is the Section 11 courts, which are designated by the center, and there are Section 22 courts, which are designated by the state. So if the matter is investigated by the NIA court, which is as per the order of the central government, then the NIA court designated by the center will be the jurisdictional court which deals with it. If the investigation is done by the police at the state level, then the NIA court under 22 designated by the state will be the jurisdictional court. If there is no designated court, then the sessions court is the court that will take up the matter. At any point of time, this matter can be transferred to the NIA. There's one issue that I wanted to point out, and I would advise you to look at Nasser bin Yafai's judgment of 2022, which talks about operational transfer of the matter from the state police to the NIA. And this is in a circumstance where the matter is ordered by the central government to be investigated by the NIA. When does it effectively stand transferred to the NIA was a question that came up in this judgment. Now, what happened in this scenario? This is a case from Maharashtra. There was an order that the matter had to be investigated by the NIA, and there was a bit of a time lag between the files being handed over to the NIA. While that period was going on, the state police continued with the investigation, and what followed next was framing of charges, filing of the charge sheet, framing of charges, and the sessions court continued with the trial. Here then the issue came that when there was an order of transfer, how could the state police continue with the investigation? The Supreme Court was very clear on this. They said at no point should investigation be stopped for an offense. The continuity of that investigation is paramount. For that, operational transfer of the files is important. It's not enough that the order is given that the investigation stands transferred to the NIA. The NIA must take the files and commence the investigation. Till that point of time, the state police is well within their right to continue the investigation and continue what is the requirement under criminal law. So for this point, I would advise you to look at Nasir bin Yafai's judgment of 2022. That would be a relevant factor. This would apply to, as I mentioned, to the offences that are scheduled offences minus Terrorist Act. In my opinion, right now, Terrorist Act, this procedure and the jurisdiction would not apply. That would continue under BNSS, and the jurisdictional court would be the Sessions Court, till a specific amendment or an order is passed mentioning that Terrorist Act 113 is a scheduled offence under UAPA, NIA, for that matter. Till that point of time, this procedure would not apply. My last bit of point that I wanted to make was, we started at the point at the beginning, distinguishing between acts of violence and offences against national security. Where do you draw the line? It is easy to read any offence, any act of violence and say it endangers integrity, state, how. But the point is, do you have to, should you, in the intent of the legislature, read the intent of the legislature, do you rope in offences against national security and national security laws into every act of violence is a question that we need to consider. So for that, I would take you to Ram Manohar Lohiya's judgment of the Supreme Court, 1966. Justice Hidayatullah gave a very beautiful description of how criminal law stands. He has given it in words. I just put it in a picture for just coherence sake. He has said our criminal law and criminal law offences operate in three concentric circles. The outermost circle is very general. The innermost circle will be the most exclusive circle with limited application, exclusive application. So now, the outermost circle is offences which affect law and order. Little more restricted would be offences which affect public order. And when those two concentric circles cannot deal with it, the innermost circle gets triggered, that is the offences against national security, which is offences against the state. Terrorism law belongs to that extremely exclusive inner circle. And the point that the courts have made is, you need to draw a distinction between these offences, that is offences affecting law and order, public order, national security, and limit the application of national security offences to actual cases where the intent seems to be targeted at the state. And how would you identify it? By looking at the mens rea. So how to distinguish? Look at the mens rea. The mens rea is, one, targeting the state, firstly. Secondly, it would not have a private, more personal, one-time objective. It would have a larger general purpose that they are targeting to do. They have an objective, as we talk, political objective. There would be a political objective driving this. The intent would be to target the state and the country and its people, and it would be using coercive intimidation as a technique. So the distinguishing elements are what you need to look at. Here again, then they have also drawn the point, the last point that I made here. They said, ideally, if an offence can be dealt with under the other laws, that is, it's an ordinary, can be dealt with under the laws which deal with ordinary crime, probably you do not need to deal with it under national security laws. So if it is beyond the capacity of existing criminal law and law enforcement agencies, ordinary procedure, then you might have to consider whether you need to trigger a national security law or a national security offence. Here, and a point that they've made, and one of these judgments, the Delhi High Court, is in light of the Delhi protests that happened in the last few years. And they said, please don't treat acts of protest and legitimate dissent as terrorist acts, unless the intent to target the state is discernible from the factual allegations. So they've said, please don't apply this blankly to acts of protest and, kind of sloganeering on the street. Here, this is the advice of the High Court. Again, this is a Delhi High Court view. They said, please avoid adding terrorism legislation because, one, national security is a very exclusive area. The innermost circle has very limited application for very exclusive cases. The intention of the legislature is to apply it to a limited set of circumstances which the ordinary criminal law mechanism cannot handle. If that is the case, and if you apply it to generally to every offense, you are, one, trivializing the law, and secondly, you're defeating the intention of the legislature. So they have advised, try to only deal with terrorism law where there is a threat to the nation, threat to the existence of the nation and the interest and the defense of the country. So apply it to those limited circumstances is the advice. Again, they've said don't casually apply it to things that can be dealt with under conventional offenses. And this is the advice of the Supreme Court. Lastly, they said please be cautious so that you don't adopt an approach which brings all acts of lawlessness into the fold of terrorism law. Limit it to only offenses, to activities that are targeting the country and the security of the state, only till that, and where the intent is to target the country, limited to that. And with that, I think I will stop. We have time for questions, which I think both of us would try to handle as far as possible. Thank you.
Thank you, Madam, for your valuable and elaborate deliberation. Now, let us begin reflective section. So I request all the participants to put questions to our Madam, and I myself will try to answer your questions. But please keep in mind, our Madam is coming down from the Bhopal to here, so let us take advantage of our Madam's presence here. So put questions, whatever you think, whatever you keep in mind about these new criminal laws regarding this topic first. So, please.
Sir, can you hold your mic closer? We can't hear you. Yes, sir. Better. Extortion. Okay.
Is it possible to include that extortion into the modus also? You have given in slide that some topics which are not including extortion word. So is it possible to include extortion also?
So you're trying to ask if modus, the modus of extorting money.
Yeah, no. Modus means there are 4 or 5 things which you have included in the modus, no?
Yes.
So, but extortion is not there. But
yes,
extortion become a very important point. Actually, there is amalgamation of organized crime and terrorist act. The terrorist as well as organized crime persons have joined hands together, and they are carrying out activities which are beneficial for them. Like terrorist person is using the infrastructure of organized crime persons, gangsters, by using their men and arms ammunition to create terrorist activities, while gangsters are using their infrastructure abroad to move abroad and settle down abroad and running their activities from abroad. Like this Lawrence Visnoy and other is this Bombia gang. The people are doing this type. I am investigating that case, so I wanted to know if this type of activities may be included in that category or not.
So to my mind, the factual scenario that you are mentioning seems to be more of an organized crime scenario. That is, extortion itself is an organized crime, where they are using it to gain an illegal, unlawful benefit. So that, to my mind, would be more an offense under 111, more than 113. I would say, primarily, I would look at organized crime as the offense that governs a fact like this. That is, you are extorting money from various people, civilians, and using it for your own illegal means, right? So I would say this is more of an organized crime.
No, ma'am, I am saying something different. Actually, people have joint hand to carry out terrorist activities, including organized crime. See, they people are working together like Khalistan Commando Force. They people are carrying out terrorist activities or preparing for terrorist activities in sync with these gangsters.
Right.
So they are using their infrastructure, they are transferring the funds, they are carrying out the terrorist activity. So there is basically a new trend which has never come into the picture in India previously. But right now this thing is going on, like Gogamadi murder case, like 3-4 target killing in Punjab. So these activities has been carried out by terrorists sitting abroad in association with the gangsters operating in Punjab as well as Delhi and Haryana.
Okay.
So I am talking about those things.
I think I understood, sir. Two things that come to mind is, one is you're saying there is an extortion activity being committed. One, this funds is being raised illegally through extortion by a group of people. They ultimately use these funds for terrorist activities, amongst other things, including organized crime, right? They're committing organized crime also, they're committing terrorist activity. Am I right, sir? So two things would come into place. One is raising funds for terrorist act, section 17 UAPA, would be applicable to the person who's raising these funds for terrorist act. So section 17 UAP would apply. Second point, go to Sudesh Kedia's case, 2021, where they have said the person who's being extorted is not liable. When you are coerced into giving this money, you cannot have said to be willingly have provided funds. You cannot be penalized for providing funds for terrorist activity. So the person who is coerced by extortion would not be liable. But definitely the person who's raising these funds, doing this activity and doing organized crime, he would be liable under 17 UAPA, as well as if he's committing an organized crime which ultimately leads to terrorism, he could also be penalized under 111, that is organized crime. So 17 and 111 would be relevant provisions that you would need to look at, sir.
Thank you.
Yes.
What I was telling is that organized crime is more of economic in nature, to gain of the more of an economic benefit. That's why if you see section 111, organized crime, we have this sequence of offenses. It is not one offense. For example, kidnapping and ransoning. So it is again mix of offenses for the benefit of economic benefit. If we go to the section 113 or the section 15 of the UAP Act, the very first line it says that destruction of property or the sovereignty and integrity against the state. So it is more of a state, whereas organized crime, it is more of gaining illegal access or illegal benefit of the money. That's what we can, that is one of the key point that, so now rising of the funds and the extortion. Now what is the basic difference? Rising of the funds, you have a consent or a tacit consent of the person who is giving the money. I may say that I may going for a separate Khalistan or something else, please give me the money. That person is motivated to give me the money and is this one. Whereas in the extortion, if you go to the IPC as well as in the BNS, extortion using the criminal force without the consent of the person to get the possession of the money or whatever it may be. So there we can find the difference. Ha. Terrorist, the ultimate aim is to terrorist case. Then we can, yes, UAPA.
So one point with regard to organized crime, it could be for a material benefit, which may include a financial benefit, but it is material, largely is economic. So as I was mentioning, in the grander conspiracy, if you look at it, organized crime does become a chain in the commission of terrorist activities, one. Secondly, I would point, and this was one thing I wanted to deal with in another scenario, but I'll take you there anyway, and two things we can cover. Look at 32 of BNS. 32 of BNS says, and very simply I'll put it, just a sec. Acts to which a person is compelled by threats, because you mentioned he's forced to give money. Except murder and offences against the state punishable with death. Nothing is an offence which is done by a person who's compelled to do it by threats, which at the time of doing it reasonably cause the apprehension that instant death to the person will otherwise be the consequence. So if he is being coerced, then he doesn't become liable by virtue of 32, because if he is able to show that he was coerced by a fear of threat to his life, yes. And one more point with regard to organized crime, extortion is specifically, unlike the state legislation, extortion is specifically by name mentioned as an activity that falls within organized crime. So when it is linked with terrorism, definitely as a part of the conspiracy, you will deal with it as organized crime, but also if the other person who's raising these funds by extortion, he will also become liable. We can absolve the person who's being extorted by virtue of 32 and Sudesh Kedia, but the person would be liable either both under organized crime, 111, and 17 of UAPA. So with regard to organized crime, there is a state level legislation, sir. So, okay, so there is no state level legislation for Manipur, but there are about 7-8 states where there are organized crime state level legislations. Haryana. I'll have to check that. There is yes, sir. So that's a new legislation coming. Broadly, all of them are on the same page. They are more or less similar to Maharashtra's law on organized crime. Yes, sir, Makoka. Probably not, sir. I don't think it has retrospective application. One thing with organized crime, I would say, since you have mentioned this, I'll take it a little further. Today there is a person, right now I don't think that you can have a retrospective application, but in organized crime there is an exception. For example, today there is a group that is committing organized crime, you want to charge a person. The provision allows you to look back 10 years for any, it says continuing unlawful activity, right? Continuing, they have said if you want to see continuity, you can look at existing FIRs for the past 10 years. Because otherwise, if you see 531 of BNSS and 348 of BNS, it says repeal and saving. It says, it draws a clear line of divide that from July 1st, you will apply BNS, things gone before FIRs will continue under the old law. Here, this allows you to read and consider previous FIRs under the old law for activities of the same nature done by the same person or the same syndicate. So past 10 years activities in a new incident happened post-July, you can definitely consider. So in that sense, you can have a bit of previous application. If he commits an activity post-July 1st, then you might have, you will be able to consider things he's done before 1st July. In that case, you can, but otherwise, first he needs to commit an act post 1st July. This I wanted to take you to 32 with regard to, there was a query once, somebody raised it in a program from the state itself in CAPT. They had raised an issue of young people being taken, coerced, forced to join a terrorist organization, and terrorist organization, and are put through training. They are minors, and later they are entered into the membership rolls. So the question arises, when they are caught, are they liable or not? So number one, I wanted to just make a point, if he's a minor, his consent is irrelevant, because he cannot, as a minor, consent to anything. But the question arises, suppose he is at the age of 18, post-18, continues, maybe he's under duress, maybe he's under coercion. So then, when he does not break free from the organization after he turns major, is he liable when he's caught to be punished as a member? So here then 32 becomes relevant, because it says if he was under a threat to his life and that's why he continued to be a member, maybe you can consider that he's not liable. So for these kind of scenarios, 32 would be your answer. So if he's under a threat to his existence, to his life, threat to life, then these kind of cases where they are coerced, you can draw an exception. That's just the point I wanted to make. I had promised them that I will research it and give them an answer, so I thought now would be a great time to answer that. Sir. He's saying that he was engaged as a lawyer. So whether he is liable for the activities of terrorists. So to my mind, this seems to be a completely different scenario. That is, you are a professional, an advocate for that scenario, and there is an organization which is a terrorist organization. Am I right? Correct so far? Or an unlawful association?
Yes, I know that. That very accused is a member for that allegation of being a member of unlawful association.
He is a member.
He is a member. Allegation. The case is to be fight in the court. In the meanwhile, who engaged me? He is in the custody. That very accused is in the custody, and I have been engaged by another high-profile member of that very organization.
Okay.
He came to me.
Him.
I have been engaged by him on behalf of the accused in the custody. Then, whether it shall be interpreted that I have been promoting the activities of that very organization or not.
No, sir,
we are
to
in
my
the
mind,
profession
no.
only, but this very provision of 132 of this BSA does not provide these things, I think.
To my mind, sir, no, I don't think you are liable for doing a professional duty.
Yes,
I don't
professional
think so.
duty, but my confidential communication may be leaked because of the surveillance, adequate surveillance of the security around my chamber.
Right.
We have confidential communication with our clients, but it has been leaked.
It has been leaked by intercepted communication.
And kept by the securities. Then in that case, what will happen to me?
Sir, I would say you are not liable because you're doing your professional duty. Very honestly, that's not an activity that is targeting the state.
But the fees paid to me is maybe somewhere from the other source.
He's brought illegal money and he's paying you.
I don't know that also, but
Possibly.
the allegation comes to me.
That's a problem, sir. I do. But you did not collect those funds for terrorist
Whether we are
activities. So
fully
you're not
protected or
liable
not
for
in my
that.
profession is this is my question.
Yes, sir. You are not collecting funds for terrorist activities, first
Yes,
of all.
I am not collecting, I am taking the money which has been collected from the illegal field.
Sir, to my mind, no, you are doing what is your professional duty, and
There
that
may be
does not become
confrontation
a...
between the police and our profession in that case. I want to clear this.
That becomes a challenge in practical terms because they will be like, how are you representing a terrorist is a concern, yes, but legally I don't think you are liable for doing what is your professional duty, in simple terms, sir.
Partly this is provided in 132 of this BSA.
So you have something to add, sir?
Yeah. But whether completely protected or not, this is a very challenging question in
I
our
understand,
state.
sir. Sir has something to say to that.
Yeah. See, here you are following just only the professional ethics. For the lawyers, there is a professional ethics. For example, a murderer comes, for example, a UAPA member comes or a terrorist comes and you have taken up the case. And there is a professional confidentiality also. So he might have told that I am the murderer, I am the one who have made the terrorist this one. But your professional ethics allows you to take the case and still fight the case that he is not a murderer, he is not this one. Now coming back to the question that you have received the funds from him. The ultimate mens rea for you is that not to put it into any terrorist organization, but as a professional fees you are getting, this is the one thing. Another point is that how do you came to know that whether he is funding from the terrorist organization or this one? This is another question that is coming especially in the recent cyber crimes. So there is a portal called National Cyber Crime Portal, that is 1930. Earlier it was called as National Cyber Crime Portal for the Protection of Women and Children against cyber crimes. Now it is redesigned as National Cyber Crime Portal against the cyber crimes. Here what happens, for example, I am the victim and somebody A has frauded me 1 lakh rupees. Now immediately when I go to this www.cybercrime.gov.in or 1930, when I lodge the complaint, 1 lakh that has been frauded by A automatically will get freezed. Now what A will do, A will distribute 10,000 to another 10 persons. B, C, D. For example, B is a restaurant owner. A gone to the restaurant and paid restaurant fee and all those things as 10,000 rupees. Now what this cybercrime portal will do, up to the 10,000 rupees for the second layer, it will get freezed. Now B is asking a question, how can I know that the money paid to me as a bona fide fee or a bona fide restaurant bill of 10,000 rupees by A is a means of fraud? Isn't it? This is the question that the B, C, D, E are all asking in the National Cybercrime Portal. Yes, this is a major charge. But B will not be frauded or B will not be treated as a crime or anything else. Only thing is that their apprehension is there and the National Cybercrime Portal is thinking on these things. In any way, you will not be held responsible for getting the money, this one. And in the same way, B, C, D in the cybercrime case also, they will not be lead to this one. But yes, when it becomes fraud, now there are some cryptocurrency agencies like WazirX. Sometime back WazirX was in the news because WazirX and Angel and these did not follow the proper KYC rules. Now what they have done is that every cryptocurrency agency which is investing the money has to deal exactly with the KYC. That means to say that I am the person, I am going to WazirX to raise a virtual account in my this one to invest in cryptocurrency. Now it is the duty of the WazirX or the whatever be the platform to see whether the funds that I am parking there as an investment of cryptocurrency is a fraud money or is from illegal means. That is the thing that the new government rules have been come. So just for the information I am telling. Thank you.
I also would like to add.
My question further.
No, just I'd like to add one question. This thing. See, if I'm a member of a band organization, they do have a right. They do have a right in a sense that they are not punished beyond what they deserve to be punished. And as an advocate, it is your duty to defend that, yes, he may be punished in such and such section, but in such and such section is not applicable as per his acts done or as per being a member of the organization. So for defending an accused or any member of the band organization, any advocates have nothing to fear, because as a profession, it is the duty of the advocate to bring justice, to assist in bringing justice. So there's nothing to fear. Supposing if I buy something grocery and give 2,000 not, and that person who have kept terror fund, with that change, he returned back the money to me. That doesn't mean that I'll be charged because I got the money changed from terror fund, this thing. So there's whatever fee that you receive doesn't matter, whether, because that is the fee which you charge. Whether that is from a terror fund or from a clean or white money doesn't matter. That is a fee which you are supposed to charge. If you want to go pro bono, that's different matter. But that fee have no authority have the question. I mean, as Madam also rightly said, that fee which you receive are not going to further fund terrorist activities, but to support your family. So I think there is nothing much to fear for that.
But the still apprehension is there, because the one who engaged me indirectly on behalf of the person in the custody, he may be someone who has been proclaimed offender also, but I have no knowledge about him. In that case,
So
proclaimed
one thing,
offender.
just adding to the point sir said, because you are saying you are representing somebody who is a proclaimed offender, for this act,
No, that is not the question.
the,
That very accused
sir.
is in the police custody or judicial
Somebody
custody.
else who's
Then in the meanwhile,
member-
I have been engaged indirectly by another activist or high-profile member of that very
Yes, sir.
organization. Then he may be a proclaimed offender earlier or not, but he engaged me indirectly. In that case,
Right,
I am
sir.
liable for that offense.
to the point what sir was making, I'm just adding, he also has a right to a fair trial, presumption of innocence. So he may have committed offenses in the past, but can we convict him right now at the time? Does he not have a right to a fair trial to be represented by a lawyer of his choice? If he chooses you, aren't you also duty bound to represent him? So in that sense, the presumption of innocence kicks in, at least for this part of the, he may have done things in the past, his members are roping you in to represent him. You are well within your professional duty to represent him. He is entitled to a fair trial. Even Kasab was given a fair trial. So in that sense, you are not violating any law. You are not supporting a terrorist organization or promoting a terrorist for that matter. You are doing what is your professional duty, and you are giving him a fair chance before the court. So within that, I would say you are absolutely entitled to do that, and you should rest assured you're not committing any offense as such. You're not a terrorist
So far,
yourself.
I'm not committing any offense.
Absolutely, sir.
Something please. There is no nexus in between the receiving of
Yes.
that money and talking with the highly profound members. If he is not involved in the terrorist activities of that particular organization, that's why there is no nexus in between that particular organization and the receiving and the talking with that person. That's why there is no nexus. That's why he is not liable for that.
Absolutely, sir. And again, the point, I think that I've done my job well, if you're saying this. That is because ultimately terrorism offenses are mens rea emphasis-based offenses. Intent is crucial. So that intent has to be manifested to show that you had an intent to target the state. If you're representing him, that intent is missing. So mens rea is absolutely crucial if you want to bring in a terrorism offense against anybody, for you for that matter. It's,
but still
you do not have that intent, sir.
Security
So,
surveillance
sir,
is
very
there
well
in my
put it,
camp
sir.
market.
Another thing, that is another thing, but in factual, there is no liability for you because there is no nexus in between the terrorist act and terrorist organization and taking the fees and communicating with a highly profile person.
Absolutely, sir. True.
Thank you.
Very good afternoon. Very good afternoon.
Sir.
This is Syed Abdul Samad, SP Special Crime and Departmental Cases. Well, we are very thankful for your this session on terror, because I would like to highlight few issues and even technical issues and queries which we might be expecting. This terror offenses, right now, as of now, the state, we are very much familiar with UAPA. We are familiar in such a way that our state is having the maximum number of UAPA cases after JNK.
Okay.
And the conviction rate is also very low. As it has been already highlighted in the new laws, the SP has to decide whether to book under BNS or UAPA. Now, here comes the situation, as we have already experienced. An incident of IED explosion and ambush took place. We have witnessed innumerable cases. At that point of time, the SP will decide whether to book under, right now, as of now, as a practice, if it has led to explosions, explosive activities, then we add Explosive Act and other relevant sections of IPC as of until now. And if we know that such and such organization has already, they have carried out this attack, but as a practice, now there comes a situation, the SP has decided we will book under BNS. But in due course of time, XYZ organization has claimed the responsibility through media. Now the question arises, the ones which we have booked under BNS, what happened, what has been the practice is that we have booked under relevant sections of law at that point of time. But at a later stage, when such an organization has claimed the responsibility, we add that UAPA sections.
Right.
Does this provision still exist? This is the first question. This is my first question.
Question is asking us if later they are, in the course of the investigation, they are adding in UAP. So can they do that? They can bring in the course of the investigation if certain other facts are revealed. They can continue investigation under UAP. They have lodged it under BMS, and later they are saying can we add in UAP and investigation is continuing. I think so, sir, if you want. So two things would come out. What we are seeing is, yes, you can in the course of the investigation, you're filing, you could file a charge sheet, you could file multiple. But the point is, if you want to, you can, if the materials as you disclose, that are disclosed during investigation, if you feel that UAP further needs to be brought in, yes, you can, but two things will come out of that. One is the moment you have brought in UAPA into the matter, then maybe the jurisdiction of the NIA kicks in. So then maybe that procedure that we were discussing earlier, having to report it to the government for a call whether the NIA takes up, that might become what gets triggered after that. So right now nothing stops you from examining the materials in the course of investigation and seeing if UAPA becomes a relevant statute to rope in during the course of investigation. I think nothing stops you from doing that, but consequences will change after that.
Fine, thank you. Next question, my second question is that it has been highlighted that SP has to decide whether it should be booked under BNS or UAPA.
Yeah.
But it is not clearly mentioned who is going to register the FIR. The SP has to decide, of course, it is fine, but who is going to register the FIR? As of now, the OC or SHO registers FIR.
As per NIA Act, it says the police officer in charge of the station would be the one registering the FIR. But then, if it is, he will have to act on the decision of the SP. So I think if you read NIA, that gives you the answer who's the person registering the FIR.
Is there any format for the SP to decide? Is
Currently,
there any written
no.
format?
In fact, I would say there's one step further. Format to decide, also the question is, he says it says shall decide. But does it require him to record reasons for deciding? It's still vague. It's up to you. Right now, the law does not say shall decide with reasons. He shall decide. But whether he has to record those reasons for lodging in either of the statutes, that also itself, the law is not clear right now. Maybe in the course of interpretation, when these matters come before the courts, they will give you a requirement of what needs to be provided when you decide this, when you make this call. So whether the reasons have to be recorded in writing, right now the law doesn't require you to do that.
Good afternoon. Section 239 clause 5 also already talk about the, madam.
Yes, sir.
Section 239 clause 5 of BNS have already talked. At the time of investigation, it may apply BNS. But in the course of investigation, if some findings are found new in the course of investigation, it relates to an open organization. At the time of submission of his charge sheet, he may change it. Is this written in the 239 clause 5 of the BNSS?
BNSS, 39 clause 5. Let's have a look.
The deliberations of your speech, I have already noted down that.
39 clause 39 of BN. No, I'm looking
239
239.
and 239.
That is addition of charges.
That is there. The IO of the case or the SP concerned has the right to choose the option and depend upon the findings of the investigation.
239 is with regard to framing.
That is the submission of charge sheet.
His question was at the stage of investigation if they.
No, at the time of investigation, any BSN may be booked at the time of lodging FIR. But in the course of investigation, at the time of submission of charge, they have the option to submit in accordance with the BNSS or UAP Act.
Okay.
That is,
The
yeah.
question sir was putting was a little one step earlier, that is, they've lodged the FIR under 113 BNS, and in the course of investigation, they feel UAPA needs to come in. Are they bound by the section in the FIR, or can they add things later? That's what was the question that sir was putting. So that we have, I think, to my mind, nothing stops you from seeing the material and directing the course of investigation. Till the point you file the final charge sheet, you're quite well within your right to explore what all offences are made out. So that would be.
What I meant is that just after a few days of the incident, few organizations, they do claim that they have committed such type of act.
They
So
claim credit for the
yeah, claim
act.
the responsibility. That was the case.
Yes.
And secondly, ma'am.
Sir, just a question, just to understand how this is operating. You are saying that there is an activity which is done, terrorist act per se. Till the point nobody claims credit for it, it is going under 113. The moment somebody claims responsibility, UAPA comes in. Is that how it is operating, sir?
Right, right.
Okay.
UAPA or say, as of now, such type of activities we used to book under UAPA, or if UAPA, that too if they come under the schedule list. If they don't come under the schedule list, then we usually book under 400, earlier 400 IPC. So that has been the norm up till now.
Right, sir. Thank you.
And second, my another question is that the IO, investigating officer, is not being mentioned in the BNS. Under UAPA, not below the rank of DYSP, but as far as the NIA, an inspector rank officer has the authority to investigate the case. So what about, what is the case in this BNS?
It's an offense against human body. So whatever the investigatory powers that are there for an offense against human body, the same would apply. So the normal procedure would apply, sir.
Yeah.
There is no special.
Yeah, in the BNS, it is the, depend upon the nature and gravity of the offense. The SP can enter the DYSP to take up the investigation. That sentence is specifically there in the BNS. So when the SP decides whether it is an unlawful assemblies or whatever it may be the case, 113 or section 15 of the UAP Act, SP has all the powers to entrust a DYSP this case. Because earlier Dowry Prohibition Act 498A and all those things were investigated by DSP. For example, in NIV it is the inspector, which is this one. But in these cases, depend upon the nature and gravity of the offense, the SP can decide. Yes.
Fine, thank
But
you,
with regard to scheduled offences, which would be waging war and endangering sovereignty, those two offences in BNS specifically and UAPA, the officer as per the NIA jurisdiction would be the right one.
Fine, fine.
Only for terrorist act, it would be what sir is saying, it would be that officer.
Good afternoon, ma'am.
Where are you? Yes, ma'am. Please.
I'm Sundarwala, SDPO. Continuing from what sir has asked, I just wanted a small clarification. If a crime is committed by a member of scheduled unlawful organization, will it automatically fall under UAP Act, or how do we attract terrorist act? Where do we draw the line?
So you're saying there's an organization, he's a member of an organization listed in the
Scheduled
first schedule.
unlawful organization that
terrorist
comes under UAP, yes ma'am.
Terrorist organization. Okay, he's a member and he's committed an act.
So yeah, he has committed an act, so will it fall under, automatically comes under UAP Act, or like when do we attract the terrorist act, like where do we draw the line?
See, for the commission of the terrorist act, I think you would go under either 113 or 15 of UAPA, because as such, if you look with regard to terrorist organization, only 3 offences are there: membership, support and fundraising. But for the commission of a terrorist act, you would have to go back to the offense of terrorist act, which is either section 15 UAPA and the additional sections along, or you would go under 113. So for commission of the act, membership aside, commission of the act, you would have to actually look at terrorist act as the offense. So there you would have to either 113 or, depending on what the SP decides, 113 or UAPA section 15 to 21.
What I'm confused here is, ma'am, the act is, let's say the terrorist act, but it is committed by a scheduled unlawful organization. So which one to come, like first, UAP Act or terrorist act, or like when SP decides?
It's a terrorist organization, it's committed a terrorist act. The
What
factum,
will come?
the factum is the organization is committing a terrorist act. It's banned, it cannot operate, that is a different aspect. But the commission of the terrorist act itself is a standalone offense. So the fact is that it is banned, it complicates things further for them because you are a terrorist organization which is banned, but you committed a terrorist act. So for the offense, you will specifically look at only 113 and section 15 to 21 for the offense of committing the terrorist act. Right? So I would say first look at the offense that is committed, terrorist act, then add on things would be membership and etc. of a terrorist organization. The existence itself is illegal is one thing, but they have committed a terrorist act, that itself has to be penalized. So that would be 113 or section 15. So SP takes a call, depending, there is no rationale why they should opt for either or right now. Because you are saying because it's a terrorist organization already under UAPA, shouldn't you bring in UAPA offenses there, right? Or why should you go for 113 when it's already a terrorist organization under UAPA? That would be a decision for the SP to take. The SP might weigh these factors saying, it's a terrorist organization, committed a terrorist act, we need to bring in UAPA because that might deal more comprehensively with the entire matter in hand. That would be but for a SP to decide.
So, ma'am,
the law does not provide that.
What I'm confused here, let's say, ma'am is saying, even in the book is also saying that it is the SP who shall decide, but what, I just want to know what is the factor to decide?
Right now, the law does not provide any factor whatsoever to
so it is the
control the decision. So this might be the rationale that the SP weighs in his mind. He may or may not record this, but this might be the factors that weigh in his mind. 2-3 things might weigh in his mind. One is, does UAPA cover the entire offense, the nature of the activity, the organization, what has been done, more comprehensively than 113? That might be the factor. He says, okay, let's go under UAPA.
Yes.
That might be a rationale, but the law does not require him to consider that rationale, one. Secondly, he does not have to record these reasons, so we may never know if that was the rationale that was in his mind. So ultimately, the law does not circumscribe the decision of the SP. The SP has to take a call, depending on factors, even investigation for that matter. It might be far more suitable to investigate the matter under BNSS, because if we opt for 113, BNSS kicks in. So that might be also rational that they would want to investigate it under BNSS, or they might want the stricter provisions of remand and bail under UAPA. These might all be rationales which weigh. So, but these rationales are not prescribed under law for the SP to take a call. Right now, the law does not tell the SP how to do this decision. The SP will weigh all these factors and ultimately come to a call that we will ultimately see as the this jurisprudence evolves, what were the factors that came into mind when they made this call of picking either BNS or picking UAPA. But the law right now does not tell the SP how to make this decision.
Good afternoon, ma'am.
Good afternoon, ma'am.
1 minute, can't see.
1 minute.
Ma'am.
1 minute.
1 minute, the sir had said.
I will add something to her question. Suppose an unlawful organization which are declared banned under UAPAC Schedule first schedule, if they committed any act, any terrorist act, my advice is to the police personnel to register FR under the UAPA Act, because it was committed by the unlawful organization who are declared unlawful. So for any organization who are not declared unlawful organization, some organizations there, if they committed any terrorist act, there is this is to decide by the SP. By the SP, suppose in the earlier time, police personnel registered the case under section 400 of the IPC for any other crime committed by the gangs who are not declared unlawful. So now, those offenses can become under section 113 of the BNSS. For the crime committed by the unlawful organization, declared as unlawful organization, is better to register under UAPA. this gap, this distinction is only there. So SP has to decide. And another that I will add also to another to the question. Suppose a case is registered under section 113. Then after that, during the investigation, some material is available which attracted UAPA. Then when the SP was decided, it should be registered under the section 113 BNS. Then SP has to decide again. The IO has to report to the SP during the investigation, such materials are available which attracted UAPA. So he has to report to the SP, then SP again to review his order, first order. Then you can change to the UAP, then the procedures of the investigation for UAP will continue. Because handing over to the NIA or something, you have to change your investigation procedure. This is the thing. So we can, you can ask a question. Who are the?
Sir,
Raise your hand.
may I interrupt?
Oh.
Sir, as you have stated, my question relates to Schedule 1. So if an organization is listed as a terrorist organization under Schedule 1 of the UAPA, but the Schedule 1 does not specify its formation and manifestation. Like there are some organizations I would not like to mention. However, can this organization still be legally considered a terrorist organization? Like there are some formation and manifestation, however, it does not mention in the UAPA, in the Schedule 1. So does the lack of such details invalidate its designation under the UAPA?
It's not specified by name in Schedule 1.
It does, it does specify the name, however, it does not mention its formation and manifestation. Like just say there is an organization, a terrorist organization, but there are some formation and manifestation. Like
it might have wings or branches or something.
Yes.
Are you trying to say that?
Yes. So
okay.
Does the lack of such details invalidate its designation under the UAPA?
So
that's my question.
If it is not mentioned by name in first schedule, no. By specific criteria, by specific notification, a specific organization is declared a terrorist organization. There might be other organizations linked to it also which are not declared. No. It has to be mentioned by name in the schedule, only then can we penalize it to be a terrorist organization. So there might be manifestations, as you're saying, there are sister organizations or brother organizations which are not mentioned in the schedule. It does not apply to those organizations. Only the ones named in the official gazette, which are now included in the first schedule, only those it will apply to.
Okay, ma'am. Thank you.
Good afternoon, ma'am. Here it is. Sir, here, this side, ma'am. Your right side, ma'am. Yes, here.
Okay, I was expecting a question from her. She had something to ask. Yeah.
Okay. This is Saran Kumari. I would like to know from you that how do you define ethnic violence? And if it is organized by some group of people, then whether it will comes under the term terrorism. And if it comes under the terms terrorism, then whether it can be considered as waging war against the state under section 147 of BNS. Shall I repeat, ma'am?
No, I got the point. You're saying that they are committing ethnic violence.
Yeah,
right?
How do you define ethnic violence? My first question. And if it is organized by a group of people, then whether it will comes under the term terrorism. And if it comes under the term terrorism, whether it will be under the Terrorist Act, which will comes under waging wars against the states under section 147 of BNS.
It would, depending on the factual scenario. Broadly saying, first coming to the point of ethnic violence. Very simply put, I won't give a very elaborate description of what I think. If it is a violence which is based on a rationale of any ethnical rationale for that matter, that is one ethnic community against another ethnic community, certain points like that, that would be what would be called a violence that is driven by ethnic reasons. So maybe that's what I would say would be ethnic violence. Coming to the point of whether this would be an act of, say, waging war. Now, if you look back to what we were discussing earlier, often these things are the intent behind an act of waging war. If you look back at when I gave you the intent part of waging war as per jurisprudence developed, it said waging war can be an activity driven to cause communal tensions in society as well as public order, disturbing law and order, peace and tranquility in the society. That would be, now you're trying to create a situation where there is unrest and public order problems in the country. That would be something that is an act of waging war. And then going to that judgment that I gave you in the last, which said internal disturbance, whether that is an act of waging war. The dominant intent behind it is to create a state where there is public unrest, you're basically causing a situation where the entire state mechanism, the prevailing peace and tranquility of the state is being put to peril. Yes. You're disturbing that. That would be an act of waging war. So, but it depends on facts to facts. You need to look at each fact, whether the driving intention behind that was to create such a state of law and order problems in the country to kind of destabilize the state in that sense. That would be something that I would say, if it is an ethnic violence, that would be something factually that would become a matter which is waging war.
So whether it can becomes under the term terrorism again?
It can be.
It can be. Thank you.
Or else sometimes it may comes under the definition of 103(2) also, mob lynching, and 117(4) also. Now, if you see the definition of the mob lynching, it says language, sex, community, and reasons to believe by those persons also. It is quite vague. So I feel that there is a person, and my community and his community are this one. So there is a word community also, and reasons to be believed by that mob. The only thing is that 5 or more persons are involved in that mob and they killed another person. So the specific word mob lynching is not there. So in these cases also sometimes it may be ethnicity but comes under the definition of the mob lynching 103(2) if the person dies, or if the person does not die but he get into a grievous act, then section 117(4) of the BNS will be attracted, just as an add-on.
Good afternoon, ma'am. I am Momota Thaunaujam. I am very grateful to witness your valuable session. And I want to discuss a matter there has been many cases recently where an arrest arising out of the Nakabandi, like a phrase seeking and checking, are being booked under the section 17 and 20 of UAPA Act. Then there is a delay of release on the accused from the custody on the ground of the seeking sanctions or further investigation. By that time, the freedom of the accused is restricted and restrained. It mentions essentiality to be liable for an offense, should not necessitate the state to prove its force.
Very simply, if it's a UAPA offense, remand is far more stricter. Bail is also far more stricter. That is the interest of the state is paramount. So yes, if he is kept within the reasonable period of remand that is allowable, it would be a fair exercise of the investigative powers, that is they're keeping him in jail while the investigation is pending. The remand period is extended. So if it does not violate that remand period, so far so it's a fair exercise of power. So bail he cannot get as a matter of right. It would only be in cases where he is entitled for default bail, that is he's kept longer than the period of remand and where the trial isn't commencing. At that point of time, yes, the courts have held that yes, the statutory bail cannot be held to be an unlimited exercise of keeping him behind bars, but ultimately he will be entitled for default bail after this period is gone. So till that point of time, yes, he can be kept behind bars. So bail is stricter.
But ma'am, the accused person has been met his arrest arising out of the frisking and checking on the allegation of the suspect.
But he's charged under UAPA.
Yeah, UAPA under the section 17. They are booked on the Nakabandi, like frisking and checking, and booked under the section 17 and 20 of the UAPA. But the SP sir also told that conviction rate is very low, those who book under the UAPA. But till the time of the clear, should the bail granted or not? In your opinion, what the advocate will do in this period to save the freedom of liberty of the accused persons?
I would say for all stakeholders, including the advocate, follow the letter of the law. The remand, you can keep him up till the period of remand. Bail has to be granted if you're going beyond a reasonable period of time. Till that point of time, follow the letter of the law, follow what is required under 43D. That is where he can be entitled to bail. Look at that. And I think a fair exercise of those powers is what is in the interest of justice.
Okay.
So,
is it required a strict mensura to essentiality to be a liable of an offense?
I'm sorry, I didn't get you.
It is required a strict mensura for those who arrest on the Nakabandi and book under the section 17 and 20 is an essentiality per according your slide. Mensura is essentiality.
Essential, yeah.
And it is like should know the law necessitated to state the proof each offense, or how can we proceed for the further?
See, up till this stage, it's all on a prima facie evaluation of the materials before you. So at that point of time, if the materials disclose that he is liable, he seems to be complicit in the offense that is involved, 17 for that matter. Till that point of time, yes, the provisions that follow will kick in. So yes, bail is not a matter of right as such under UAPA. It is a far more stricter provision. But that letter of law will apply the moment the section is invoked. Okay. So that is the reality of the statute. We will have to be. But please remember, if you are applying it to very limited cases, you are not going to have everybody being charged under this if you apply it fairly. So this kind of a stricter provision of incarceration will not apply to every case. This will only apply to offences against national security. But yes, it is strict.
Okay, thank you, ma'am.
Good afternoon, ma'am.
Yes, sir.
Yes.
There was one sir up there who had a question. Yes, sir.
My name is Thingom Susni Kumar Singh. My question is, A has love affairs with the lady B, unknowingly that B is a sister of one leader of UG listed in the first schedule of UAP Act. B called A for dropping to her house. A go there and pick up B. On the way, they met frisking and checking conducted by CDO under the supervision of the SP of their jurisdiction. From the possession of B and her lady's bag, seized one live round ammunition for letterhead of the UG and some case at around 9 p.m. Under section 42 clause 5 of BNSS says that some except in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall by making a written report obtain the prior permission of the magistrate of the first class within whose local jurisdiction the offense is committed or the arrest is to be made. Then B has handed over to her parents or her relatives. And police also did not take prior permission of the magistrate first class. By that time, it may be there are unavoidable circumstances. Here, my question is that A shall liable under unlawful UAPA Act as he did not know the law, or there is no law any means to arrest the lady B for smooth investigation, and shall be free from that terrorist act.
Okay. He's saying that the girl was with him. She took him, went with him. He was caught. But
your question is very long, so
so you'll have to use your
please
mic.
bring your this.
Actually,
moderator da ayona ay Manipur da amu ay hajarake A sina B kauba nupi amakak love affairs lejare unknowingly ma B se ngasagi akogi one leader UG amagi masan ni haibasidi A sina khanghou de adubu ngasagi B sina
ngako nangi amakano do mi ama de UP de haido kano raba organized crime ke kano to mi raba kambu raba
ngasagi listed in the first schedule of UAPA Act ki makha da leba amakaki masan nupi oidune ba B se ado ngasagi B se madi aduni haibase A sina di khangja hokdreba adubu mabani love affairs di leithoreba B na ngasagi A se da ai gari phangre pharak tare aduna ai yumbau da di drop to bio na man harak badagi A sina mamana bagi gari ma waira kanda B se lokhal ure adu mai mayum da thinba lakpa kan sidai da ngasagi on the way da ngasagi commando na frisking checking to wa ma thengnare under the supervision of SP from their mukogi jurisdiction dugi SP ma thengnare thengna kan ngasagi makoina check to ba kan sidai da ngasagi nupi sigi magi position dagi magi ladies back dagi ngasagi akoi one live round immunization ma seize tore 4 letter head moi ngasagi mabung dugi UG dugi phange some case kharasu paisa kharasu phange aduga ngasagi hujiki law da akoi section 45 clause 4 CRPC aduga hujiki new law gi section 42 clause 5 BNS da di before sunrise and sunset nupi di phaba yadre hare karigumba phaba ta phaga dabne hargadi akogi prior permission ama akoi magistrate first class tagi logodobne na hare adubu nungdangi matam oyunina madu unavoidable circumstances da police tuna ngasagi madugi prior permission do logdaba ni khangde adu baina logidre aduga hariba nupi B se ngasagi maki mama mapa natragana magi my relatives da handed over to thokre nungdang sida ado aina huji hangjaninge bo question sidi A na B lokhat pa chalu base ngasai UAP gi law se ma khangda batuna maram orakanda ma liable oigadori bra natragana B C smooth investigation gi damakta mark se arrest to ba darkar oidabra natragana ngasai gi B se high terrorist act dagi free oigadori bra
A do the far bro police na
A do the faraga madi judicial remand like the yora
sir, I kumage sigse matam mange ba. Go. I think we are off shooting our lunch time again. The tea was cold before, no, so it have to be reheated again. Anyway, Hajiki Miyamasi a terrorist. Somehow he make a fake identity and he was traveling by Indigo flight to Delhi, carrying such incriminating documents like demand letter and all. Can the pilot be arrested or can be he booked? There's the same question here. Not at all related. He's not a member. He have no knowledge, no intention. He may be a witness, but he cannot be made an accused. Regarding that ethnic violence, madam, that yeah. See, ethnic violence committed by a banned terrorist organization, which is in the Schedule 1, yes, it's a terrorist act. But ethnic violence committed by some individual, it cannot be a terrorist act, but he can be put under BNS. That's a different matter, but it will never come in under UAPA Act. I think we have to break for lunch. And whatever other questions now we can have during lunchtime.
May I have the last question? May I have one last question?
I feel bad that he had a question first.
Hello?
Exactly.
I just...
Please change your microphone.
Use the other mic if this one is not working.
Hello?
Yeah, that's better.
Okay, I am Paikomba LADC, Chief LADC of Thogwal. I just want one clarification from Sir Manoj. As Sir Manoj has stated that if a case is registered under 113 BNS, and later on the IO added provisions, sections from UAP Act. In that case, Sir has stated that the IO has to report the matter to the SP, and the SP has to review his earlier order. But sir, instead of that, can the IO report the matter to the OC? And can the OC be reported the matter to the concerned magistrate instead of reporting the matter to the SP directly for reviewing his earlier order? Can this be? Thank you, sir.
No, there is explanation in the section 113. SP has to decide in which section UAPA or section 113 of BNSA. SP has to decide. So OC cannot decide. So if the IO during the investigation find having prima facie of material of attracting UAPA, yes, he can report to the OC. Then OC is to be reached to the SP. SP has to decide. That's why SP has to decide. It can become up to from OC. This IO is SI or SI. He has to report to the OC. Then OC to report to the SP. Lastly, SP has to decide. First, he has to take decision. Then it should be under the under the section 113 of the BNSS. If the matter comes up like that, the OC or IO has to bring the matter to the notice of the SP. Then SP has to decide again whether it should be under the UAP Act, under the 113 again. He has to decide.
Just to add to one point, just to add to one point to what Sir was saying, when you are lodging the FIR, it's right at the beginning of the matter. Whatever the materials disclosed at that point of time, the SP will take a call, whether 113 or UAPA. But then in the course of the investigation, more materials definitely will come forward. If things disclose that UAPA needs to be added in, I don't think it's a letter that, you can't look any further than 113 if it is lodged under 113. You can always, based on the material in the course of the investigation, look at the other offences that are being made out, what materials disclose, whether you need to rope in UAPA. So ultimately, till your final charge sheet is filed, I think you can definitely explore both the statutes and see what your investigation, where it takes you. So that way I would say it's not a hard and fast rule that once 113, nothing more. So even the investigators can examine the case based on the materials before them. So that would be my point to add.
One more question. I am Premsa, Chief Legal Defense Counsel Imphal West.
Yes, sir. I think we'll keep this as the last one because we have to follow Alex's instruction.
My question is very short. Is there any provision for review the earlier decisions taken by the SP in the BNS?
Review by whom?
Review by SP.
SP.
Is there any provision in the BNS? He has already decided the case is to be registered under BNS or UAP Act. Those decisions can be reviewed under what provision of BNS?
Reviewed by the SP himself.
Yes, yes.
Good question. Can he review his own decision?
This is in the course of investigation. Everything can be changed. Everything can be changed during the course of investigation. Sometimes informant also become accused. Sometimes informant also become accused. First research the case, then everything will be depend to the investigation. During the investigation, it happens to the having evidence of the UAP, it can be changed. But through the SP has to decide again. It should be bring to the notice of the SP because 113 says that SP has to decide. So it can be reviewed. There is no restriction in the law, but as a general law, he has to decide. First, he has to decided it should be under the 113. Again, material come up, then again he can take decision. Because of the available evidence, this UAPA will be attracted. That's all. Thank you, everybody. Now lunch.
Thank you, madam, and thank you, sir, for such an in-depth deliberation and analysis on the terror-related offences under the new laws. Now we shall break for lunch. I request all the participants to reassemble at 2:10. Thank you. Thank you, ma'am.
Hello. Good afternoon, everyone. We shall start with the 7th session of the 2-day orientation program on new criminal laws. The topic for the 7th session is digital evidence under Bharatiya Saksha Adhiniyam. The resource person for the 7th session is Shri Rajasekhara N, IPS, Director, CDTI, Hyderabad. I would like to request sir to please grace the dais. Yeah, please. No, this is. Sir is an IPS officer of the state of Nagaland State Cadre. So, sir is very familiar with this part of the country. And sir has also been to Manipur as a resource person for some other program. So, I'm sure many of the police officers and some other participants are familiar with sir. So we are privileged to have you as one of the resource persons for today's program. Now I would also like to request Shri C.H. Momont, Professor, LMS College and Panel Advocate, Manipur State Legal Services Authority. So to please grace the dais. Sir is also a regular faculty member of the State Academy training at Takil. So I'm sure many of the police officers and other participants are also familiar with sir. So we have two very dynamic and distinguished speakers amongst us today. Now the 7th session and the 8th session will be taken up together continuously without a break. I would like to request Shri Alek Muivah, Member Secretary, Manipur State Legal Services Authority, to please present a memento, lengyan and a bouquet to sir. Thank you, sir, for the felicitation. Now I would like to hand over the rest of the session to our moderator, sir.
Very good afternoon. So without wasting any time, sir, it's better to start because you have to. So session 7, that is digital evidence under BSA and review of BNSS addition, deletion and modification of session 8 will be held together. So sir, please take your own time, and time is up to 4.
Good morning, good afternoon everyone. So, few things, since there was, we starting almost 20 minutes delay, we will combine both the sessions, and the reflective session we will after both the sessions. This is the number 1. Number 2, no tea break I think. After 4 o'clock only. Okay. Then another thing, I will cut short my presentations because the presentations are huge, and I will concentrate only on the relevant facts so that it will be, I can finish off this one. And the electronic evidence I am covering in the Bharatiya Sakshya Adhinayam. So I will skipping many of the slides which are not relevant or which is of less relevant. So please be sure, and please note down your questions, and thereafter we can have a very, the questioning answer is the most important thing. See, out of the 3 laws, the least changed law is the Bharatiya Sakshya Adhinayam. 170 sections, 170th section is the repeal and the savings. And the important things that has been changed, the addition of only 2 sections. One section is section 61, that is the electronic evidence, digital and electronic evidence. And another section is 170, that is the repeal and the savings. But lot of sections and the clauses have been deleted and added also, isn't it? And up to section 17, that is admission stage, the way to remember the old act to the new act is that there is a difference of 2. So whatever there is section 9, for example, the test identification period in section 9 of the Evidence Act, now falls under section 7. Thereafter, we will have the multiple gap between these things. Because in admission stage, 5 sections have been, 6 sections, in fact, have subsumed in the 1 sections, within the sections. So there 6, and section 22A has been deleted. This is the one thing. That's why section 25, 26, 27 now appears unitedly under section 23. This is the number 1 thing. Section 25, 26, 27. 25 is the confession made to the police officer. 27 is the recovery leading to the material evidence that is admissible before the police officer. And thereafter, section 32. What is section 32? Dying declaration. Now appears under section 26. Next, section 45. That is the expert opinion. Now comes under section 39. Now what is the difference? In section 39 and section 45, a new word called experts in any other field is also added. Because earlier, art, science, foreign law, GQD and all were there, but now experts in any other field is also added under section 39. So these are the important changes that has been there. And section 57, earlier section 51, 9 to 61, that is the primary evidence. Now under section 57, 4 new definitions have been added. 4 new definitions under the primary evidence have been added in section 57. So that is another thing. And secondary evidence also, some minute changes have been made. And shall presume, may presume, earlier in the form of definitions have come under section, here in section 2 only. So no separate definitions have been there in this one. So we will see to that one, and we will concentrate on the section 61, section 63.4. Earlier section 65B, that is the certificate that has to be issued for the electronic and digital evidence under section 65B, now comes under section 63.4. That means what makes the difference is that earlier section 65B, we have only one, that means a certificate has to be given. Now under section 63.4, we have to give 2 certificates. One by the controller or the owner of the data of the electronic evidence, and second certificate, that is form 2, has to be given by the expert. And one of the madam has covered who is an expert, but again add to that one, expert is the one who is as stated under 79A of the Information Technology Act. For that, the state government has to bring a notification who actually is an expert as far as the section 63.4 is concerned. So these are the overall views. We will go into detail a little bit later. Okay. So another thing, only important thing, definition of India has been taken off. See, if you see cyber crimes, virtual private network, Chinese app loans, Tor browser, Onion browser, deep fake, deep web, dark web. And why it is called Onion browser? Because when I am searching any internet, you can trace where the server is there. If you go to the keylog and see what are the hops, isn't it? But what happens in the Onion browser means you cannot trace where the server is called. That means there are multiple servers. That means to say that any offense that has been committed outside India, now it is difficult to trace where exactly the email come from and all those things. In the Onion browser, also called as the Tor browser. Why it is called as Onion browser? Because like Onion has different layers, like server has many layers, so that I cannot trace back the original server. So these are the things that has been there, especially using the cryptocurrency, using frauds online. Now what happened, the word India has been taken because to give a territorial jurisdiction beyond India. You might have seen the Chinese app loans. App loans were made in China. They hired up people there, or they have some accomplices in India and commit the fraud in India. Earlier, even within India, jurisdiction was a major fact, major hurdle. For example, the Muivah region in central part of India, northern part. It touches with Haryana, Delhi, UP, Rajasthan. So what the fraudsters used to do, they make a fraud here, just sneak into the other place and the territorial jurisdiction issues were coming, even within India. And outside India also, our IT Act is not applicable, isn't it? That's why if you ask section 65B certificate earlier, now section 63(4) certificates to Google, Facebook, Twitter, Instagram, they give the information, they don't give the certificates. Ideally so, because they are not entitled to adhere to the Indian laws. That's why the word India has been taken off from the very definition of the Bharatiya Sakshi Adhiniyam. Okay? So presumption as to telegraph messages has been gone because obviously the telegraph is no longer used and all those things. This I will not go into the detail. Next parts. Section 26. Explanation deleted under Indian Evidence Act. Confession by accused while in custody of police not to be proved against B. Section 65B, fifth explanation. Verification of digital signature. Presumption as to electronic messages. See, look at the 73A. Digital signature and electronic signature. You find the definition in the under the Information Technology Act. What is a digital signature and what is the electronic signature? In layman point of view, I will explain you digital signature certificate. What does it mean? It means that, for example, what you do, you go to income tax, you file your income tax and give the Aadhaar authentication. It will send a OTP and file your income tax. That is called as a digital signature or the electronic signature. In other times, what you do, you make your signature, take a photograph and affix wherever it is. There another one called digital signature certificate. You might have seen the dongle type of a thing. That is the pink colored one, which is given by the ESL, Mudra services and all those things, where you can file the income tax or anything via either digital certificate, that is the putting the dongle, or through Aadhaar notification. Isn't it? Electronic signature is that you sign it and paste it there. Now, digital proof as to verification of digital signature has been taken off. Next, this I will skip it. Modification. Definition document includes electronic and digital records. Isn't it? That is very important to undo. Documents means what are the things? Letters, figures, marks, means intent to be used, including electronic and digital records. So section 2(1)D is a basic thing for the electronic and digital records. This is the thing. Next, these are some of the things I have seen. Document is stolen and produced to the court, whether relevant. Now, how many of you say whether it is relevant or irrelevant? Whether relevant or irrelevant? It is relevant. In other ways, in matrimonial cases, what happens? Wife steals the husband's mobile and she produces into the court. Whether it is admissible? Whether it is admissible? It is admissible. Now, can she be charged for stealing of theft one? Yes, that is a separate thing. Or wife or somebody hack into my mobile phone, which is admissible in the record court, take that one and produce in the court. If it is genuine, it is admissible. But what is he charged? He is charged under section 43 of the IT Act. That is unauthorized access of an electronic this one. So these are the things. Because this has a root in America. There is a rule called roots of the poisonous tree. There this principle comes there. That means stolen and produced also. Emails, server logs, documents, laptop, smartphone, messages, websites, locational evidence, voicemail messages, digital evidences or documents. Now if you say locational evidence, what does it mean? LBS, location based services, IPDR, CDR, they are all comes under the definition of documents now. Okay. Now, evidence electronically, oral, I will not go into this one. Under statements including evidence, electronically, logical currently 530. So, 530 is the last but one section in BNSS. Section 530 of the BNSS says all searches, warrants, everything can be issued electronically. We will come to more detail when we deal with the BNSS. Okay, electronic records were treated as documentary evidence. No express mention digital records, but now it has an express mention. Okay, Now, if nothing has been proved or defined, then you have to go to this other laws for a particular definition. Okay. Another word, barrister, pleader, vakil. Now only word called advocate. For just a simplification, lawyer who passed the law degree, barrister passed the law degree in London, pleader, one who takes the cases on behalf of the government from a particular department, advocate, lawyer plus who written the bar council examination and has the license to practice. Now all these words are there. Now only one word called advocate in the entire law. Now all these words are replaced by advocate. Next, whether it is relieved, I will again does not go into section 22. What is the first change? Coercion. Confession caused by inducement, threat, coercion or promise. Remember Indian Contract Act. When the contract is not correct or void in ab initio or void, there you find if it is of distress, duress, misrepresentation, coercion. On the same lines, now coercion has been added. But the thing is that there is a coercion in threat and there is a threat in coercion, if you speak legally into the legal terms. Then 22(1), 24, 22, this one and all those things. Coercion has been inserted in section 22. Next, confession by the co-accused is irrelevant. Now what happened? Joint trial. Confession of a person against a person who is absconding, that is also relevant now. That is especially we will deal with a proclaimed offender under section 84(4) or under joint trial. Okay. Now, promise of secrecy, deception practice, drunk answer to the questions not warranted. Look at them. In the morning, one of the honorable member was asking a question. For example, during the practice of law, the person came to me and said that I committed a murder. I made a terrorist act. Under professional secrecy, I am not there to declare it open. But somehow the court came to know that, yes, he has made to that lawyer that this one. As I told, somebody has put a CCTV against me and it has appeared in the court. Now that is admissible. Isn't it? Of course, the next question is what is the security breach and all those things. That is there. Next, whether relevant may know. Again, I will skip this one. Accused, co-accused in this one. When more persons than one are being tried jointly for the same offense, confession made by one such person affecting himself and some other such persons is proved, may take into consideration. That's what the proclaimed offender or the absconder also included. More than one held under, that's what I was explaining. 84(4) of the, you can add 4 also. Who is absconded or who fails to comply with the proclamation notice. 84(4) is the proclamation of offender under the Bharatiya Nagarik Suraksha Sanhita. Now it says that any offense punishable more than 10 years punishment. Now in those cases, a proclaimed offender can be illustrated, can be declared. Earlier it was not clear, but now it is clear. Next, expert obedience. This one. Any other field after foreign law, science, art, handwriting or finger impression. Now expert opinion also includes any other field. Now what does it mean? By the course of practicing this one, by having enough qualification, a person can be added as any other field, because in certain cases what happened in one of our CBI case, what happened? There was some Arabic documents has to be translated to the Hindi. Now we get it translated by a professor in some of the college. Isn't it? Like those kind of situations arise. Very, very important thing is section 57. Earlier section 262 of the Indian Evidence Act. Now primary evidence. There are 4 new definitions that have been added in the section 57 of the primary evidence. Very, very important for the prosecutors, for the judges, as well as our police officers. What is the first one? Electronic digital record created or stored simultaneously or sequentially. What does it mean? For example, I took a photograph. I took a photograph means it will be stored in my mobile in multiple spaces. not only in gallery, not only in internal storage or in this one, correspondingly or simultaneously, then all those copies are considered as primary evidence. We cannot say whatever there in the camera, that is the primary evidence. If it has gone to the internal memory, it is the second evidence. No, it is the primary evidence. Here question comes section 105 of the BNSS. Yesterday we were discussing. Lot of questions were asking, sir, what happened to the video that has been taken during the search and seizure? Somebody also pointed out e-Saksha app. For example, I gone to the scene of crime, or I gone to the or wherever the search and seizure happened, I took a videography of the search and seizure. Now what I do, I do not download it, I will not download it to a pen drive, I use the e-Saksha app, I will send it to the court through that app. The beauty is that it cannot be downloadable, only the link is shared to the court and link is shared to the accused person or whoever be there. Now there it comes. Recorded, created or stored simultaneously and sequentially. Whether I need to take the 63-4 certificates? No. I took a videography of the scene of crime or the search and seizure. I upload it in the e-Saksha app and send it to the court, the link. I need not to give the section 63-4 certificate or the earlier section 65B certificate, because it comes under section 5, 57.5 of the new law. Then electronic digital record produced from proper custody. Now what happened? Proper custody means that is the same thing. For example, mobile belongs to me and somebody has stolen it and gain it. But it is admissible, isn't it? Proper custody. It may be proper custody in another things that I will give an example. There is a DC office. There is a data operator is there, who gives the caste certificate or the tribal certificate, isn't it? Then who is the proper custody person to give the 63-4 certificate, whether the DC or the person who is controlling the computer? What is the answer? The operator. Although DC is the head of the institution, although DC has approved the issue of certificate on the file, yes, so and so person can be give the caste certificate. Now who is the proper custody to give that certificate 63-4? It is the computer data operator. Why? He is in the proper control and the day-to-day functioning of that computer. Got it? So that's why electronic digital record produced from the proper custody. Video recording that is simultaneously stored in electronic form and transmitted or broadcasted or transferred. It is almost the corollary of electronic, that first one. There it is the electronic digital record, now it is this one. For example, you take a videograph and you uploaded it like e-Saksha Adhiniyam, e-Saksha. Take the videograph of the scene of crime or search and seizure, send it to the e-Saksha app to the court. Next, electronic digital record stored in multiple storage spaces in a computer resource. Very, very important. Now what happens? I will give an example. You might have heard of a file system called File Allocation Table, FAT. You also heard of a file system called NTFS, New Technology File Transfer. If you put some of the pen drives, immediately a pop-up comes. This is not supported by FAT or NTFS. Have you seen this pop-up? Many of the cases, because each of the storage capacity or each of the system, how it stores, it depends upon the operating system. Now to elaborate this one. There is a document of 7 MB. There is a document of 7 MB. What I will do, I will store in the computer. When it store in the computer, it will allocate 2 MB, 2 MB, 2 MB, 2 MB sectors. So 7 MB means how many sectors it occupy? 4 MB. 2 MB first sector, 2 MB, third MB, 2 MB, so 6 MB. 1 MB will be occupied by the fourth sector. Okay, tomorrow I add another 3 MB, another document. Now, whether 1 MB will be stored in the fourth sector or it will occupy the new sectors. What is the answer? It occupies the new sectors. It will not go and occupy the fourth sector where there is 1 MB vacant. Isn't it? So it will. So if you go to the computer in a technical manner, how the files are being stored, you can see the dots of yellow, green, red. Have you seen anybody? There you can see some of the files have been stored here, the same part is stored here, same part is stored here. Here there is another question. I have a 100 GB hard disk. Please pay attention. 100 GB hard disk. August 1, I put 10 GB. August 2, I put 10 GB. Like that, August 1 to 10, I put 10 GB, 10 GB, 10 GB, 10 GB. August 10th, my hard disk is completed. Okay? August 11th, I deleted 50 GB. Shift deleted. Shift deleted. Now, whether shift deleted means it entirely wipe out the memory? No. Can I recover 50 GB back? How many will say, yes, I can recover 50 GB back? Please answer. Let us be interactive. Yes. Although you made a shift delete, you can recover the 50 GB back. As long as it is overwritten. As long as you put another 50 GB on top of that one, still you can recover the shift deleted files. That is how police officers do the investigation. When you take a mobile, using the oxygen, X-ray and all those things, shift delete does not mean that it will go out of your memory. Make sure. So what to do? You have to overwrite. Then only you can get rid of the earlier memory. Okay? August 11th, I deleted 50 GB, shift deleted. Actually, visibly, I can only 50 GB. 50 GB has been shift deleted. I cannot get it. I cannot see it. But what happened? Now 50 GB is available. 50 GB as of now available. 50 GB you can recover using forensic tool. August 12th, I add another 30 GB. Another 30 GB. Then how many GB which has shift delete I can recover back? 20 GB. Now the question is which 20 GB? Whether August 1st and 2nd or 9th and 10th, 3 or 4th, which 20 GB I can shift delete? Any answer? Huh? Random. So we cannot say which GB I can recover, because again it depends upon the multiple storage spaces in a computer resources, where the spaces it occupies, we never know. Okay? That's why I have given the full illustration of the 4 examples, especially for the primary evidence. Next, 61. This is the brand new section that has been added. You know there are 4 case laws in the electronic evidence. Navjot Sandhu case, way back in 2005, Madam was also telling in the morning, isn't it? Where they said, yes, secondary evidence, for primary evidence, no need of certificate and all those things. It was overturned in 2013. PK Anwar versus PV Anwar versus PK Bashir case, a Kerala case, a election related mobile case, where it said that Section 65B certificate is necessary for the secondary evidence. Then came the Shafi Ahmad case, Shafi Ahmad versus the state of Himachal Pradesh, where it said that in all cases, even for the secondary evidence, 65B certificate is not required. When I say 65B, it is the old law. New law is 63.4 certificate. Then everything was cleared, and the Supreme Court held up the PK Anwar versus PV Anwar case and set aside the Shafi Ahmad case in Arjun Pandit versus Kailash Rao case, Maharashtra Jalna district case, where it says that 65B certificate is compulsory, number 1, and you have to produce at the stage of evidence. At the stage of evidence, that certificate is to be produced. That means to say that at the time of charge sheet, you may not be having 65B certificate, but the stage of evidence, admission, your 65B certificate is required. And the same thing has been retained under section 63(4). Now, as per as 61, take the certificates, 2 certificates, and produce the IO. Even though he is not able to get at the stage of charge sheet, but he has to be equipped with these 2 certificates at the stage of admission, when it comes to the admission of the electronic evidence. Now look at this sentence. The definition starts from a negative connotation. Nothing in this adhinayam shall apply. What does it mean? It means 2 things. It supersedes the earlier thing. It is the superseding section, isn't it? Nothing. Second thing, why nothing has been added? Can anyone else tell me? This one? Because why nothing has been added means, what is the definition of electronic evidence? We saw that one. Logs, call records, location-based evidence, websites, and all those things we saw. That is the electronic evidence. But that is not exhaustive. Today, I have many electronic evidence. Even this is an electronic evidence. My button may be an electronic evidence if it is a spy camera. My watch, smartwatch may be an electronic evidence because it is a smartwatch. The TV I am using is a electronic evidence. The tie I am wearing is a electronic evidence if it has a spy camera. You know, Internet of Things. So now deepfake is there. Everything. So many electronic evidence are there. Now what happens, a new type of electronic evidence comes tomorrow. Now can you tell that no, the new type of electronic evidence is not included in the Bharatiya Sakshi Adhinayam, hence it is not admissible. Can I tell that one? No. That's why they added the word nothing. That means to say that even a new type of electronic or digital or electronic gadget comes into the market tomorrow, then it is admissible. Way back 15, 20 years back, we were using floppy disks. Are we using it now? No. Floppy disk gone. Even the FSLs does not have the facility to test that one. Maybe outdated, our pen drives may be outdated. FAT system has been outdated. New came, deepfake came, deepfake video came, new software came. Now they are all admissible because of the section 61. Please make note of the section 61. That is the admissible electronic or the digital record under the section 61A, that is the newly added. Now there is no confusion, there is no court case, electronic and digital records are the definition under the document. Okay. Next, landmark case on the electronic evidence. I will not go into this is Thomas Bruno versus State of UP. This is relating to CCTV camera. I think in the terrorist case it has been added by morning or yesterday. One of the other faculty. It is relating to CCTV footage. I will tell you in a short while. 3 Italians came to Varanasi, Uttar Pradesh, checked into the hotel. Out of the 3, 1 was killed in the hotel. Now, based on the circumstantial evidence, the Sessions Court took up the view that these 2 Italians killed the 3rd one. Okay? High Court. Yes, confirmed it because you know, Sessions Judge can give a death sentence on the conformity by the division bench of the High Court. Matter went up to the Supreme Court. Supreme Court set aside the lower court order. It says that the important piece of evidence in this murder case is one of the electronic evidence, that is the CCTV footage that was put in the hotel. Now, what are the reasons that the police did not collect that CCTV footage? No footage, CCTV footage collected. That is the important piece of electronic evidence. Hence, the death penalty was set aside. A landmark case in Thomas Bruno case. Okay? I will not go into the facts. Again, I told everything. Decision, reasoning, and all those things. This anyway, the PPT will be available for you all people. You can later look at this one. Footage, Honorable Supreme Court. And the court observed the CCTV footage was not collected due to the fault of the investigating agency. Isn't it? Okay, court, same was not produced. Their conviction order was set aside. Okay, next. Next, electronic evidence, earlier section 65 is 60, now it is under section 62, 63. Now, Information Technology Act, documentary evidence, contents of electronic evidence, okay, primary and secondary evidence, again, basic things. Contents of electronic records may be proved, admissibility of electronic records earlier, now another thing. That was there in the section 65. Now, what are the conditions for a computer to get electronic evidence? First says, used regularly. What does it mean? Mobile is there. I used it for 2 years. Then discontinued, it was battery down, everything down for 4 years. Later on, I used it for the 5th year. Now, whether was it used regularly? No. That means to say that any electronic, this one gadget should have been used regularly unless and until some brokerage happened in the between and it was legally found out. Then information regularly fed. Again the same thing. Anybody? Okay. For example, the information regularly fed. You might have seen the companies. You might have seen the office. For example, if we go to the banking sector, I will produce the check. Isn't it? I will produce the check. What the first cashier will see? He will check whether my signature on the check tallies with the signature in the computer system. Because these days it is a truncated check. It will not go to the collection branch. Then it will go to the another cashier, another person. They will check whether amount is there. Then it will go to the another this one. They will check whether the check is already proper or not. Then it will go to the pass. Isn't it? So the information has been properly fed. Even if you go to the bank and open an account, you give the account this one, you will fill something, then it will go to another, then it will go to another. So it was regularly fed. Isn't it? Regularly fed. Computer was operating properly. As I told, computer was operating properly. Some virus attack was there. For example, sometimes in the laptops, you will get a very greenish kind of a thing when the computer is broken down. During that time, you collected evidence. Do you think that the computer was operated properly that time? No. Then information fed in ordinary course of activities. Very important. Now, I will give a very unique kind of a situation. A document as prepared by the judge office. Judge office. Now, with an intention mind, what I do? I broke into the judge's house or judge's office in the midnight and I put some of the information. I know that the morning the computer operator is coming to take out the printout. Okay? I put it something which I needed. Whatever it may be. Morning the computer operator came, he provided and he gave this one. Now do you think that the ordinary course of action activity was there? No, it was not there. Isn't it? Next, functions performed by combination of computers. What does it mean? WAN, LAN, wide area network, local area network. There is a combination of computers. You might have seen computers based on bus, in a tree manner, parallel, series connection. Different computers. Now, different computers means what? For example, here only I can give the example.
Ma'am, announcement Hyundai Grand i10, dark grey color, MN01AG 1950. Yaubira ko yaubra. Si gate ki wang muda khamamba. I guy number of the hijara ke Grand i10 Hyundai gi MN01AG 1950. Gate ki opposite khamamba. Thank you.
Okay. Now, combination of computers, different computers. Now tell me, this PPT, I made it in my laptop. Then I transferred via Bluetooth to my mobile. Mobile is also a computer system. Then from mobile system, I transferred it via WhatsApp to one of the assistants here, one of the officer here. From WhatsApp, it has come to this computer. That is whatever the laptops are there. Now see, that has been series of computers used. Different combination in succession. Different tree, bus, area, what all the combinations. than in any other manner. Okay, these are the things. Cases: Anwar versus P.K. Bashir, Arjun Pandit Rao Kotkar case. I already explained these case laws. Later, please go through with these case laws, especially on the electronic and the digital, this one. Just you can mention the name of the case laws: Anwar P.K., PV versus P.K. Bashir, and Arjun Pandit versus Arjun Pandit and Kailash case. Okay. Next, 62, contents remain same. 63, yeah, 63, electronic record, computer or any communication device. See, everything remains the same. Communication device has been added. Like that, the phone, smartphone, everything. The communication device has been added in section 63. Deem it to be also a document. Electronic record, printed on paper, stored, recorded or copied, optical, magnetic, semiconductor memory. Obviously, this semiconductor memory is also a new word added. So section 63, two things have been added. One is the semiconductor memory and another one is the communication device. Along with the computer, they are added. Okay, for the sake of electronic device. Otherwise, stored, record, copied in any electronic form shall deem it to be a document. Apart from that one, section 61 also says that paper record, which was not found in the earlier. What does it mean? It means, for example, I found a mobile. There the boy and girl have chatted in the WhatsApp, whatever it may be. Or a photograph. I took a photograph or chat in my paper, xeroxed or photocopy. Now that is called as a paper record. Isn't it? Paper record. Now that acquires the concept of primary evidence. That is equal to a electronic or the digital evidence, and it is a primary evidence. Please make sure, because our officers, police officers, they cannot produce the mobile to the court. What they do? Sir, these are the conversation between the accused and the victim. What I do? Whole WhatsApp messages, I will just put it in the paper and produce to the court. Whether it is admissible? Correct. It is admissible. Okay. It is not downloaded or anything as such. Drone as a communication device. So I will not go into the details. I have list out what all the electronic digital gadgets and where this one is there. So this is the one thing. Conditions of computer output, computer resource, communication devices, email, phone, etc. in standalone mode. Standalone mode means what? This computer is standalone, which is not attached to anywhere or only one device. Computer system, computer network. Now, what is a computer system? What is a computer network? The definition is there in the Information Technology Act. Please go through the Information Technology Act. You will find the proper definition for all these things. Computer resource enabling information creation or providing information processing or storage. Now, last one is through an intermediary. What is an intermediary? ISP, TSP. Internet service provider, telephonic services provider or intermediaries. That's why please go through the intermediaries guidelines of 2021 by the MeitY, Minister of Electronics and Information Technology, which says that all the telephone companies has to preserve the call data record for how many days? 180 days. Now it is 180 days. Up to 180 days, they have to keep the record of all the things, even the CCTV footage also. All the things in the companies had to keep the record for 180 days. Okay. 63.4, certificate along with electronic record. 63.4 is earlier section 65. Now what are the differences? 65B, 1 certificate. 63.4, 2 certificates. 65B, certificate to be given by the owner or the controller of the data. I give the example of DC office. She is not the owner of that computer. No. Owner still who lies with the Deputy Commissioner's office. But she is the controller of the data. Got my point? Okay. Now, whereas in 63.4, 2 certificates. Owner or the controller of the data along with the expert, this one. Expert as said by in the earlier session also, SHO or a senior officer or a forensic expert. Or as stated in 79A, expert that has to be notified by the state government. Then if a person in charge of the computer or communication and an expert that retrieves the electronic record. So there are 2-part certificates now. Another difference is that earlier in section 65B, there was no clear-cut format. Only you have to mention that, yes, the computer was performed regularly, fed in the ordinary course of activities, it was not broken in the middle. All these undertakings used to be given in the 65B certificate. But now, there is a fixed format for given for these 2 certificates. I will show you the certificates, 63.4, 2 certificates. That is called Form 1 and Form 2. Okay. So, Part A certificate I already filled by the party who owns, manages or maintains the computer device from which the electronic record is retrieved. Part B of the certificate should be filled by an expert who retrieves the electronic record from the device. Okay. Sometimes it so happen that, for example, a CCTV footage is there in the traffic light. I will give one example. There is a traffic constable who is manning that there. The CCTV captures one through ANPR, automated number plate recognition of an accused vehicle. Now CCTV footage. Can you take the whole CCTV footage to the court? No. Although section 57 primary evidence says that as far as possible take the primary evidence to the court. But in more situations the primary evidence cannot be taken. For example, CCTV that has been put to the whole campus, can I take to the court? No. For example, a crime happened means for 5 minutes means on this day means I will take out that one, download it and produce to the court. IRCTC or SBI bank hacked. Can I take the whole this one? No. So that's why in the traffic junction, in the case of junction, whether the constable is entitled to give the CCTV footage certificate? No. Then who has to give the CCTV footage section 63 certificate for the crime happened near the traffic junction? The command and the control center. Please make sure, that's why I am telling proper custody. Although the traffic person was placed in the traffic junction, it is his duty. Some crime happened. No. It is the command and the control center who controls the data. Okay? Now, currently due to lack of format, but now there is a particular format. Okay? Entire computer never work on original hash value hack into IRCTC. So I will just dealt with hash value. Hash value is the digital footprint of any file or folder. Simple. Digital. Like I walk, I put a footprint. Like whenever I create a document or a folder in a computer, it creates a hash value. Now two questions. I typed a document called Manipur Legal and put it in F drive of my computer. Got it? And I copy it and paste it to my desktop. Now, whether the hash value changes. Whether the hash value changes? How many of you say the hash value changes? I take the file cut the file from F file or copy it and put it in my desktop. Whether the hash value changes? Hash value changes? No. Why no? Why yes? Why? First we shall go with why yes, hash value changes.
No, unless otherwise the file will be changed, then hash value will be changed.
Unless?
Otherwise no change.
Can you repeat?
No, unless otherwise there is any correction or modification in the file, no hash hash value will be changed.
So your answer is that the hash value doesn't change in this case?
Yes.
From F drive to desktop?
Yes.
Yeah, you have any other answer? Sir, you told that no hash value changes. Why?
Sir, we have changed the place now. So
The path changes. The path changes, the hash value doesn't change. Because hash value is related only with the content of the folder. Got my point? Okay. I will give another example. In the F drive, it is called as Manipur legal. I copy it, put it in my desktop, and I gone and right click, rename it called Manipur Judicial. Now tell me whether the hash value changes. Yeah. So hash value doesn't change. What about you?
It will change.
It will change. Why it changes?
Because the file name has been changed.
Okay.
Modified.
What about you, sir? Now we are correct. That is the answer. Correction for you. The hash value doesn't change by renaming the file of the folder or the document. Please make sure. Hash value doesn't change by rename or this one. Isn't it? In this case also hash value doesn't change. Okay. Third. Manipur legal, my folder is there in the F drive. Took it, copied it to the desktop, gone into the content, add letter A, then deleted A. Practically no change. Now whether the hash value changes. What is the answer? Why changes? Content on a whole it has been changed. On a whole it might not have been changed. Who says no, the hash value doesn't change? Anyone? The answer here is hash value changes. Because the moment you put a fresh hash value came. The moment you deleted the same a fresh hash value came. Because the hash value is not reversible. Got my point? That means based on the hash value, you cannot retrieve back the same file. There is no definite sequence in this one. Remember all these three situations, especially with the hash value, so that the judges and the prosecutors will not get this one. Okay? Now, another fourth situation. This was asked by one of the judges in Assam Judicial Academy. A bail petition has come and there was a question of one CCTV footage. Crime happened and CCTV footage came into the judge madam. Now judge madam want to see the contents of the data. Got my point? That was the original piece of evidence forwarded by the forensic through the police messenger, come to the court. The bail petition came. Madam want to see whether crime happened or not. She asked me, sir, can I see the file in my room, in my judge room, put it in my laptop and see the contents? Now, what is the correct thing? Whether she can, yes, she can see, as long as she does not change the file. No, she cannot see it unless and until it comes for the admission stage in the evidence, and when both the parties are this one. What is this one? She can see. Because she doesn't change anything. Huh? Yeah, that is another question, but it has been forwarded by the court. Okay, she doesn't change anything. She just want to see it. As already stated, just seeing the file, copying the file doesn't change the hash value. Now what is the problem? If the judge madam sees and sees the folder, hash value doesn't change, but what changes? The metadata, the properties of the file folder change. If you right click the file, if the madam see the CCTV footage and later if you see the right click, it will say last access date will be shown the date when madam sees it on her computer, which the defense will certainly object. Ah, my lord, somebody in between have been interrupted. Although there is no change, isn't it? So what the best madam can see, madam can do, she can ask for another copy from the forensic, or there is a duplicate copy from the police. Now that's why there are two methods how to collect an electronic and digital evidence. Please bear in mind, this is followed in the entire country. Scene of crime, I found a laptop. What you will have to see, the police officers, when I see the scene of crime and a laptop is found, what I should have to see first? What are the procedure to collect the electronic and digital evidence? Videography, then before seizing, photography. Why photography is required? Because you need to mention the exact model, serial number, color of the laptop. There may be Dell laptops of same color like anything. Number one. Number two, photography, how it has to be taken. Police officers, please open your thinking this one.
With the scale measures.
Huh?
With the scale. Scale.
Scan.
No, measurement with the scale.
With a scale, okay, that is there. But what is the correct ideal to take the photograph of that, this one?
3 ways.
Take the laptop photography with a reference picture. The same thing followed in collection of the evidence. For example, a blood has been there in the road. You take the close picture, but at the same time, you take the blood pattern with a reference point, proving that the blood sample was found there only. Like that, you have to prove that the Dell laptop or whatever laptop has been found in the same place with a permanent object. That is, oh, you take the photograph, serial number, mention everything. Now, the laptop is on. Now, what to do? What is the sequence you collect the electronic digital evidence? Police officers, please. How you will collect? Live? If it is on, you pull the cord. You will not shut down. I will come to that one. Before that, what you do? What are the two types of memories found in laptop? Volatile, hard disk. First, you have to see what are the temporary files running. That is found on the toolbar. So that is also called as RAM, random access memory. So using a kit called forensic toolkit, FTK, what you do, you collect the RAM first. Why we collect the RAM first? Anybody? Correct. RAM is called as temporary memory. The moment you close the laptop or shut down the laptop, the RAM memory is gone. That's why stored in multiple storages. That's why you might have seen, you are working on a computer, there is a document, light gone. But resurfaces and asks whether you want to save it. Whether the file has been earlier saved it in the hard disk? No. It was saved in the RAM. Isn't it? That's why always collect the RAM data first. RAM data means temporary data. See what are the website he has open, what are the files he has open, what is the RAM that is open, what is the cookies there. You collect that one. RAM. So before collecting to the computer, to the hard disk, which one you use? Police officers? What measure, one of equipment you use in the between? Right blocker. Or you can use FTK. FTK, forensic toolkit, is itself this one. FTK is not a hardware. It is a software. It is an open source intelligence. You can download it for free. Please note down, forensic toolkit, FTK. It is useful to collect the electronic and the digital data. Okay. You collected the RAM data first. Then what to collect next? After RAM? Hard disk. So collect the hard disk with the write blocker, then download everything. Now there are two options to collect this hard disk. What are the two ways of making the collecting the data? What are the two ways? Both the ways you are using the write blocker. Imaging. Another one? Cloning. Have you heard this one? Police officers. So silent, why? Imaging and cloning. There are two methods of getting the exact data of the original hard disk. Now what is the difference? Tell me what is the difference between imaging and cloning, and what method the police officers has to use? Okay, imaging. Why imaging? First, what is the difference between imaging and cloning? While collecting the electronic and the digital records, digital evidence, both are the same copies, but imaging means it will give the data as it is. It will not give the deleted data. Sorry, it will give the deleted data. Whereas the cloned image means exactly what it is as of now, it will give. That is called as clone. Exact identical bit by bit copy is called as cloned image, where the deleted files cannot be found. That is called as a cloned image. Whereas imaged copy means you still get the deleted files. So whatever the files that have been deleted, photos, videos that has been deleted from this computer, I can get while using the imaged copy. Number one difference. Now, as a police officer, which one I will prefer, whether image or cloned? Imaging. Because I get the deleted. Who knows? Accused has used many things, he has seen videos, everything, and he might have deleted it. But I want to recover it. Second, but which is easier to use? Which is easier to analyze the data? Whether cloned copy or a imaged copy. But easier to analyze is the cloned copy. Because to analyze the data in the imaged copy, you need extra software. Isn't it? You need an extra software to read the data that has been collected under imaged copy. Whereas in cloned copy, you need not need. You can directly access this one. So this is the difference between image and clone. Okay, now I am collecting the hard disk drive. I am using the write blocker. As you know, I prefer to use which method? Image method or clone method? Image method. Image, this one. That means to say that I had to use a original hard disk. If it is of 900 TB, I use the 1 TB. 900 GB means 1 big GB. Again, police officers ka galti hai. I have seen many of this one. What they do? Police officers, mahan baalog. They took the accused mobile. They see that there is still some talk time. They just use the talk time. Isn't it? They use it to take their own photographs. Pen drive has been seized in the case. What they do? They put their own videos and photos. This has been made by our police officers. So don't do all these things. So whenever you are getting the copy of the image copy of this one, use the fresh TB hard disk only. Or if the earlier hard disk if you want to use, make sure that not shift delete. It is called as wiping. Wiping the memory. For example, there is a hard disk, 500 GB. I want to entirely wipe it out, then only I can use it as a fresh one. Otherwise, don't use it. Okay? You copied image copy. Now, there are two methods to send it. In Kerala, Tamil Nadu, what they do, as soon as the original hard disk is taken, they send it to the court. Correct. Because after FIR, every property including the accused document belongs to whom? Court. So they send it to the court. The court will send it to the CDAC. From there, they will make 2 copies. One for the IO copy, one for the CDAC to analyze, and the original copy they send back to the court. This method is also correct. The problem is that from court to CDAC, CDAC to court, obviously the police officer has to go as a messenger and take it. And the problem of chain of custody. Yesterday madam was telling chain of custody. Another way is that we were using most of the times is that scene of crime, right blocker, take all the contents into the empty hard disk. That empty hard disk where you collect the image copy, you keep it. That is used for investigation purpose. And the original hard disk, you send it to where? FSL. Straight away with 2 blank copies again. Why 2 blank copies again? Yeah, the whatever you are copied from the scene of crime, that is only a copy for your investigation. That is not the copy given by FSL. So the official copy should be the one given by the FSL. That's why take 2 blank copies, blank hard disk, send the original along with the FSL. They make a imaging. They send the original one to the court through a police, and 1 copy they will give to the police, and 1 copy will be with the FSL for their report. Now the IO will have 2 copies. Why 2 copies? The first 1 copy is to be utilized till the FSL sends the formal copy. It takes time because imaging 500 GB hard disk means how many hours it will take? Any idea? No. It takes many days also. It depends upon this one. It takes many days also. That's why the IO first take a copy of himself using the right blocker. Then officially he gets a copy from the FSL. Both the methods are proper provided you maintained a proper chain of custody. There was one case that happened in front of our eyes. We sent electronic hard disk through packed to the FSL director, Meti in fact, Meti director. Our constable took the copy, he gone there, the gate man stopped him, he said, I want to deliver this to the director by name. Director has not yet come. What our constable did, he handed over to the gate man. When the director come, you handed over to the director. And he simply come. Now in the court, the defense asked the director, sir, whom has delivered you this electronic evidence? He told, my watchman. My watchman XYZ has given this one. Whether the watchman name is there in the chain of custody? No. Case gone. Silly mistakes we police officers are doing. And defense taking the advantage of this one. So please don't make the mistakes on the chain of custody also. Okay. So these are the things that I would like to tell about the hashing, collection of the electronic and the digital records. Now I will quickly, already with 3:30, we have to go for the next class also. So cryptocurrency, I have dealt very well how to collect electronic and digital records in all the case laws, like earlier CCTV footage, cryptocurrency, computer, off condition, on condition, what to do, how to collect, on condition. So just have a cursory look. RAM, FTK, Belka software, these are the, this one, hibernate position saved automatically. Okay, mobile phones, off condition, on condition, IMEI number, mobile to Wi-Fi. Another thing, how you collect the mobile phones from the scene of crime? By what means you transport them? by a Faraday bag. By a Faraday bag. Why mobile phones are kept in Faraday bag from the scene of crime?
The data should not be damaged.
Okay. When you put a mobile into the Faraday bag, you need not to switch off. The moment it put it in the Faraday bag, all incoming, outgoing, all its connection to the nearest network will be banned. Wi-Fi, Bluetooth, everything will be banned. Another thing, you can put some of the devices even in aluminum foil also. Aluminum foil is something like a foil that has been used to pack the food material. They are also called as anti-static bags. That prevents any magnetic communication, okay? So Faraday bag and all those things have the pen drive, calculate the hash value, hardware tools, virus if the pen drive you obtained is having a virus, will you scan it? Original evidence, pen drive has a virus. Will you scan it? Don't scan. Okay. Properties, CCTV evidences. Okay, I will just quickly, NVR. NVR means network video recorder, DVR, digital video recorder, especially for the CCTV footages. Hard disk, CCTV, FSL, hard disk, scene of crime, original evidence. So it is a huge PPT. Static bags, I have told about the static bags, anti-static bags, SIM card, smart gadgets, hash value, WhatsApp, Android, chip-off method. Have you heard about the method called chip-off method? Chip-off method. Chip-off method means if the battery cannot be replaced from the original mobile, what to do? To read the memory, in forensic lab they use the chip-off method. That means they solder along the edges of the mobile, they break open the mobile, and after the battery there will be a small motherboard. Along the edges of the motherboard, again they put a soldering and take the motherboard out of the battery, out of the mobile, to read the contents of the phone, internal memory of the phone. That is called as chip-off method. Not found in any this one. This is well practiced in National Cybercrime Forensic Laboratory under the I4C, Indian Cybercrime Coordination Center, that is there next to our institute. CDTI Hyderabad, we have that capacity, chip-off method. In the CFL, National Cyber Forensic Laboratory, that method is there. Many states also have that method now. Correct procedure of chain of custody, I will not go. Cloud forensics. Okay, these are the two certificates under section 63(4). One by the owner control, to be filled by the party, then to be filled by the expert. These are the two certificates under section 63(4). So there I end the first session, that is regarding the electronic and the digital records and the evidence under the new Bharatiya Sakshya Adhiniyam. Okay? Okay. Now, shall we go for the next BNSS? Continue. We don't have much time. Can you upload the next PPT, please? BNSS. Yes. Bharatiya Nagarik Suraksha Sanhita. Again, a huge presentation. I will go only the important things, very, very important things. Okay? So, as you know, audio, video, electronic means bail, bail bond, bail without surety, bail bond with surety, and look at the last sentence. The definition of the victim. Now the accused need not to be formally charged. What does it mean? For example, in his murder, proceeds of the crime taken from the victim. Now you need not for the investigation to be over or the trial to be over. In the midway only, those properties can be given back to the victim. That's why it is a victim-centric clause. So, the accused need not to be formally charged to call a victim. That means to say that he can get the whatever the properties or anything in the midway of the investigation or the trial. Just. Okay. So investigation, now the sequence of the magistrates you know. Only thing, assistant session judge is not there. Metropolitan, assistant metropolitan magistrates, the nomenclature has been changed. Now both in the metropolitan as well as in the rural, there will be same set of magistrates. Chief Judicial Magistrate, JMFC or JMSC. Of course, some states have additional Chief Judicial Magistrate, additional or whatever it may be. That depends upon the state. But only thing, assistant session judge is not there. So the cases will be either transferred to the CJM or the additional CJM or to the sessions court or the additional sessions court. Okay. Now what are the powers? Obviously, you know, JMSC less than 1 year, 1 to 3 years FC, first class, 3 to 7 years is the CJM, above 7 years is the session judge. Whatever the penal provisions, earlier 5,000 to 10,000 is JMSC, 10,000 to 50,000 is the JMFC, above 50,000 is the CJM. Obviously, CJM can, the session judge can give any sentence, isn't it? Another thing, earlier the judges, unless and until written, the sentences used to run consecutively, one after the other. It is called by default rule. But now, both the magistrates and the judges in multiple offences has to compulsorily write whether the sentences run concurrently or consecutively. Okay? Okay. Next. On basis of the executive magistrate, now a police officer not below the rank of a superintendent of police can be designated as special executive magistrate. That means to say that, for example, there is a range headed by a DIG or an IG. Now, as like executive magistrates, now a police officer can also be called as a special executive magistrate. Why? Because there are some provisions like 107, 110, 112, 116, 117, 151 preventive detention measures. Now, earlier, the rural SPs used to ask for the DC office, but need not to ask now. Because the state government can declare them as special executive magistrate. Okay. So if police officers are there, please ensure that Manipur government has, I think they might have already passed the order regarding special executive magistrate. Next, I will not go. Public prosecutor. See, Delhi has a unique situation. Legislative Assembly, High Court, public prosecutors are appointed by the LG. Not the Home Department, not the Delhi government. That's why a lot of confusion. But now, High Court of Delhi, public prosecutors are appointed by whom? The central government. Okay. Next, 14 days notice. For example, if there is a no PP or a assistant PP for a particular case, but it is a time-bound case, now the district magistrate can appoint a assistant public prosecutor for that case or for that period, giving a 14 days notice to the state government for the sake of speedy justice. Next, Directorate of Prosecution. You see, investigation plus prosecution. But prosecution was not uniform in the entire country. For example, Madhya Pradesh, Directorate of Prosecution was an IPS officer. Uttarakhand, IPS officer. In Telangana, Andhra Pradesh, senior PP used to get elevated as a assistant director or joint director and all those things, and Directorate of Prosecution. But now, pan-India uniformity. There will be a Directorate of Prosecution. Okay. Next, Deputy Directorate of Prosecution. And this law has created one more post called Assistant Directorate of Prosecution. Okay. What is the eligibility? Both the Directorate of Prosecution and Deputy Director should have worked as a session judge or 15 years as advocate. Okay. For Assistant Directorate, he or she should have worked as 7 years as advocate or as JMFC. Okay. Now what are the powers? Directorate of Prosecution can give his opinion on appeals to be filed where the punishment is more than 10 years. Deputy Director can supervise, monitor the cases where the punishment is 7 years to 10 years. Less than 7 years, it is the Assistant Directorate of Prosecution. This doesn't mean police officers has to compulsorily send their case study, case diaries, charge sheet to these officers. Because these three officers work under the State Home Department. Only in those cases where the state feels, oh, this is a 10 years more case, let us go for appeal, revision, then these officers come into the picture. Okay, section 18, 19, 20 deals with the Directorate of Prosecution. Okay, I have told all these things. In short, yes, already we see the magistrates concurrently and all those things. Yes, it has been provided. No arrest shall be made in case of an offence less than 3 years, is infirm, or 60 years without permission of the Deputy Superintendent of Police. Any accused to be arrested, less than 3 years punishment, now is infirm. Infirm means physically and mentally not so sound. And above 60 years of age, DSP's permission has to be required. Now second thing, whether oral permission? No. Because SOPs of many states have told that it is written permission. Written permission of the DSP has to be taken to this one. Although it is not written in the book, it is prescribed as it is written permission. Then, protected witness, person above 60 years of age or a person with acute illness will require to attend in any other where they reside. We will come to that one again. Remember DK Basu versus State of West Bengal. It says the grounds of arrest has to be conveyed to the arrested person. Inform the friend or the relative of the arrested person as identified by the arrested person. But problem comes when I am arresting a person out of my jurisdiction. He may tell or he may not tell. I may not found his relative or friend. So, earlier the control room was there. Along with the control room, now it says there should be assistant sub-inspector. Sorry, yesterday madam said it is sub-inspector. No, it is not sub-inspector. Not below the rank of sub. It is assistant sub-inspector. Yesterday in our PPT, please ask to change that one. It is assistant sub-inspector. Assistant sub-inspector should be there in every police station, who is called as a designated police officer. Whenever arrest has been made, that designated police officer has to be informed, and that designated police officer will in fact inform the friend or the relative as identified by this arrested person. That's why in Telangana what they are doing, they are informing to the designated police officer. They are also giving an intimation notice to the friend or the relative of the arrested person. But this relative or the friend is not at all taking that intimation notice. The moment there is a notice from the police, they told, no, I will not receive it. They think something peculiar. Oh, if I receive this, then tomorrow I have to go to the court. Even our police are telling, you have nothing to do with this one. This is only an intimation notice under the new law. Please receive it. No. They are so scary people to receive any notice kind of a thing. That's why we suggested that delete the word called notice. The moment something comes to the notice to the mind of people, they become scary. Just mention only intimation under the BNSS, so and so section. And give it to the friend or the relative in written. Okay? And also in digital means. That means so and such person has been arrested, you can put it in the SP office website also. Next, 6 hours, private arrest. Just now our Secretary Sir was telling, in Manipur, in some of the drug cases, people might hand over the drug peddlers to the police. Normally not done. As per law, 3 persons can make arrest. Police officer, cognizable offense. Second is magistrate, when a cognizable offense has been made in front of him. Third one is the responsible citizen of our country. When a cognizable offense has been made, he can also arrest that person and hand over to the neither to the nearest police station or the nearest available police officer. But there was no timeline in what time that police or that civilian has to produce to the nearest. That sometimes become illegal custody or unwarranted custody. For example, if I had to settle the scores, I got arrested from a citizen and put him in for unwarranted this one, thinking that 24 hours. And maybe in our neighboring state, Assam, it is not so uncommon of the private arrest, let me tell you, especially in India-Bangladesh border, especially with the cattle thieves. The village people, they caught hold of the cattle thieves and hand out to the police. That is quite existence in India-Bangladesh border. So now 6 hours time is there. What is the implication? Now whether the police have over and above 6 hours, 24 hours? No. Now the police officer's power to produce the arrested person before the magistrate now reduces by the time that has been taken by the private person to cause arrest. Got my point? For example, the private person got 5 hours, excluding the time taken for journey, to cause arrest and produce before the nearest police. Now, how much time I have now as a police officer? 19 hours. 24 minus of 5. Second thing, whether he will do the Caesar memo arrest of civil person? No. Whether he will take him to the medical? No. Whether he will take it to the magistrate? No. Everything else has to be done by the police officer only. Third thing, very important, in earlier CRPC, when a civil person hand over the person, the arrested person, and the police, it was called as re-arrest. But now, since the arrest has been made by the citizen, now it is only shall take into custody. Mind you, these are the words changed. There is no re-arrest, but only shall take into custody. Shall take into custody. Another thing, very important. Please.
In that case, what about the arrest memo, sir?
Police officer has to make. Police officer has to make arrest memo. Remember the Sunil Batra case and the handcuff case. Remember the parliament attack case, where some of the advocates gone to the Supreme Court and the various lower courts also, seeking that let the police take the permission of the court even to handcuff so-called notorious criminals. Isn't it? So there was ambiguity in which cases handcuff has to be done while arresting or taking into the police, to the courtroom. But now it is simple. 3 grounds. First, nature and gravity of the offense. Whether he is a notorious criminal, like in Nigerian frauds and all those things, they are very, very well built. They can easily overpower some of our constables or something. Nature and gravity of the offense. Repeated offender. Third, if he has escaped from the custody earlier, either judicial or police custody. In these cases and in these offenses, the police officer can handcuff. What are the offenses? As I told, organized crime. Section 111. Not 112. Section 112 BNS is petty organized crime. It refers only for organized crime. Then Terrorist Act. What is the section? 113. Next, drug related crime, NDPS cases, illegal possession of arms and ammunition, Arms Act, murder. What is the new section? 103. Rape, section in BNS 60, 63 and 64. Rape. Sexual offences against children. Which chapter in BNS? Chapter 5. Now sexual offences against women and children are clubbed in together and come in chapter 5. Okay. Next, acid attack, counterfeiting of coins and currency notes, as per the 1976 Act. Now it is deleted from the BNS. Then human trafficking, anti-human trafficking, and whether human trafficking is one of the offense under NIA. About to be person, carefully see the section, carefully see my PPT, there is a word called about to the person. That means to say that any offensive weapon that is there with the pockets or with the custody of the person, now immediately seize the weapon. Now what is the idea behind this? Because when I am searching a person, accused person, if I am so very legally bound, means what I will do? I will offer my body search first. Then he has a chaku, he put a chaku to me only. Or there are some notorious criminals. What they do? They hide some blades here and there. Either they tore off the police officer or they tore themselves. They make damage for themselves and put the blame on the police. Sir, देखिए, ये police officer है ना, ये अरेस्ट करते समय क्या किया? ह्यूमन राइट्स वायलेशन किया, isn't it? So immediate seizure of the weapon while causing arrest. Okay, medical practitioner shall without delay. The word shall has been added. There are two ways now: medico-legal cases or medical examination report. In ordinary cases, shall without delay, you have to give the medico-legal report. But in the rape cases, it is 7 days. There are 35 timelines prescribed in the Bharatiya Nagarik Suraksha Sanhita. 35 for speedy justice. I will come one by one. One of them is that within 7 days, 6 hours is also one of the timeline. Within 7 days, this shall without delay. Another thing, additional medical examination. If the doctor says yes, I will give one peculiar case that happened, that is Telangana. A girl came. She says that I am getting stomach pain, please examine. Doctor says you are pregnant. Are you married? Girl says, yes, I am married. Ask her parents, who is her husband, whether she married. Parents say, no. Because she has some friendship or something. Now she came after 2-3 months. Now how to find out? Now the doctor prescribed for additional medical examination to find this one. Now those poor villagers, they put a blame on the doctor itself. Why you are asking for medical examination for her? No, I want to test her and what is the thing and all those things. I want to see that one. That is my duty. Even MLA called. This is a kind of a sometime politics. Because they were also asking what is the status, what is your position to ask for a medical examination to the doctor itself. But now it is not there. If the doctor says no, I want to conduct additional medical examination, nobody can object. Now another thing happens also in some of the rape cases or what happened. Boy and girl get into a relationship. Girl get into a pregnancy. She put a complaint. Now if then both the side comes, then they will say, sir, don't register, no investigation, nothing. If they are minor, we will ensure that they will get married when they are get into major, or if they are major, we will get married. Don't put up anything. Now what the girl says, okay, she will not cooperate with the investigation. The case becomes weak, thinking that the boy will get married to her. Having seen that the girl is not cooperating or retracting from the earlier statement, this boy later refuses to marry her. These are the cases happening now. Reality. If you ask the doctors, they are telling these things. Now where the police go? So these kind of situations also exist in the society. Okay. Additional medical examination. Next, 63, summons. Earlier summons can be, it says that adult male member of the family. Above 18 years, male member, family definition you know. Servant is not considered as the family member. Because old laws, there are some communities where the woman does not come out of the house, Pardanishan women, Burqa women. That's why they kept out of the purview of issuing summons to the lady. But now things have been changed. Now the summons can be issued anybody, gender neutral. And even by electronic means, very important. Now that electronic copy should contain the proper signature and seal of the court, number one. Number two, a register has to be maintained in the court as well as in the police station for mentioning the names and addresses of all those cases where the summons has been given electronically. These are the things that has been changed in section 63, the issuing of the summons using electronic means. Okay. Next, gender, women, adult member, now already discussed. Duty on police officer, forthwith give information, ASI already discussed. And proclaimed offender. Earlier there was no proper definition. Now under section 84(4) of the Bharatiya Nagarik Suraksha Samhita, any offense which is punishable for more than 10 years, you can issue a proclamation notice. Okay, that is very much there in this one, 10 years or more. Superintendent to initiate the process of requesting assistance from the assisting state. This is called as laterogatory or investigation abroad or collecting the evidence from the assisting state. Assisting state means, or assisting nation means, or assisting country means where India has signed Mutual Legal Assistance Treaty, MLAT. According to it, any fugitive offender has gone to that country means we can extradite him. Earlier, the process was cumbersome. Take the permission of the court, write to Interpol, which is there in CBI 6th floor, then MEA, embassy, then go to foreign embassy. from foreign embassy to our embassy, from there to chief secretary or DGP or blah blah, whatever the hierarchy there in the foreign country. Many of the cases, the investigation abroad have not been this one. So we were not getting any evidence. But now SP or the Commissioner of Police can initiate this process. Okay. Attachment or forfeiture of the property belonging to a proclaimed person, proclaimed offender. Okay. Next, 105. So lot has been spoken about 105. Audio, video, electronic means and using this one. That's why the Telangana police have made a beautiful SOP. We know that the entire process of search and seizure cannot be videographed. That's why they made this one. First 1 minute. Take introduction of the parties, introduction of the independent witness, explaining, show the search warrant, offer body search. Then whatever the materials you can, this one, collect it. Signature, this one, so that it is minimal. Mind you, very important for both judges as well as officers. Now the seizure video will become a part of our final report. That is the charge sheet. It is bringing more challenges for the police officers now. Earlier, what you used to do, police officers mostly take all the documents from the scene of crime. Then where we will take it them? Go to the police station. Then segregate what is required, what is not required. Prepare the seizure memo there. Call the witness. And sometimes even the witnesses are just our neighbor chai dukan wala. Just on a funny side, you know, na? So these were things were happening, might be happening, but now it is simple. And one of the thing, very important basic thing is that, what is the basic mistake that the police officers do when go for search warrant, search places? They do not do offer body search. The moment I go for searching, first I have to offer my body search. Because it is very easy to put a pen drive here, some narcotics, and place it in the house, bedroom. And later, oh, I found this one, that one, this one. That's why there is always allegation that police have implanted the evidence. Isn't it? Now, putting end this one, now what you have to do? Compulsorily videograph the search and seizure. Having said that, it will become a part of our final report under 193. It brings more challenges. Now the lawyers, defense lawyer will open this videography and say that, sir, you know, they have not followed this procedure, they have not followed this procedure. Because in search and seizure, it says that the inmate of the house has to compulsorily accompany the searching team. Is it? Second, no human right violation should be made. Third, as far as possible, the decency and the order of the objects in the house should be kept intact. Isn't it? Now, we have to take a lot of caution while doing the videography. Whether you keep everything ready, then videograph, it is up to that one. Moreover, the videography that you make will be automatically uploaded in the eSaksha app, where you share the link of the eSaksha, that video, to the court, to the accused. So no need of worrying of taking pen drive, downloading this one, because it is a cumbersome method. Because here we have 1 or 2 police stations. In UP kind of a thing, in one district there is 30 to 45 police stations. Even if they go for one search a day, can I take go for every day? Can I go for with a fresh mobile phone? Or shall I go with a fresh pen drive every day? 45 pen drives every day. Even one police station into 30 police stations. Moreover, our search may conclude for 3-4 hours, 5 hours. Then shall I take so much of hard disk? Not practically possible. That's why eSaksha app is there. So download from that is made by the NIC, National Information Center, and use that app as early as possible and ensure that our judiciary or police department are good in using, sharing, and also the judges need to appreciate this e-Saksha app. There is another app called Shruti. Please note down. Shruti by the NCRB. That is also a good for the evidence. There is another app called E-Sankalan. That is an app created by National Crime Record Bureau, which says about the old law, about the new law. That is the new, this one. And lot of material you will get it from our own department. That is, since I am from the BPR&D. Yesterday, madam was telling, no, all SOPs, we saw this one. We have uploaded lot of SOPs, lot of e-modules, everything on the BPR&D website. Bureau of Police Research and Development. That is our organization. There you get lot of videos, lot of material on the new criminal laws. And lot of SOPs also. SOPs, yesterday madam was telling about 76 page. On the search and seizure, this one, that is from our organization only. So go and visit the website and all those things. Apart from this, please visit CDAC website, website, because there are so many online courses like Chariot, Side Train, Meg Shikshak. These are the good courses both for the police officers or judicial officers to train yourselves on cyber crimes. www.cytrain.gov.in. Cytrain, C-Y-T-R-A-I-N. Cy stands for cyber. Okay? Go to CDAC, Center for Digital and Advanced Computing. CDAC Hyderabad or CDAC Hyderabad is also there. There you find Chariot, C-H-A-R-I-O-T. There is a educational this one, where you get lot of training. Go to Meg Shikshak. Meg Shikshak under the CDAC only. There you will get again some of the course. And another one training module, training course that has been developed by BPR&D is E-Ustad. E-Ustad. U-S-T-A-D. Ustad means what? Teacher. So it is e-teacher. So there is a lot of things already available with many of the organizations. Okay, we can learn better, aram se in our office, we can learn a lot of things on cyber crimes, get training, you will get certificates. Unlike in other websites, unless and until you pass the each course, it will not end. That makes sure. Oh, I will just flip all these things. Later, I will download. No. So we have taken the practical this one, how our police officers do. Okay. So make use of these tools that are being available online, but especially by the Government of India. And there is Astra, A-S-T-R-A, Astra, by C. Center for Digital and Telecommunication. There you can find which SIM is the fake SIM and all those things. C. has nullified almost 1.5 crore kinds of SIMs across the state. Astra is also a software. Oh, okay, I'm running out of time. Okay, Astra is also a software which helps in many other things. Visitor Assistant Register, ANPR, NAFIS, and all those things. Okay. Chalo. 107, attach, forfeit any property obtained as proceeds of crime. This is what I am telling. The accused need not to be formally charged for a victim. Now, how it happened? 107. This is a brand new section, especially for the judges and the police officers. Forfeiture of the property, attachment, even during investigation. Procedure what? Take permission, SP or CP, application to court, court issue notice to the accused. Then, or whoever the property is there, ex parte order is also can be done. Proceeds of the crime can be rateably distributed to the claimants. Of course, now some questions are there. Give 60 days time to the district magistrate and rateably distribute the proceeds of the crime, even during investigation. Now what happens if Now the question is why it is sub judice, later the acquitted, later if you find that the property does not belong to the claimants, that is there. But if we go to the verbatim of this section 107, sufficient take care has been made both by the police officer as well as the judiciary in releasing this property. Next, maintenance of wives and children, parents. Parents is the new one added by the government. Now, if the parents want to claim compensation or maintenance from their children, they need not to go to the place where the children are residing. They can put up a petition here only, irrespective of where the children are staying. That is the idea behind this section. Deputy Commissioner of Police can also deal with in case of public nuisance. CRPC prohibit, now I will not go. 172, for example, if any person is refusing resistance to the bona fide directions of a police officer, arrest him 24 hours, release him, mentioning it as a petty case. Okay. Next, filing of 0 FIR and DFIR. 0 FIR, you know, beyond the jurisdiction. Earlier was also there, but it was not under statute. Now, Manipur, crime happened here, but you are traveling to Delhi. Go there, put up a FIR in any of the Delhi police station. They will send that copy to the concerned police station in Manipur. Or EFIR. Even if in Delhi, you can submit a EFIR for a case to be registered in Manipur. There the police station in the CCTNS, Crime Criminal Tracking Network System. Now NCRB is coming with the second version after this one. CCTNS 2, where these all new items are there. There you go, choose 0 FIR, mention all this one and send it to the concerned district. But only thing, CCTNS, they are not giving all the details of the police station. They are giving the districts. For example, if I had to send it to district of West Bengal, they are not, for example, in Bardwan district, what are the police stations, they are not mentioning. That is the only thing. Of course, you can send it to the SP. They will decide. Okay? 0 FIR, EFIR, there is no word mentioned called 0 FIR or EFIR. In the first sentence, 173, it says, irrespective of the area. Have you observed it? That says that is 0 FIR. Complaint even by electronic communication. That means EFIR. 173.1, the substance of the complaint has to be mentioned in the particular report, particular book referred by the state government. These are the words there. There it means GD. Whereas in 173 it says, a copy of the information that has been recorded under 173.1 has to be given to the victim, to the complaint. There it means FIR. Don't make confusion. 173, 0 FIR and EFIR. Okay? Okay. Cognizable offense, commission of this one not signed, 3 days and all those things. Yesterday I told the procedure. If not come with 3 days, if later they come, then what is the procedure? First you treat it as information, send the police officer verification report, then you can register an FIR. This is not new. Earlier also dial 100 was there. Electronic communication. So in a way it is not such novel. Okay. SP, now another thing. Police station did not register case. Law says for police station you can send electronically. But for police SP, you have to send it by either by post and a written complaint only. Now question asked, why written complaint only? Because the SP has to make sure that there is a person behind the complaint. Second thing, you can send it by post. That also means that the person can go and meet the SP in person and give the complaint. Okay. Now, if SP also does not register a cognizable case, then that person has to approach the magistrate with an affidavit. Why affidavit? Otherwise, falsely he can implead. He can make an affidavit that I have met SHO, SP, all these things, and cognizable offense. And now the magistrate can ask an explanation from the SP. Why you did not register a case? So that is all there. Okay. Now complainant, victim, accused all get the copy of the FIR. Then preliminary inquiry, 3 years but less than 7 years, cognizable offense. Now take the permission not below the DSP, again return permission and go for a preliminary inquiry. Okay. Making application even if FIR is not registered. Okay. Non-cog offenses, yes. NCR cases, earlier no FIR, but dispose of the case. But now, even in non-cog cases, 15 days once, all the non-cognizable offenses report has to be sent to the magistrate. Once in 15 days. Why? Because the magistrate can see whether there was a chance of registering FIR in the police station, but the police did not act. They just sum up the clause by making it as NCR. That's why. Especially in matrimonial cases, husband and wife jagda karte hai, police station aata hai, then police will, okay, both will come and they just solve the matter. What happens if there is a beating by the husband to the wife? So these all cases come into the picture. Now 175(3), this is what I was mentioning in the morning. 175 allows the SP to depute DSP rank officer to conduct the investigation. Depend upon the nature and gravity of the offense. Morning I was telling in the madam's class. Then 175(3), examine application, this already I told. Protection against false and frivolous cases against the public servants. Good news for public servants. So if there is a false and frivolous cases, earlier what used to happen? Either FIR or departmental inquiry used to happen. But now, when a false or a prima facie a false or frivolous case against us has been made by a private person, then ask the officer in question to explain the assertions of the case. The word assertions is there. For example, I am controlling a mob, but I exceeded my lawful duty. I may be asked, sir, what are the circumstances that make me to this one? Also, seek a report from the superior officer. That is, if I am DIG, then ask from the IG or whoever had deputed me. Next, place of our choice in for rape victims, presence of our parents or guardian, relatives or social worker of locality, preferably by a woman police officer. Now she can choose to give her rape victim anywhere she likes. 7 years or more, any offense 7 years or more, compulsorily take the forensic team to the scene of crime for proper handling, collecting, transporting, preserving, identifying the evidence. Okay? So 7 years and above. But all states are not equipped. That's why states have given 5 years time to prepare themselves for a better forensic facility to comply with the earlier provision. Next, these people need not come to the police station even during investigation for giving their statement. Who are those? Male below 15 years, women, physically handicapped, above 60 years of age, acute illness person. These need not come to the police station to give the statement. Then, judicial magistrate whose district the offense has been registered, he is made competent to record the confession or statement. Now, this is another one. Earlier section 161, now 180. Earlier 164, now 183, confession. Now the question comes. See, what changed? In section 183, earlier, the word judicial magistrate was there. But now, in the new law, the judicial has been taken off. That raises the question whether any magistrate can conduct confession. No. You have to read section 183 with the last sentence. That is the section 3. Magistrate means only the judicial magistrate, either of the first class or the second class, where section 3 says construction of references, unless the qualifying word says magistrate means either the judicial magistrate first class or the second class. So that means to say that in section 183, anybody having the book later you see in section 183 the word judicial is not there. Whereas compared to 164 the word judicial was there. Okay, but still it means that judicial magistrate of the first class or the second class. Okay, these are some of the things this one. Next, 10 years. This is a very peculiar section where there is an option for the police officer, no option for the magistrate. Any offense punishable more than 10 years. Now the police officer can take as number of witnesses or persons to the magistrate to record the statement. The magistrate shall record. Look at the sentence. Look at the word shall. What does it mean? Here there are 10 accused people or 10 people of my case. Witnesses or whoever it may be. Now what I will choose? I will choose her, I will choose him, I will choose him. Only 3 out of 10 and produce before the magistrate. Please record their statement. Now the magistrate shall compulsorily record their statement. They cannot ask why you did not bring another 7, why you choose only 3. No. This is a very peculiar provision where in heinous cases let the prosecution build up their story. That is the idea behind this legislation. Protection victims of rape, preferably. Now, even in the court for the lady, only lady, preferably lady magistrate has to record the statement of the rape victim. Next. Registered medical practitioner, 7 days already this one. Search, case diary and audio video already we discussed. Another thing, you have to send the search report within 48 hours to the concerned magistrate. One more thing. The search report, there it is said, yesterday madam forget to spell. There it is said DM or SDM or JMFC. Okay, JMFC I agree because there is a case and you send the search report. But why DM and SDM? Earlier it was not there. Because while going for search you may found some unclaimed property or a property not involved in any of the case. In those cases obviously you have to produce to the DM. Next, custody, police custody. Already you know the 15 days police custody remains the same. But that 15 days can be taken either in whole or part by part within 40 days for a cases to be investigated in 60 days. That means cases which are punishable less than 10 years. 15 days of police custody can be taken in parts or in whole in the first 60 days for a cases to be investigated in 90 days. That means cases punishable for more than 10 years. Look at the section, this one, 15, 40, 60, less than 10 years. 15, 60 days for 90 case investigation period for the above 10 years punishment. So if you see this position, then you will not get confusion. Okay, just somewhere you can note it down for the better this one. Next, 187, detention shall be only in police station or the wherever the this one like jail or lockup. Next, 15 days otherwise. Another 187. While forwarding to the judicial custody, the earlier CRPC says otherwise than in a police custody. But now the words otherwise than in a police custody has taken off. Now the question comes whether the police custody can go more than 15 days. No. It can be taken in first 40 or 60 days, either in the whole or a part. That's why in section 187 it is clearly mentioned not more than 15 days of police custody. So need not to be this one because there are a lot of YouTube videos which are putting unnecessary confusion among the people of our country. Okay. Next, such custody and such custody may be concluded as police custody. This is another thing, especially for the UAPA Act, this one. See now, for beyond transnational crimes, 3 things. One, first the word India has been taken off from the Bharatiya Sakshya Adhiniyam to give the jurisdiction beyond India. Second, section 48 in the Bharatiya Nyaya Sanhita added where it says that abetment to commit an offence made outside India for an offence to be committed inside India. Section 48, especially for cyber crimes. Added with this section 208. Okay, that is there. Where the offence is registered in India is also added. Next, previously accused was not custody. Now, initially when you arrest the person, take to the magistrate and produce him. For re-remand, for further police custody, you need not take the accused before the magistrate. Just show that he is there in the lockup and seek fresh custody. Extension of the police custody. Okay. Next, 193, you can file it in electronic means. All the charge sheet, final report, everything, you can submit it electronically, e-filing to the courts. To make law more victim-centric, 90 days. That is the cases, heinous offense, about 10 years. 90 days you have to inform about the progress of the investigation. Progress means substantial progress made, like arrest of the accused, submission of the charge sheet, like this. Next, process supply of copies. Earlier there was no timeline. Now within 14 days the magistrate caused to give the copies to the accused. Usually the police will take a copy and give it. Now what we can do? Make a pen drive, give a copy to the accused, or send it by email, the charge sheet. Okay. Final reports, okay, 90 days, already I told. Further investigation has to be completed within 90 days. With the permission of the court, trying the case completed within 90 days. Obviously, POXO case and rape cases, timeline is 60 days only. That remains the same. Okay. Any suicide happen in the district, within 24 hours, inform the DM or the SDM. Because they are the persons who can order for the inquest. Okay? And with presence of two local inhabitants. Then these are the things, they need not to come to the police station, already I told. Committed outside India, section 208, I already told. That means any exhibit that is there outside India. Some proceeds of the crime, some building that is there in London. Now you need not to go physically to investigate. Ask the police officers there to send a photograph or a video of that evidence. That itself is sufficient to go ahead with the trial here in India. That's what it says. Electronically you can get the evidence. Then delay cost 120 days. See, prosecution sanction, very, very important. Now, unless and until the prosecution sanction is not given within 120 days, it deemed to have been given. So the blanket, protective blanket above our head is now over. Okay. It deemed to have been given. Next, cognizance by magistrates. Very important for the judicial officers. See, cognizance taken by the magistrates in 4 occasions. You know that on a police report, otherwise than on a police officer complaint made, that is by the accused regarding torture or what. Third, by a private person, or a cognizable offense has been made in front of him. These are the 4 situations where the cognizance has been taken by the magistrate. One of the important thing is that complaint made by the private person to the magistrate. That is section 200 of the CRPC. Now I will explain very clearly. Earlier CRPC says, when a complaint has been made to the magistrate, magistrate shall cause to summon the complainant, examine him on oath, and finish. There he can decide whether to send it to the police officer for investigation or close the case. Because even Supreme Court judgment says, the moment the magistrate examines any person under oath, it means taking cognizance, isn't it? But now it has gone ahead now. What it says, a complaint has been made to the magistrate. Now not only he called the complainant, he called the accused, the prospective accused, the notice. Now the accused can come alone or with the advocate. He can come up with the oral evidence or documentary evidence. Now the magistrate has to compulsorily examine the accused also. So now most of the magistrates are telling, already we are burdened with a lot of work, LPC, long pending cases. Now this will increase the burden of the magistrates. Calling the accused, 15 days notice, isn't it? So obviously the idea is that instead of delaying the matter, let the matter be end there at the maximum at the end of the magistrate. But what is the problem? It will increase the burden of the magistrates. Okay. CJ may also, now confusion. Section 200, these were there, but now that was there. Then, in order to strengthen opportunity to the accused, yes, complaint cases, protection for false and frivolous cases against public servant. Already we saw that one, 223. Special summons, petty offences. Now the monetary limit has been raised from 1,000 to 5,000. Petty offences. Then fine also raised from 1,000 to 5,000. Next, of course, MA Act doesn't, this one, apart from MA Act. Because in MA Act, even if you don't give sight to the ambulance, how much fine? 10,000 is there. So MA Act does not come into the picture. Next, issuance of process, electronic means, supply of copies to the police report, 14 days. I will again quickly go through. Police report, magistrate shall without delay was there, but now it is 14 days. Commitment of the cases, now another time period. Now the committal proceedings has to be finished within 90 days. Extendable to 180 days with reasons recorded by the magistrate. Now magistrates also has to write the reasons recorded for delay. So time allowed for committal of the case is 90 days. In one way good, one way bad. Because committal of the proceedings may not take 5 days or something unless the accused is needed in many of the cases. Now what the magistrates will do, oh there is 90 days time period, let us take on 85th day. Let us finish off these cases. That also is a possibility. Next, another thing. 60 days from the date of committal for a discharge application. Very good thing. For example, in a case, there are 4 accused. A, B, C, D. What they were doing earlier, A will come, you will put up a discharge petition in the trial court. Dismissed, he will go to the session court or he will approach the high court under 482. There, then after A finishes, who starts? B. Then after B, C. After C, D. Like this, these accused will gang up together to delay the trial for many years. Am I correct or not? Isn't it? But now, that is not the case. In committal of after the committal of the case, how many days is there? 60 days you have to submit the discharge petition application. If you have to submit. Okay? Next, offences of same kind. Earlier 3 offences of same kind can be this one, but now it is 5 offences. Okay. Judge shall frame charges within 60 days. Framing of the charges. Now the entire proceedings of the framing of the charges has to be completed within 60 days. From the first day of starting the charges. Okay. You need not to ask the accused to be present in the court. That is another thing. Because want of accused only is the delaying cause. Now ask him to produce via audio video means and read over the charges and frame the charges. Even he is absconding, proclaimed offender, designate a lawyer for him, go ahead with this one. That comes trial in absentia. Next, Use of audio video means expert witnesses and public servants. Now you and me need not to go to the court to give our evidence, nor a FSL expert. Now via audio video means public servant, expert or any officer can give their evidence via audio video means. Okay. Next, even for giving judgment. Now the session judge has to deliver the judgment within 30 days after the last date of hearing, extendable up to 45 days with reasons recorded in writing. See, 30 days deliver the judgment. For other cases, not later than 45 days. You have to deliver the judgment from the last day of this one. Third, the judgment copy has to be uploaded in the website within 7 days. Many timelines are there in the BNSS. Okay. Next, trial of warrant cases. Discharge petition again 60 days. We deal with evidence, prosecution, the examination of witness along through audio video means. Yes, warrant cases again 60 days. I will not go again cross-examination, but it is not practical. What does it say is, for example, the examination is done by the prosecuting officer, PP. But the defense is not ready, or the defense lawyer is not attending the court. After giving sufficient opportunity for the defense lawyer, the judge or the magistrate can dispense with the cross-examination by the defense lawyer and go ahead with the examination in chief, if it finds that the defense lawyer is making unnecessary delay. But it is quite impractical, because these lawyers, they will approach the higher forum and say that, sir, we are not given sufficient opportunity to cross-examine. That's why the magistrates and the judges are of the view, sir, let him take one more chance, 1 or 2 more chance, rather than he approaching all the higher forums, and again my case will go for another 2 months. Isn't it? This is the practical difficulty that we face in the courts. But anyway, for the speedy justice, this is the best method. Then 30 days non-cog offences compoundable if the complaint remains absent. For example, a complaint came to the magistrate, which is non-cognizable and compoundable. But the complaint, after submitting the complaint, is absent for 30 days. Now what to do? Why to harass the accused? Close the case altogether. That prevents some of the frivolous cases, settle the score cases kind of a thing. Isn't it? Next, summons trial. Magistrate consider accusation as groundless, he can discharge. So again, death of a complaint. Magistrate can give 30 days and close the case. Plea bargaining. Very important. Plea bargaining is only for the cases which are less than 7 years, not punishable with death or life imprisonment. What magistrate take cognizance, examine complaint, accused file plea bargaining, application in brief. These are the things, notice to PP and all those things. Here, there are 2 timelines. 30 days. 30 days time is given for putting a plea bargaining, this one after the charges have been framed, where cases less than 7 years. Okay. And 60 days time is given by the magistrate to go for a mutually satisfactory disposition, where PP, police officer, accused, complainant will sit together, decide what compensation has to be given to the victim, what is the minimum punishment to be given, and close the case. Of course, it is not a success story in India, isn't it? Is plea bargaining a success story in India? No, because they always have in mind that no, you will get acquittal. Okay, anyway, this is the case. Notice to the PP. Then disposal of mutually satisfactory, this one. Of course, admonition and probation, Probation of Offenders Act and all those things come into the picture. And what is the new thing? If it is a first time offense, minimum punishment has been prescribed. Then in plea bargaining, he will be given in BNS, then half of such minimum punishment will only be given. Okay. First time offender, then 1/4 of the punishment. Offense, accused, plea bargaining, half of the punishment. First time offender, only 1/4 of the. If there is no minimum punishment prescribed, then 1/6 of the punishment. 1/6 of the punishment. If this one, 1/4 of the maximum, or 1/6 if there is. So this is a new provision under the plea bargaining. This says for the first time offenders, lenient approach is there. Isn't it? Next, I will not go these details. Summary trials. Right in summer, all the three summary trials again 3 years. Then within 3 days, plea bargaining by accused, 30 days from the framing of charges and 60 days for mutually satisfactory disposition. 293, plea bargaining, I already explained. 1/3, 1/2, 1/4 of the punishment and all those things. I will not go this one again. Evidence inquiries, advocate through electronic means. Yes, dispense with this one. Now you have taken the statement of the accused via video conferencing. Law says within 72 hours take the signature of the accused who has been examined via video conference. Simple. 30 days has been introduced. Challenge genuineness of the document. Any document come to the court. If either of the party does not dispute for 30 days, it deemed to have been admitted. Simple thing. Again, new provision. Any document public servant. Another thing. If the officer in question could not attend to the court, despite efforts, then his successor in the office can attend on his behalf. Under what circumstances? See. Transferred, retired, died, cannot be found, incapable, he is not bedridden. For example, in Manipur and Nagaland, this happens. Assam Rifles come, put up a case under section 384 extortion. When it comes for trial, whole battalion or whole company has moved out, it is very difficult to trace them. Do they come and deposit the witness statement? Very hard to keep. Now what we can do, at least he can be examined via audio video, or his company is still there, his successor can be called into the court. This is very fruitful, especially for our northeastern states. This successor in office and audio video means. Next, curtail delays. Framework may grant more than 2 adjournments. See, now only 2 adjournments can be given to the either of the party. Again, quite difficult to implement. Beyond circumstances, when there is no opposition from the other party, only adjournment can be given. Otherwise, only 2 adjournments can be given nowadays. Or impose cost on whichever the party is not ready to examine or not ready to come over, isn't it? That is the best thing. Power to postpone without examining them, no adjournment. I already, when the witness is present, but a party advocate not ready examine, the court may record the statement of the witness as things fit. If another party does not come, then dispense with the cross-examination. Magistrate of first class direct any individual specimen. Without causing arrest, you can get the specimen sample, be it voice sample, fingerprint, whatever it may be. Need not to cause the arrest. Earlier we need to cause the arrest, but now no need to cause the arrest. But provided he has arrested somewhere earlier. Fugitive criminals, trial in absentia. I will give in brief. Now 356 is a new provision. Trial in absentia. For example, a proclaimed offender has been absented. Now what to do? Within 90 days time, the trial cannot be started. Why 90 days? Within that, 2 notices has been issued to the proclaimed offender. Publish in the newspaper, local and all that. Inform the friend and relative about the trial has been started. Then, from framing of the charges till the judgment, the person can be heard in absence. Now what to do? Only the magistrate has to appoint a lawyer for him from the DALSA, District Legal Services Authority, and this one. For example, that person is sitting in London. This lawyer takes care. And in his absence, even sentence can also be heard. Not only framing of charges, everything. That is a new provision under section 356, trial in absentia. Okay, sentence has been given. To appeal in the higher forum, he has to come in person. Okay? That not mean that sitting in London he can manage everything. No. That is there in this trial in absentia. So 90 days I have put up in a very smart, only one few sentence. This is the thing. From, new provision, this is the thing, later you go, this one, 30 days, affix in-house, display, all I will not go in detail. DALSA, trial, mobile, and withdrawal of prosecution. See, politically motivated cases. Any party come, they will take out all the cases that has been registered by the earlier this one. But without hearing the victim, now withdrawal of the prosecution cannot be done. Next. Victim-centric withdrawal of the prosecution. 366, in-camera trial, even for POXO cases. Earlier it was only for rape cases. Another important. Now, giving false evidence, it has been increased to rupees 1,000 and with 3 months imprisonment. Earlier it was only 500 rupees fine for giving false or fabricating evidence. Now it is more stricter. Lawful authority, take cognizance before rising of the court. I will not go into the details. Co-accused custody may be produced through audio-video means. Again, translation of a copy. It can be given to either of the parties. Now, earlier it was only for the accused. Court death sentence, forthwith. The idea of forthwith means as soon as possible. Has to send to the High Court. Okay? For confirmation. Witness protection scheme. You might have seen some of the cases, like one same famous film actor case who run in the midnight. There is one Asaram Bapu case where the witnesses were mysteriously missing, isn't it? Mahendra Chawla versus Union of India case. Supreme Court stated that they also come up with a draft witness protection scheme. Witnesses are either tortured, harassed by this one. Law Commission also says, Malimat Committee and all those things. But now, for the first time in BNSS, witness protection scheme has come. Okay? Malimat Committee and Mahendra Chawla Committee and various law commission reports. Now, these are the things, and what are the things? I will tell it in brief. The witness protection scheme has to be notified by the state government. There should be a witness protection fund allotted by the state government budget. The SP or the Commissioner of Police has to categorize the vulnerable witnesses into 3 categories. A, B, C. A, where there is a life threat. B, property or his relatives or something else. C, harassment, induce, coercion and all. Like this, the threat analysis report has to be prepared by the SP or the CP. Now, what are the measures? Measures include proper escorting to the court, giving patrolling around the house of the witness, changing the identity of the witness or the victim, like in the Nirbhaya case, like in the Abhaya case, whatever it has come nowadays, and also giving the alternate accommodation if the witness. So these are all there. They are giving new identity, close protection, providing police escort, all the day I told. Okay, these things are there. Then petty offences, 6 months, 1,000, now 3 months to 1,000. Now frivolous petition, applicant to say such sum, I will not go, 472. Mercy petition, there is a time law. When the mercy petition comes there, or accused, life sentence, death sentence has been confirmed by the Supreme Court on an SLP. Now accused has 2 options. Approach the governor or the president within 30 days after the SLP was dismissed by the Supreme Court. Okay, he approached the governor. 30 days time. Governor said no. After that, the accused can approach the president, but within 60 days. Central government has to give its recommendation, advice for the president within 60 days. See the beauty of this law. The central government has put itself a timeline for a speedy justice. Fourth one, there will be no further petitions or appeal once the final verdict has been given by the president. Because you see in the Ajmal Kasab cases and all those things. In the midnight, they open the Supreme Court and all those things. I will not go into the details. So now, another thing. The jail superintendent, it is his duty to tell to the accused, okay, death sentence confirmed, but you have a constitutional right of approaching for mercy petition before the governor or the president. Okay, there are A, B, C, D. Out of that, only 2 applied. But it is the duty of the jail superintendent to send the records of the other 2 also. Names and address. Why? Because either the governor or the president can understand the whole case and see whose part is how much in the crime. So that accordingly they can decide upon the mercy petition. Hope it is understood. It isn't? The duties of the jail superintendent and the timelines even in the mercy petition. So I have tell it in all the things, constitutional provisions and all those things. When the president office informs about whatever may be the case, it has to be informed within 48 hours. Again, another timeline. I will come to the end of the presentation almost. No other petitions are received. This one, he required to forward the names, records and all those things. There's again, applicant pays such sum. Sorry. Another thing. Without the consent of the accused, commutation of the sentence is possible. Life to life, death sentence to life sentence to 7 years, 7 years, and 7 years to 3 years, 3 years to fine, or rigorous to simple. Without the consent of the accused also. It can be done if the state government feels so. Next, bail under trials for first time offenders, released on bail. 1/3, this one, if involved in more offences not released. First time offenders, bail provisions have also been changed. Make application, of course, as soon as they complete 1/2 of the or 1/3 of the punishment, they are eligible for bail now. However, it is only for other than the punishments which is life sentence or the death sentence. But only exception is that if a child is involved, even the offense is of life sentence and death, the child could have the bail. Earlier it was 16 years, but as per BNS, now the child is 18 years, male or female. That is in the next slide. 7 years are convicted, 3 to 7 years, child, now child replaced by 18 years. Okay, 497, quick disposal of case properties even during investigation. Again, accused need not to be formally charged. What is the procedure? 14 days. It is good for the magistrates. 14 days, you take the photograph or the videograph of the exhibit or the property, proceeds of the crime. Property has been photographed. Then within 30 days, the court shall within 30 days after the statement prepared, order for disposal, destruction, confiscation or delivery of such property. This is another timeline for the disposal, destruction of the property. Of course, sometimes the natural decay and perishable goods are there, isn't it? 497. 530, last but one section, it says all evidences, all procedures, search warrant, searches, audio video means can be conducted through electronic means. This is one of the founding pillar to conduct everything, audio, video, electronic, we are telling, no, section 530 says. And section 531 is the last section in the BNSS, that is the, which says about the repeal and the savings. I will tell one thing. Whatever the cases registered before June 30, IPC plus CRPC. Offense happened before June 30 or 11:59, but offense came to the police station after July 1st. Then IPC plus BNSS. Second. Third. Offense happened at 11:30 midnight of June 30. Girl kidnapped. July 1st morning 1 o'clock she has been raped or murdered. Now it is called as a continuing offense. So the new section is BNS. BNS plus BNSS. Any doubt? Because this is the one creating lot of people. People used to call me also, sir, what to do. So now it is clear. Offense happened but come to the police station after July 1st. IPC plus BNSS. Continuing offense, if it extends to the July 1st, then BNS plus BNSS. Okay? And another thing, sir, somebody has cheated me in 2020, he has to give him money, and now also he has not given. It is not called as a continuing offense. Continuing offense means 120B or something like that, where it occurs this one. There is we can correlate between this one. One offense happened 1 year back, now again, no. Now we cannot say that one. For example, 2023, somebody owed the money for me. Now I called him, he slapped me. No, that is not a continuing offense. So now the fresh offense has to be taken into consideration. So these are some of the doubts regarding the repeal under the savings, when to use which section or the which law and all those things. Isn't it? So already I exceeded the time by a very, very large amount. Sorry for the exceeding the time. So I don't know whether to receive some of the questions. We have some time, or I don't know. It is a moderator our judge will decide now.
Thank you very much, sir, for your wonderful presentation.
Thank you so much for patient listening.
So now, due to paucity of time, only 2 questions may be put to the resource person. Only 2 questions.
Yes, I have one question. Okay, sir, regarding cyber crime, suppose hypothecated in hypothecation that.
Yeah, please bit louder and.
Hello.
Just raise your hand so that we can. Okay, yeah, please.
I may be Indian national or foreign national, but I live in a foreign country which India has no reciprocal arrangement.
Yeah.
In that case, I committed a crime through cyber.
Yeah.
In India.
Yeah.
I live in the foreign country which we have no reciprocal arrangement with India.
Yeah.
Then what is the mechanism of punishing him? Even if we completed the trial and sentencing him in his absentia, then what will be the procedure where there is no reciprocal arrangement?
Now you have to go to the BSA, which says that the territorial jurisdiction is not at all an issue. Isn't it? But still we can prosecute him if we can get the evidence. And now we may ask the question, since we don't have the MLAT with other country, what happens to the evidence? That's why section says that you can get the photograph or the video from the foreign country also. You need not to necessarily go to that country if there is no MLAT, mutual legal assistance treaty, but you can ask the police officer, even if the fugitive offender is there, just to send the electronic means the photos and the videographs.
Not that point, sir. What I mean is this, that the accused is still in the foreign country.
Okay.
Whether shall we use Interpol or not, or what is the procedure? If we send something, depute one officer from India, there will not allowed, as there is no reciprocal arrangement between the country, these two countries.
Yeah.
At that time, how to execute the sentence to that very accused who is living in the foreign
Yeah.
country? We have.
Yeah, it is, now if don't have the MLAT, mutual legal, then it is very difficult to get the extradite of that person. That is the problem. But nothing bars us to prosecute him. Nothing bars us to prosecute him and frame the charges, because section 356 is there, trial in absentia. Yeah. Another question, please.
Another question.
Sir, kindly explain how
This
to
may be the
seize-
last question, sir.
Kindly explain how to seize electronic currency, that is Bitcoin and all, from the possession of accused wallet.
Wallet. Of course, cryptocurrency, I added something on this one. See, now the cryptocurrency, just hold on. See, now the wallet is of two types. One is the hardware wallet and another one is the software wallet. Now, what happened earlier is that KYC norms were usually not followed by a currency called Monero. But now they have to follow the KYC norms by all the agencies. Now, what has happened? I will take only 2 minutes. Before some 2 years back, cryptocurrency was considered illegal in India. But one of the Bombay Association has approached the Supreme Court and they got a favorable order stating that investing in crypto is not illegal. There the Finance Minister of India has come up with 2 provisions in the budget. What are those? One is that whatever the money you invest in cryptocurrency, 1% TDS, tax deduction at source. Number 2, 30% on the profits earned on cryptocurrency with no set off and set on. What does it mean? 30% on profits earned. For example, today I put 100 rupee currency on crypto. Tomorrow I earned another 100 rupees. So on 100 rupees I earned, I had to pay straight away 30 rupees as tax amount. With no set off and set off means in GST, goods and services tax, for example, I have earned some 10,000 rupee profit last year. That 10,000 rupee profit can be adjusted for next 3 years for the losses to be incurred. That is called as set off and set on. Similarly, if I have incurred losses, that can be shown against the profit. But here, that is not there. Today I earned 100 rupees in crypto, pay 30. Tomorrow I lost some money, I cannot adjust. Chala gaya to chala gaya, aane wala, that day, that one. That is the thing. Now crypto, now what happens is that you have to use a specific, all the addresses and all those things. For example, Binance and all those things, and you have to take the crypto wallet addresses and the transaction addresses there. Addresses are usually 95-digit alphanumeric, that you know, in the crypto, this one. There is a specific software and also in IFSO, Intelligence Fusion and Strategic Office, that is there under the Delhi Police. There is a specific, this one there, that will give the, all the cryptocurrency transactions of a particular person. What does it mean? For example, 1 Bitcoin I purchased. I sold it to this for 100%. Cutting. Then each currency, where all it goes, then the back addresses, everything can be given by the crypto valence address that says that this one. Second thing, as I told in the morning, yesterday, now everybody has to put up definitely the KYC addresses for a cryptocurrency investment. What changed means, earlier cybercrime fraudsters, they used the mule accounts or the rented accounts. Means, I have some very old person sitting in somewhere in Manipur. Take their bank passbook, ATM card, everything. Do a cybercrime, put the amount there, take there. I will give just 1,000 or 2,000 for that person, account holder. I am using those accounts. That is called as mule or rented accounts. But to prevent this one, proper KYC came. That means to say that myself cannot invest cryptocurrency for an account belonging to any other person now. Now I can invest only in my account using the virtual account or whatever the Binance or the hardware and all those things. Number 1. Now what is the latest modus operandi by the fraudsters? They know that they can only open their account against their own ID. What they do, they will come to Manipur, Imphal. They will get a rent agreement or rent place somewhere. They will make a rent agreement with one of the landowner. Based on the rent agreement, they change the Aadhaar address. Based on the Aadhaar address, they open a PAN account. Based on PAN account, they open a bank account. Now everything ready. They do a cyber fraud in Manipur or wherever and put the money, take the money. On one fine day, within 15-20 days, they just vacate the house and go. Now what is this one? I have the Aadhaar card. I approach UADI. But the problem with UADI is that they don't give the past addresses. So they only give which address this person used for opening account in the Aadhaar. They don't give the earlier address which may be of anywhere. They don't give this. This is the major lacuna that is there, especially even in cryptocurrencies, to find out where the accused fraudster has gone. Yes.
Thank you once again, sir. So this is the last question. So I hand over my to Hilton.
Sir, I have one question, sir. Sir, could you please elaborate the exact time, time for before sunset or after sunrise, regarding in connection with the arrest of the accused woman?
Okay, arrest of the accused woman.
Yes.
Yeah, see, morning also madam was telling. Can you tell me what is the exact time to be arrest the accused woman?
No, but we still do not know. How can we determine the exact? How can we determine the sunset time or after sunrise?
Yes,
or
yes,
sunset?
yes. Sunset and sunrise.
So it is difficult. So could you please elaborate?
I think there is a particular department which says, and even in the Google also they refer to the particular time, what is the exact sunset time and the exact sunrise time for the every day and all those things. That should be followed. And morning, madam was telling, and it is also in the law, only in that day only you have to arrest the woman, number one. There is a only arrested by the woman police officer, number two, and there should be a presence of a woman person also, this one. But in rarest of the rare case, if you don't find a person, if you don't have a woman police officer, although the arrest means actual touching of the accused, if it is such of an importance that is of national interest, or she may commit of a offense of that grievous offense, still with reasonable following the reasonable this one, arrest can be made by a male police officer if such of a this one. But only thing is that we need to be explained to the court why it was such an imminent this one, why it is imminent danger, and even without the availability of the women constable or then why an arrest has been made. We need to be ready to explain that one. That's why the word save in exceptional circumstances, it is there in that section.
Thank you, sir, for the insightful, enlightening session. It was a delight to listen to, sir. I'm sure you will all agree with me that it was like an action-packed movie. From the beginning to the end, it was exciting. I once again thank Shri Raja Shekhara and IPS Director CDTI Hyderabad for the wonderful session. And I also thank the moderator Shri C.H. Momon, Professor LMS College, and panel advocate Masalsa for moderating the session. Now we will have, I would like to request, we will have 5 minutes of feedback session. I would like to request 2 volunteers from the participants to kindly share feedbacks, your suggestions, your experience of the 2 days orientation program. You may please come to the stage and share your feedbacks. Any 2 volunteers. Or you can also share from where you are seated. I think there are some, but they are still undecided. Please feel free to share your feedback, suggestions.
Good evening, myself S.K. Tyagi from NIA. Basically, I have attended both the days sessions.
Can someone please pass on a microphone to sir?
Hello. Are you getting? Actually, myself, S.K. Tyagi from NIA. Basically, I have attended both the days session. In the morning session yesterday, there was a session in local language. That was a problem for me. Otherwise, it was nicely managed, and each and every lecturer was very good in explaining each and everything. Particularly Miss Neera yesterday, today morning Shruti ma'am, and no doubt Mr. Rajsekharan has given a wide view. He has given a spectrum of knowledge within such a short period of time. I really appreciate this type of classes keep on going on in future also, so that all the persons who are dealing, whether it is judiciary, whether it is police persons, whether it is advocates, may be enlightened and improve their knowledge and may present their cases accordingly into the court. I really thankful to Mr. Rajsekharan that he has given such a wide view about this particular session. Thank you. Thanks a lot.
Thank you, sir, for your valuable feedbacks, and your suggestions are also noted. One more volunteer, please. Yeah, there is one here, in the middle row. Microphone, please. In the middle row. Second in the middle row. Second row. Somda.
Ngarangdagi chatharakpa sumba orientation program si aduki matik akoigi lakpiriba ngasigi ngasibawda delegation si aduki matik yami adu yamagasu ngarangidi yam full loy ngasigi na amu khara yawdabudong tawba aduna ngarangi session do aduki matik akoigi maman yami akoigi feedback haibabu isema RKMM sana haibiramba magi BNSS bo koin CRPC yamazena takhairami yamazena tambirami madugi damta akoi nungai tawdabu adudagi akoina khangaubuda ngasigi amu akoigi sar kenosiga amu yengnarubu kanda nupi maga nupa maga akoigi resource person lakpase siga mu akoina phangmaganda aikoigi lairiba jiki home department DGP dagi hauraga home department law department gi yamna maruoiba pot khara anova law si chanarko matamda manungda state na hapkadawa pot khara lai haibase machai thamjagi ahamada ajigi hariba metren haibadi videography adagi laptops mobile haibo mayam adi digital mayam singse masi provide tawgadra tawroidra haibana singse masi ama yam thuna 6 months ki manungda masi thambiba haibadi home department law department sidai laihan ningba haitare o thaman ningaba phajana investigation hobu yanaba hajipudi tekta tauri asaimokda hangbada zero ni knowledge akoina tabada aigi ming aham haijaudre aigi ming Koijam Brojen. My name is Koijam Brojen. I am the Special Public Prosecutor, Government of Manipur. Now I am posted at Manipur Human Rights Commission, and I am the Special PP in the MPs and MLA also. Aduna ain haining bana khangjaning bana khanganing bana haibal law se adugi matik lure e handakti evidence ki matang sida ngasibauda Manipur da fail wariba kaino mayam se criminal ki trial da ako imprisonment conviction piba ngamjiba se investigation sonbadagi ni na highlight ibne adu anoba lakwa law sida amina sonanabagi macha amana aji haribo equipment ma'am, kits ma'am singse. Bibi mama, thambi mama changi haibase. I ngasigi mifam se approve to hanning. Ma'am janinga kuwa kubiyo yaninga katoki. Number 1. Number 2. Ngasi police ki di ampazare awareness to se orientation se. Masang di lawyers lising ani en lai ribani. Amuk shoot to hanning. Ta taruk lerga mukhoy yauraga. Masim tanga masang da orientation se extend to view Manipur State Legal Service na and Haijeri. Thank you.
Thank you, sir, for your...
Nongtang supplement of the way yagadra.
Yes, please.
Yes. Now we have new law enforced and enacted, but we are given orientation course in such manner. We, the police officers, lawyers, and judges, we are in the advantage group, but law is enforcing after passing the acts in the parliament. What about the peoples in the remote areas? Mere publication in the Gazette, shall we presume they know all these laws? Whether we enforce these laws, ex parte decrees to the people. Shall we presume they know the laws in the remote areas of these countries? So I want justice to the doorsteps of the people, if possible, to enforce such new laws. If required, law commission may recommend such things. Otherwise, to implement this law, there should be many abuse of the laws in the country. I want to give this much feedback, because people need to know the laws. If the people are not knowing the laws, there is no peace and development in this country. So, awareness of the people of the enforcing laws is very much necessary. Thank you.
Thank you, sir, for your valuable inputs and suggestions.
Can we have one last from the police side? Excuse
1
me.
minute, please. 1 minute.
Yeah, here, this side, this side.
The deliberations were all good. Actually, the 2 days has been very, it's been an eye-opener exercise for, I think, for most of the IOs and many officers attending this 2 days training program. And at the same time, we've had like several short, small discussions that are on district levels and units. But I think this is more systematic and organized and well-packaged 2 days program. I'm sure, I think many of the IOs will really benefit, and as a supervisory officers, I think we'll also benefit from these 2 days. And I think the tea, snacks, and refreshment and other logistics were all very well. Hopefully, the books were also provided, but I think it's being taken away. So I think, but at the same time, I wish we have like maybe in next sessions, maybe like if there is a follow-up, as mentioned earlier, like maybe 5-6 months later, if there is some sort of follow-up, and if we have, like say before the training sessions, if we have some pre-tests and post-tests, you know, where so that we know where the IOs and other officers and other learned people are also coming, what kind of knowledge they come, and maybe that's how you, then maybe you could have tailored the training package for better, you know, in the next training sessions. But at the same time, as you said, as many learned also have informed that, I mean, obviously, yes, investigation is one reason, very shoddy investigation that happens is one reason for lots of cases, failure as well as pending. But at the same time, I think at this moment, even prosecution, I think, is having lack of infrastructure, manpower, and I think that's where the coordination between the police investigation and even the prosecution units have to work in close coordination. All these three units have to work closely so that with the coming of these new laws and new challenges, I mean, it's going to be very going to be very, I mean, we need to pick up things very fast so that, you know, it doesn't become a double jeopardy again to add on to the already existing limitations that we already have in the field. So I hopefully Masalsa can actually maybe resolve, or maybe be the proponents for kind of advocating for as the new equipments or other things which prosecution needs, which the police will be need. I think that can be advocated from Masalsa side also. That's all I want to say. Otherwise, it's been very wonderful experience, and I hope we all had good learning experience. Thank you so much.
Thank you, sir, for your valuable feedback. I'm sure Masalsa and the law department and other concerned authority have taken note of the suggestions and feedbacks and will implement it. And we certainly will look forward to another such orientation program in the days to come. Before we conclude, I would like to request Srimati Rajshri Yambem, Deputy Member Secretary, Manipur State Legal Services Authority, to propose a vote of thanks.
A very good evening to everyone. We have come to the close of a very intensive and exhaustive 2 days orientation program on the new criminal laws. As we conclude, I would like to extend our heartfelt gratitude to everyone who contributed to its success. At the outset, I would like to thank our Honorable Chief Justice, High Court of Manipur, Honorable Mr. Justice Siddharth Mridul, Patron in Chief of Masalsa, and Honorable Mr. Justice A. Bimol Singh, Judge High Court of Manipur and Executive Chairman Masalsa, for their leadership and guidance throughout. I would also like to thank Madam Eno Shitombi, Commissioner Law, for the constant support while organizing the orientation program. I would like to extend a sincere thank you to our resource persons and moderators, especially Sir Rajasekara and Shruti ma'am, who have come in especially for the program. Your expertise and thorough analysis have provided us with a clearer understanding of the recent legal changes and their implications. Your time and effort are deeply appreciated. To our delegates, judicial officers, police officers, learned members of the bar, LEDCS, officers of prosecution department, customs, forest, forensic department, faculty law colleges, NIA narcotics, NELIT, media personnel, thank you for your active participation and engagement. Your thoughtful questions and discussions have enriched our program. I would also like to thank the staff of City Convention for the constant cooperation. I would also like to sincerely thank my colleagues J. Hilson Angam and Potsamam Praveen for conducting the 2 days program so seamlessly. A big thank you to the technical team and the staff of Masalsa and the High Court for the hard work put in to make the program a grand success. To conclude, let us carry forward the knowledge gained over the past 2 days and continue our efforts to ensure that the new criminal laws are understood and effectively implemented. Thank you all once again for your invaluable contribution. Thank you.
Thank you, Srimati Rajshri Yambem, Deputy Member Secretary, Masalsa, for the vote of thanks. We shall conclude the session here. As we moved out, tea will be served in the lobby, in the ground floor. So I would request all of you to please enjoy the tea before leaving. Thank you.